Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will
relevant.
bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
We're getting commentary on the case. Dati mihi Anglican po rin,
Is that correct?
I didn't ask you to interrupt me.
Literally not true.
Oh, for Trump's sake.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. I'm not going to argue about semantics today. Maybe we will. Good morning. Good morning. Welcome. Good to have you all here on this Tuesday morning. Happy Tuesday to you. As we are getting started to follow day 2 of the Tyler Robinson trial out of Utah. Steve Douglas says, wow, never been here for the intro. It's good. It's all downhill from here, Steve. Welcome. Welcome. It's good to have you here. Appreciate it. Thank you. Thank you. We also have to welcome one special person. Here we go. It is Ruth Ann. Ruth Ann, 85. Congratulations. Ruth Ann, you were first in chat this morning. And I actually think you were first in chat last night when I put the thumbnail up. Because of that, we're going to punish you. Yes, your promptness and punctuality has earned you a punishment. Everything IP related worldwide is your responsibility. We are sentencing you to internet ownership. So please keep it running for the rest of us, and we will try not to complain very much, at least towards you. But welcome, Ruth Ann. Thank you very much. Longtime supporter of the channel, an OG around here. So wonderful. By the way, I forgot to put Steve Douglas on the screen. There you go. Never been here for the intro. It's good. Thank you. Thank you. Welcome. Boy, do we have a day in store for us today. I will tell you in just a minute, what I hope that the judge does early this morning. And I've got my fingers crossed. I'm hoping there's no jury. He's the decider of fact in this preliminary hearing. But I'm hoping he didn't isolate himself from all media. I hope somebody talked to him and told him, Judge, if you could do just this one little thing, it will take you it will take you about 2 or 3 minutes to do it. But if you could do one little thing for us all, the next 4 days will be a breeze. So we'll talk about that in a minute. Welcome. Selena Kay, our court watcher from yesterday, is in the house. Says, hello, everyone. I was interviewed by a reporter from the New York Times. That's awesome. Selena, welcome. Good to have you here with us in chat today. We'll be watching together on the YouTube as we're waiting for the live feed from our KSL Pool media cameraman to be turned on. All right. If you haven't been here before, when we start the show, something we've done every day. This is a Rode mic. It is. This is a Rode mic. And this is a Rode mic. This is a Rode lavalier. It's cabled, but this is the wireless one. I'm a big fan of Rode. This is a Rode. Well, you can't see it because it's under me, but this is a Rode soundboard as well. All right, we have every morning when we get started, we have birthdays, and and we sing to them, and by we I mean all of us. And if you have not done this in a while, I mean honestly, just you're sitting here, you're watching YouTube, you might have it on your phone, on your TV, on your laptop, on your tablet. It might be in that second monitor in your office. Doesn't matter where it is. If you haven't sung happy birthday to someone very recently, and by that I mean this week, now is the time to join in. If you have, good, you're in practice. Join in anyway. We're going to sing happy birthday to Alicia Love for Horses. I'm here for it, Cindy and Heather from Texas. And by we, I mean all of us. So wherever you are, if it's legal and you're able, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. That'll do. Texas. Happy birthday to you. And not quite here yet. Josh waiting for a newborn nephew who will be born sometime today because, trust us, things are in the works. They're in the works. That process has already begun. Happy birthday, Josh, to your new nephew. Any minute now. To everyone who celebrated their birthday today, happy birthday. We realize there are a million places you could have been and a billion people you could have celebrated with, but you chose to be right here with us. The privilege, pleasure, the honor, the joy, that is ours. Hopefully we can turn that back to you and make your day just a little more special. Or begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, Bob Evans, and Cracker Barrel. There you go. Woo! Now, didn't that feel great? I imagine if you're in your office and everyone's staring at you, you're like, who are you singing to? That's a lot of names and none of them work here. Why are you doing this? Just send them a link to the channel. They'll understand after a day or two and they'll be singing with you. So happy birthday. It's a good way to just spread some goodwill and cheer out in the world. Especially as we like to focus on some of the darkest things society has to offer on this channel as we look at murder day in and day out. But wonderful. Appreciate it all. Heather from Texas, I hope you have a fabulous birthday. Thanks for letting us celebrate with you. That was awesome. Yes, bring them into the RA cult family. Excuse me. I almost said something else. The family. That's what we call it. I think we have a drum solo coming up here. If you play the air drums, join me. If you don't, here's the time to learn. It goes like this. Ready? One hand does the bass over here. Snares on the other hand. Beautiful. Big finish. Happy birthday, all. We are ready to go to court now. That's how we start the day. 54 this year. Not rushing it, says Steve Douglas. No, take your time. I'm right up there next to you. I mean, I'm a couple years behind you. We wouldn't have been in high school together. I would have been in junior high while you were in high school. I like to show off my air drum skills. It's one of my many talents. Yeah, I'm not good at it, and obviously I sound better playing the air drums than the real ones. We have another day of court ahead of us. Maybe we can get through more than 2 witnesses today. Maybe, with our fingers crossed, maybe we can. And if we do, if for some reason we do get through more than 2 witnesses, it will probably be for the following reason. Judge Graff, lend me your ear this morning. Please, good sir. You're an amazing judge. Governor Cox from Utah, C-O-X, like Fox, but with a C, appointed you to the bench as a judge last year. This is your first death penalty trial. Now, I have never been a judge in a death penalty trial. I will admit that right now. But I have some suggestions from judges that have been judges in a death penalty trial. And they're not necessarily suggestions, but more like examples that they set. And if you could do this one thing, everything you're doing is fine. Just make a slight adjustment. At the beginning of the day, before you let anyone have the benefit of the record, which I love, could you just explain to the courtroom in general and Ms. Nestor in specific what a standing objection is? Can you just explain how a standing objection is one that is made once and it stands for the whole hearing? If you could do that one thing and just explain how that works and how you don't have to get up and keep raising the objection. Objections are not like weak hands that fall after being raised for too long. They stand. A standing objection stays. It's like putting a pin in it and holding it right front and center for the entire hearing. It's there. If on appeal, guess who sees it? The appellate court judges will see it. A standing objection, if it's at the very beginning, applies to the very same issue at the very end of the trial, even if you don't raise it again. Just one time is all we need. One time. And that could save us, by my estimation, at least a day, at least a full court day, 8 hours of court time. We are only up to 52 objections, but that's only because the process has ground to a halt. And we called it a little bit. We called it, and just renewing it. I understand you can renew an objection if, like, you object to something early on in the trial and then lots of other things happen, and then it sort of comes up again and it appears that the judge might not have remembered. You can renew. Hey, judge, just letting you know, we do have that objection about this. We raised it earlier. And he's like, okay, noted. That's good. That's all you need to do. That's it. Then it's done. Okay, we've got somebody calling in. I don't know who it is. The burner phone number's out there. Let's see who's calling us here.
Call from Legally Blonde.
Legally Blonde. How are you doing, my friends? Happy good morning. Happy Tuesday to you.
What's up? Good morning, Pixel fam. So, two things. One, I have a bone to pick with you. And number two, well, I guess I have two bones to pick with you. First of all, let's talk about the fact that no matter what the judge says in the beginning, Nestor is going to renew her objection every single time. No. She doesn't care. The rules don't apply to her, and she gets really indignant when they do. Am I wrong?
I'm hoping you're wrong. I need you to be wrong on this for my sanity sake.
I need me to be wrong on this. I had to turn it off yesterday. After she threw a fit when they tried to identify Tyler Robinson, I went, what? And I had to turn it off. I was like,
Your Honor, long-standing case law, extensive amounts of case law point to the fact that you can't point at my client because that breaks his constitution. It hurts his feel-bads when you do this. When you're like,
yes,
hey, this
Thomas
one,
Jefferson
this one right
would
there,
be so disappointed.
Guess what? Just very recently, there's a lawyer I follow on Twitter. I'm not going to out her right now, but she posted and she said, guess what? I won a case today for a reason I never would have expected. The prosecution failed to identify the defendant with the witnesses. Three witnesses didn't point the finger, and the judge says it's over. The case law is the other way. It's the other way.
God. Oh. She just be saying stuff, man. She just be saying stuff. Okay, so here's my second bone. So yesterday, you told this terrifying story about a sea of crickets.
Yeah.
So last night when I went to bed,
guess what you
I dreamt about crickets.
Nice. Mission accomplished.
And then when I got up this morning to take a shower and get ready to seize the day and take care of all these little kids that run my house, I almost died because there were two crickets in my shower.
So maybe it wasn't a dream.
I know, that's what I was thinking. I'm like, maybe they were chirping in my shower last night, and I turned it into a dream of hydroplaning on crickets.
I'm sorry. It happens. I shared the story. It's true. Every bit of it is true.
I believe it, and it's terrifying.
Yeah.
It's terrifying. Crickets are a nuisance anyway. They're loud, and
I will tell you this.
Go ahead.
I think there's a scientific aspect to crickets chirping that you can actually calculate the temperature based on the speed they chirp. That might be folklore.
I think I've heard that.
But I've heard it enough that I think it's true, and I almost believe it. Because they do tend to chirp faster when it's hotter and slower when it's colder.
There are 883 people in chat right now, and I bet all of them have access to Google.
Man, if only we knew how to use it.
Oh, I know.
Legally Blonde, I'm sorry I made you dream about crickets.
Yes.
Thanks for the call.
It's
Love talking to you.
Yes,
we'll
thank
see you later.
You too. See you later. And we live another day to be frustrated with Nestor.
No. It'll be different. Today's a new day. We're turning over a new leaf. I feel it in my bones.
Don't get your hopes up, bro.
All right. See you, Legally Blonde.
Okay, bye. Bye.
Oh, man. We're hoping that we get a little different experience today. It is 10:41 on the East Coast, which means it is 8:41 in Utah. The live stream should be up between now and 9 o'clock. So we have about 19 minutes where somewhere in there the camera's going to turn on. We'll join and jump to it as soon as we can. Right now, all they're showing us is this beautiful shot of Chopper 5, which is, well, it's a still image. That's the placeholder for KSL, the pool feed, which they're running through YouTube, which is interesting. Sometimes it's run through YouTube, sometimes it's run through a different content delivery network. But just a little unlisted clean feed for those of us in the media. All right. So we talked about crickets. I missed an anniversary post. No. I haven't. I just haven't gone there yet. I haven't missed any. I've got them all right here. Selena K, thank you very much for the super chat. Our court watcher yesterday, one of 4 just random citizens able to get into the courtroom yesterday. So thank you very much, Selena. I appreciate you doing that. That's hard work. Getting up at 12:30 in the morning and driving to the courthouse and standing in line all night, and then being up and alert and following court and calling in and driving. Yeah. Staying home with Warren. Please express our love and concern for Warren. He needs to get feeling better so you can do what you love as well. But love that you're with Warren as well. Lisa, 31 months makes you an OG. Thank you very much, Lisa. Also, Debbie Cook. Welcome to the gallery, Debbie. Great to have you here with us. Love it. All right. Anything else we need to talk about? I don't miss anything. I just haven't gotten there yet. I think there was a couple things I was going to bring up. The objections. A lot of people have asked about the objections about Miss Nestor. Let me get this out in front. We've poked a little fun at Miss Nestor a little bit, but I have to tell you, and I mean this. I really like her. This might. Oh, this is Selena, I think. Hang on.
Call from
People have asked about the objections about Miss Nestor.
Selena. To accept, press 1.
Hey, Selena, we need you to turn the sound off in the background. Can you hear me?
Yeah, is that better?
Yeah, that's better. How are you doing?
I just want to tell you a cool human story that I learned this morning. So my friend that goes with me court watching, he said that he met 4 young women today that were all at the event where the shooting occurred, and they didn't know each other before, but they became friends, and now they are best friends, and they're there watching today.
And they
so
went,
I just wanted
they went
to share
to
that.
court to try to get in. Wow.
They got in too. They got
Oh, wow.
in, all 4 of them. So.
Oh wow, that's amazing.
Yes.
That's awesome. They might be the only 4 that did. So,
Exactly. Isn't that a cool story? How life can
that's
kind of
neat.
like just change our, events.
it's sometimes
can
a
change our
random
lives.
thing that puts you in somebody else's path, and suddenly you find out you were best friends and didn't know it. So, Selena, that's awesome.
So anyway, I just wanted to share that real quick because that's kind of a happy thing in all of this. So
Thank you so much. I appreciate that. We need that today.
All right.
Have a great day.
Yes, we do.
Selena.
Okay.
Bye.
Bye.
All right, one more thing. Miss Nestor, I was saying I actually like her. I like her tenacity. She will fight and continue fighting for her client, and I like that. I think that our system needs that. We need more of that on the defense. Sometimes we see a lawyer, defending, what doesn't matter what the crime is, defending anybody. We're like, yeah, this looks like a public defender, and it's sort of like a slant, a little sly comment against the lawyer because they appear to be doing a halfway job or just going through the motions. I don't think that's fair ever to any defendant, even the ones that are like blatantly guilty. Okay, we all were there. We all saw it happen. You did it. You declared it. You posted it on YouTube. You signed a sworn notarized declaration. You did it. We know you're guilty. You still have your day in court. I think that they still should have a lawyer that fights for them and forces the state to meet their burden. That's one thing that Miss Nestor does, that at least in pretrial. We'll see if she actually goes through trial on this one. I have my thoughts on that one. Anyway, with the objections, which is what we mostly see from Miss Nestor right now in this preliminary hearing, the objections stand. If there's a standing objection to anything on the topics that she has filed raised a standing objection on, if she forgets to object or is just talking to somebody else and the judge says, Ms. Nestor, and he doesn't respond, he's like, oh, hearing none, and he goes on. It doesn't mean that that's not preserved. The standing objection is preserved for the entire hearing. And then on the other hand, if she turned over a new leaf and said, Judge, we know where this is going. This is just an exercise in futility. We're going to stipulate to all the evidence, just for the preliminary hearing. We're going to stipulate to all the foundation of all the evidence. Every picture the state has is legitimate, at least for the preliminary hearing. She could do that. Does that make it all come in the trial? So now it's admitted in the trial. No, it's just for this hearing. She could She could stipulate to all the backgrounds, the expert designations, the legitimacy of the hearsay. We've got a feed now. Hang on just one second. There we go. Camera's up in court, and you should have audio as well. She could do that, and we've seen that happen a lot. I think there were some items she could have done that too, and I think that would have been a good token gesture, even if it was only limited to like the maps, the map of campus. Do we really need to fight over that? And there's one other thing I think the judge can do. I told him there was just one, but the second thing is if he could make a ruling, a blanket ruling that goes along with the current Utah state law, which is a presumption of openness to the media on these exhibits, and then only address the ones that shouldn't be shown to the media. I think that'd be good. But unfortunately, Ms. Nestor right now thinks nothing should be shown to the media. And then at the same time, she seems to be performing for that same media. It's not for the judge. It seems like a performance. Shannon S., member for 29 months, OG. Also 33 months. Lena H., welcome to the gallery, OG. Time sure does fly by. I love listening to work. It's either work peeps or RA, and RA wins every time. I'm sorry you don't have more interesting work people. Well, I'll try to make my content a little more interesting just for you. All right, let's see. Catsy Corner. Is that how we say it? Catsy Corner? Welcome to the gallery. Love the kitten, by the way. Lucky Lady, member for 1 month. Love the new color courthouse. It changes rapidly when you're a new member. And I think I got everyone. Lisa OG, we got you as well. I think we've got the members. We had a lot of membership anniversaries yesterday. Now we're getting comments on the case, right? Somebody had asked for a sound effect. I think it was this one.
Because we here in Canada hate you and hope for bad things for you because we hate you.
There we go. A little bit of Ian Runkle to kick the morning off. Ian's amazing. He doesn't actually hate us. He was talking about UPS there and their policy about billing him like 6 times for something he already paid for. That resonates with me just a little bit because I bought a clicker, I bought a counter. I've wanted one of these forever. It's a SMIRL. Smurl is how I've been pronouncing it. A Smurl counter that is real time, that will show us how many likes we have on the video, how many subscribers we have, and it's sitting in Paris, France right now. I imagine at the Eiffel Tower, waiting to be shipped across the ocean. And I found out that they get to pay like a huge, hefty import duty fee when it arrives. After I paid for it once. Virginia Little, best sound on YouTube and the best people. I love it. Virginia, we're hoping that the court feed gets a little bit better today. We have been able to fix it so far, which is wonderful. Just have to do a little boost and split it because they're only sending one channel of audio. So we add that second channel, so it's not just left ear. We get left and right ear. That's important for people whose phones only play one side. Sometimes if your phone only plays one side of the audio, which some phones do for some reason, you might think there's no sound. Everyone else can hear it, but you're only listening to the wrong side. But we'll fix that. We've got that taken care of. Rejected Juror. Hey, everyone, haven't been watching court in a bit. Decided to watch this one. So, of course, I came to the best place to watch court. 29 months, Rejected Juror. Thanks for being a member. That support, even when you're not here, that's huge. That's huge. I appreciate that. Objection, Your Honor. Member for 15 months, almost an OG. Love it here. Love it here. Thank you, Objection, Your Honor. Also, we have Genesee Gal. Welcome to the gallery. All these people getting out of slow mode. That's the real perk of being a member. Dr. Bullbutter, member for 32 months. Hey, I missed everyone. I've come home. Rest in peace, Charlie Kirk. 91025 Freedom. Never forget. Scott, please give Mrs. R.A. my best. I sure will. Dr. Bullbutter, good to see you here as well. Wonderful to have you. All right, I renewed my membership as a birthday present to myself. Thank you. Thank you. Happy birthday. Vaporware. Which one, Tumblr Troy? Are you talking about the phone? If you use one earbud, or if you use one earbud at a time, yes. For those of you that have to pay attention to your coworkers and you can only put one side of the headphones in, we got you. We got your back. So we'll do a couple things. Miss Nestor is, I think Josh from Courtroom Confidential, whose shirt I'm wearing today, by the way. Big shout out to Courtroom Confidential. Josh is amazing. Josh was saying last night on his show that that Miss Nestor has a rapper mic. It's just a handheld wireless, a Shure mic. I've got the same ones. As a matter of fact, I think I could grab one here, but that mic, the volume is just way too high, and Miss Nestor is talking into it like she's right here when she talks, and it just is deafening. So we're taking her down, bringing everyone else up, and splitting it right to left. And luckily that's all we have to do. We don't have to put any other filters or band pass, cutting out beeps and air conditioner noises and things like that. So easy work on me today. Mics have to have cables. They run a lot of wireless. How's Jules doing? Have you heard from her? Yeah, she replied to one of my tweets yesterday. So she's doing okay. Well, she's kicking. She's a fighter. So I don't know the details of how she's doing health-wise, but she's a fighter, and she's, it's always fun to hear from her. Let's see. This is the best audio. Poor Brian Ensign's show this morning. Clipped some stuff, and you can't even hear it. Oh, man, that's... I should just... Here's the thing. Top Mark Media, my parent channel that I own, it's not monetized. We're going to monetize it eventually. It's got all the viewers and the watch hours. The problem is when I just show court, YouTube considers that low effort content, and it doesn't qualify for monetization. So when I put a stream up, I can put a stream up where we're fixing all the audio, and then there will be a clean feed that someone could use to take clips from, where the audio is in both right and left channel, and Miss Nestor's not too loud, and it's the rest of the court is loud enough to hear. It just hurts the channel, is all. So I could fix it, but I don't know. Maybe if they need it, we could do it. But it's not incredibly difficult to do. I'm not like some wizard on the ones and twos, mixing it up here for you guys. But it does require a little bit of specialized hardware, which makes it a lot easier. Selena K, when I wasn't napping in court and was so bored, I was looking at the back of Don Jr.'s head. You were right behind him. And the security was looking at you, I'm sure. So right now we're only putting out this one feed, which has my commentary. I'm not running a clean feed on Top Mark. Good. Let me think. I don't know. I'll think about it. Let's see. Lego My Briefs member for 29 months. Just bought a new home in my childhood neighborhood, surrounded by friends and family. Still there. Best medicine for my too young to be a widow heart. Lego My Briefs. I'm sorry you are too young to be a widow, but what a wonderful feeling to be able to move home and have so much of what you remember be there, including the people that you know and love. That is wonderful. Excited for you. Girly Jones, you should be able to get money for your work. Girly Jones, the media likes to work together, and if this is something that the media could use, I would fix this in a heartbeat and give it to all the. We normally do it for all our friends and channels that we support. So it wouldn't be something I would sell, especially since it's. I'm a big fan of open courts, and it would be disingenuous for me to then make a little fix to make it a little better and then charge people for it. When it's something that literally KSL is expending all the money right now to give us the feed for free. So that we sort of take our turns where we can, but I'd feel bad doing that. But we just like that we have good audio and you can watch it here. That's all. All right. Tyler was very involved in the case of Selena, who was watching yesterday in the courtroom. doing lots of writing, doing lots of talking to his attorneys, and was quite interesting. I did hear he sort of was joking around with his attorneys, with the family right behind him early on when he first came to court as well, which some people didn't like. But I imagine as a defense attorney with a client who's extremely nervous on the first day of the actual court as it's beginning, this preliminary hearing, I imagine just trying to help them ease and relax a little bit is important. I don't fault them for, telling a joke or something like that. It's probably common. They have turned off the mics at the attorney table, so she has to use the mic. Just saying, yes. That is so we don't accidentally overhear. We're getting some motion. We don't accidentally overhear something that they say to Tyler or to each other. Or to the opposing counsel. Those are conversations we should not be hearing. The judge should not hear them. We should not hear them. And so the mics are off for that reason. But she is using a really fun mic. Let me grab mine. Hang on. I've got the wrong box. I reached for my video box. I need to get my audio box, which is in the other room. The mic she has a switch on and off. She just has to turn it on and off. It has a great pickup. It's dynamic. It's not a condenser mic for those that are curious, but it's a Shure SM58 mic head. If you're a little bit of a nerd like I am, and they have about a 600, 700 foot range wirelessly. All right. Yeah, Selena, there are a lot of victims when there's a crime, and not all of them are the people who directly got physically impacted by the crime. It's sad. There are victims on both sides. All right. Since she has that wireless mic, she should wrap all her objections. I've got an old, what is this? This is the Electro Voice 635A. This is an old reporter mic. Hey, Twin Tail, thanks. I saw you sent me the cat pictures. Thank you very much. The kittens, doing well. This mic would work really well in that setting, probably better than the SM58 because it's a little bit quieter. It's more even on the pickup, and it can be dropped probably off a very tall building and still work just fine if there are mic drop moments. Canadian Crime Watchers says, I wonder if Tyler's former partner will get called as a witness. He will, but not in person during this hearing. He will be called during the main trial. During this hearing, we're going to have evidence presented through hearsay, which will be police officers sharing information that they received from Lance. And so that's how it works in the preliminary hearing. We won't see him. The defense actually asked that he be flown in. They wanted an out-of-state subpoena, him brought in so he would testify directly instead of having this other text message and things come in. The text messages are bad. Okay, that's why the defense wants him. They'd rather have him on the stand where he could say it in a way that's not quite as bad as in the text message, and sort of try to make it better. But I didn't hear. Oh, the judge said he was drinking water, and if you have water, you should drink it as well. Just don't spill. That's what we heard. All right, we are 1 minute past the scheduled start time. Curly Q NPR member for 15 months. Silly work has kept me from live court watching for way too long. Glad to be back among the best. Curly Q, thank you very much. Hope you enjoy it here today. I saw Peter.
Calling case number 251-403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Chad Grumander, Ryan McBride, David Sturgill, Lauren Hunt for the state, Jeff Gray, the county attorney, as well as Chris Miller are also present.
Good morning.
Good morning, Judge.
Good morning, Your Honor. Good morning, Your Honor. Good morning, Your Honor.
All right.
Kathy Nestor, Michael Burt, Richard Novak, Stacy Visser here for Mr. Robinson, who's seated to my right.
Good morning, counsel. Good morning, Mr. Robinson. And for the record, the court also recognizes the presence of victim representative, Ms. Erica Kirk. Good morning. First, with respect to courtroom protocol, to maintain security and decorum, any individual who exits the courtroom during proceedings will not be permitted to re-enter until recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices.
Audio cut out.
Is it the audio working?
That was their fault.
All right. Well, let's just take a brief moment.
This brief moment sponsored by Fruit of the Loom.
And just let me know when it appears to be working.
Have you tried changing the batteries in the wireless mics? They're bouncing the system. Looks like all the...
While we're waiting, if you have any water bottles or such, feel free to drink them. It is a little bit warm in here today, so I will be drinking from my water, so don't hesitate to use that if you need to.
Okay, mics are working, Judge. We can start now. Bright Bear, good morning. 26 months makes you an OG. A little bit of a tech issue this morning. Because of how KSL is shooting this, I believe they're shooting this in 29.97 frames per second, and it's interlaced instead of progressive. If it was 29.97p, it would take the whole picture that cameras can see at once, and send that. Interlaced takes half the picture in lines, it paints stripes, and then it rotates down a line, pixel, and then takes the other half. So it alternates back and forth like this. An effect of that is when people move quickly across the screen, you see like a little jagged edge, lined edge on the camera. TV does interlaced because it takes less data to transfer. It's a little easier on the live stream, but it doesn't look as good. I'm a big fan of progressive. Bright Bear, thank you very much. Welcome you. That was my nerd moment, sharing a little video here. Who are we hearing? The multiple hats. that was a sound effect that was triggered by Laura. We normally turn those off, Laura, during court. But it was quiet, so it's okay. We do save audio sound bites from various courts that we watch that can be triggered by you guys. Like this one, the Blackbirder just did.
I think Can you send them a link to where
now
this
I'm going to turn it off,
so they have something to look at? I see. All right. All right, let's go ahead and continue. And let me repeat it, just because the audio may have cut out. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. Second, the court will address the camera operator and still photographer, and I will invite you to come forward.
The camera operator is from KSL, a still photographer is from Deseret News. They are sister companies owned by the same corporation, which is a church.
All right. Today's, the purpose of this is to ensure clarity regarding the expectations governing today's proceedings. Could you both state your name for the record?
Yes, Trent Nelson with the Salt Lake Tribune as the pool still photographer.
John Wilson from KSL Television, video photographer.
Good morning to you both. Have you reviewed the court's standing decorum order?
Yes, Your Honor.
Yes.
Do you understand the requirements set forth in that order as they apply to your activities today?
Yes.
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
No.
Do you anticipate any difficulty complying with the order or today or with the court's instructions?
No.
All right. Well, thank you. I appreciate your cooperation today. As we begin this morning, the court wishes to acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. The court also expects every person in attendance will be treated with the dignity and respect to which they are entitled. Consistent with the court's standing decorum order, all spectators shall remain quiet, civil, and orderly during all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or other visible reactions during today's hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or opposing to any person connected with this case, or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, orderly, and faithful to the rights and dignity of every person involved. Turning now to counsel. Before we begin, I wish to acknowledge the professionalism, civility, and competence demonstrated by counsel for both the defense and prosecution during yesterday's proceedings. It is evident to the court that each of you approach this matter with seriousness, preparation, and a deep commitment to your respected responsibilities. The court appreciates the care which you have taken in advocating for your positions and the respectful manner in which you have done so. Thank you. Do either party require the benefit of the record before we proceed?
The state does, Your Honor. Mr. McBride will address the court.
All right. And just as a reminder, the microphones at counsel table are turned off to prevent the inadvertent capture of any communication. So if you would like to come forward, thank you. And turning to Mr. McBride.
Thank you, Your Honor. Before this hearing, the defense moved to find Article 1, Section 12 of the Utah Constitution, Rule 7B, and Rule 1102 unconstitutional as it relates to the admissibility of hearsay and reliable hearsay at this hearing. The issue was extensively briefed and argued. The court denied the defense motion to exclude the use of reliable hearsay at the preliminary hearing. That ruling is at docket number 631. In addition, defense counsel filed a standing objection on July 3rd. That's docket 678. The standing objection reasserted the arguments made in defendant's previous motion. Defendant continues to make these same objections throughout the testimony of each witness. I believe both the state and the court and everyone present knows that the defense objects to the use of hearsay or reliable hearsay at this hearing. On the point of preserving the objection, that has been done. Defense counsel has filed their motion, they filed their standing objection. Throughout the proceeding, they have continued to make objections. At this point, further objection is unnecessary to preserve the record and causes undue and unnecessary delay. This is needless delay, and we'd ask the court to acknowledge and the record to reflect the standing objection. And we also ask the court to give an instruction that continuing objections on this ground are unnecessary. Of course, if it relates to some other ground or is some item that's particular to a particular statement, that objection may be appropriate. But at this point, we feel that the repeated objections that have been made and already been ruled upon are unnecessary and cause undue delay.
Thank you, Mr. McBride.
Defense.
Defense.
You know it's right, Ms. Nestor.
Good morning, Your Honor. Michael Burt for Mr. Robinson. We have no objection to that procedure as long as the court makes a ruling that the objections are preserved. We do think it would expedite matters if we didn't have to repeat the standing objection. There may be particular objections that are not covered by the standing objection we've made, and so we ask permission to be allowed to make those objections as needed.
Thank you, Mr. Burt. Thank you to both sides. I appreciate the presentation and your argument about this. The court takes no position in regards to whether the objection is made again and again or not. I leave that to the parties. I recognize the need to expedite this, and if both sides stipulate, I will adopt the request that the standing objection as it relates to 1102, Article 1, Section 12 of the Utah Constitution, and all relevant authorities that have been cited have been noted, and the standing objection by defense is in place. However, if defense feels the need to do that in order to protect the constitutional rights of Mr. Robinson, the court will not prevent that, nor stand in its way. This court is not is acting in the role of a magistrate and will allow the parties to move forward as necessary. But as noted, I will make that note that the standing objection has been noted for all of the yesterday's proceedings and will be in place throughout the rest of the preliminary hearing. Anything further or any need for the record given the court's statement?
Not from the state.
No, Your Honor.
All right, thank you.
Thanks the prosecution for that one.
All right, the court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. And again, I will leave it to the parties to monitor the courtroom to ensure that if a witness has come in, and they shouldn't be, that they are redirected. I invite Agent Hull to return to the stand to resume direct examination. And Agent Hull, you are still under oath. Mr. Sturgill?
Thank you, Judge.
And before we begin, is there a way to dim these lights just a tad like we did yesterday? Perfect. Thank you.
Nice. We can
All right,
compensate with the iris on the
as of
camera.
yesterday, there is also a water bottle to your left. And if you wouldn't mind just making sure that microphone is directly in front of you, we want to make sure that the record picks up your testimony today. Mr. Sturgill, you're a witness.
Thank you, Judge. Agent Hull, we're going to return to what has been marked State's Exhibit 12.1. There was reference to it yesterday.
It's the compilation
and
video.
I'd like to ask you again, have you reviewed that exhibit?
Yes.
And if you wouldn't mind, just briefly remind us what that exhibit consists of.
The exhibit is a compilation or
His mic's off. We're going to fix that.
summary of videos from UVU campus security footage that was obtained.
Okay.
Your Honor, excuse
Judges
me,
on
we
it.
can't hear the witness.
And that's what I hear. So let's go ahead and
Yeah.
stop. I'm not hearing it, so I'm going to have you repeat. Let's test it. Go ahead.
Check.
All right, I believe that.
Thank you.
Mr. Sturgill, if you wouldn't mind restarting.
I can do that, Judge.
Thank you.
Maybe bring the mic from the base a little bit closer to you. I don't know if that'll help. All right, let's go ahead and go back to what's been marked as State's Exhibit 12.1. I'd asked you a moment ago if you'd reviewed that exhibit.
Yes, I have.
Okay. And would you just remind us what that exhibit consists of?
It's a compilation of videos that were part of the overall footage that was obtained from the Utah Valley University as part of the investigation.
And does that compilation video, from your point of view, capture Mr. Robinson arriving to and visiting the UVU campus?
It does, yes.
On September 10th through the 11th, 2025?
Correct.
Okay. And again, I asked you this question yesterday, but did you prepare that video compilation?
I did not.
Okay. Do you know who did?
The Utah County Attorney's Office.
Okay. Does that video, and I'm referring to 12.1 exhibit, State's Exhibit 12.1, does it include all of the footage collected by the SBI from UVU?
It does not, no.
Does that video, again, 12.1, include all of the footage you collected from UVU that captures who you believe is Mr. Robinson walking around campus?
Not all of the footage, no.
You reviewed this compilation with Mr. Olson, correct?
Correct.
Okay. And in its entirety?
Yes.
And he actually, and then you collected an 1102 statement from him?
I did, yes.
And I believe that has actually been admitted into evidence as State's Exhibit 12.3. Did Mr. Olson refer to that exhibit, 12.1, in his statement?
He did, yes.
Okay. 12.3. I'm going to put on your monitor State's Exhibit 12.3, and I'd ask that you scroll down towards the very bottom. And I would ask that you read from the statement specifically what Mr. Olson said about State's Exhibit 12.1. And I want to narrow your focus, so I'm going to draw your attention about 3/4 down the page. There's a sentence that begins on the left margin, "I have reviewed." Do you see that?
I do, yes.
Okay, would you please read that sentence?
I have reviewed State's Exhibit 12.1, and the recordings are true and accurate, including timestamps, dates, and camera labels. The only changes are some zooms and red highlights, which were not part of the original recording.
Okay.
Would
Have
like me
you,
to-
I'm sorry?
Sorry, I didn't know if you wanted me to continue. Or...
No, that's good enough. Have you had a chance, well, you reviewed the raw footage yourself, is that correct?
Correct.
And does that comport with your viewpoint of that exhibit?
It does, yes.
Have you had a chance to review what's been marked as State's Exhibit 12.4?
Yes.
Okay, and when did you review that exhibit?
This morning.
And who did you review that exhibit with?
With Kimberly Durfler.
Okay. Was there any conversation about that exhibit?
No, I was just shown the video.
Okay. Nobody asked you questions or suggested anything to you?
They did not know.
Okay. The did you prepare that exhibit?
I did not.
Do you know who did?
The Utah County Attorney's Office.
All right. And I'm referring specifically to what's been marked State's Exhibit 12.4. What is depicted in that video?
That video is, again, a compilation of videos from the overall footage that was obtained from Utah Valley University for September 11th and September 12th.
And how does it compare to what's been marked as State's Exhibit 12.1?
It appears to be the same footage. However, on this particular version, there were no circles or blurs that had been made to the video.
How about zooming in and zooming out?
No, there was no zooming or zooming out.
Does it appear to be identical to the raw footage that you've seen that portrays this particular part of the UVU surveillance video?
It does, yes.
Judge, the state would move to admit what's been marked State's Exhibit 12.4.
Your Honor, we just object to the publication of this for all the reasons we argued yesterday. We think this video is going to play a big role in the trial, and to allow the public to see it now would seriously impact our ability to get a fair trial, and we're asking the court not to publish it.
We've already seen it.
Thank you. And Mr. Sturgill, and to all counsel, as it will apply to all counsel, when you are moving a piece of evidence, it's the three parts, whether admissibility into the record,
right,
to be published in the courtroom, and captured by the media. So, Mr. Sturgill, as it's your request, what are you requesting?
Judge, first of all, clearly I'd move to admit the exhibit. I'd ask, and Judge, the presumption is that this is a public record and should be published. And so the state's position is that it should be published here in the courtroom, and it should be published in such a way that the media can capture it on video.
All right.
Your Honor, can I be heard on that very briefly?
You may, if you would approach the lectern, please.
Media lawyer. He's
your
going
name.
to double down. Here we go. This is going to be
I'm
good.
David Ryman. I represent the news media. I didn't make an appearance because the news media technically aren't parties, but as you know, they do have the right to be heard on issues like this, and I've tried to keep that to a minimum. But since this is the first one coming up today, I thought it might be helpful to just address it again. there is a presumption not just that it be published in the courtroom, as we talked about yesterday, because the participants or the spectators in the courtroom have a right to know what the court is viewing so that they can understand how you're making your decision. This seems like a very important piece of evidence. It doesn't seem like there is a basis to keep the people who are in the courtroom today from understanding why it's being introduced. It is not like the videos yesterday, my understanding at least is, and you can correct me if I'm wrong, but we didn't object to the videos that weren't published yesterday that were graphic. We didn't object to the non-publication of the autopsy report. The argument here that Ms. Nestor just made is this seems really relevant, and that is precisely why it needs to be public. With the last thing I'll address is just EMC. There is a presumption, it's a rule presumption, not a constitutional one, that EMC is allowed. And I think that for all of the reasons that we've briefed this for Your Honor several different ways, there needs to be a really good reason why. You know, if it's being published in a public proceeding in the courtroom, it should not also be it should not also be allowed to be published to the media. So,
thank you.
Thank you.
Mr. Sturgill, do you wish to respond or perhaps give a little bit more detail on what this video purports to show?
Well, do you want me to proffer that, Judge, or have the witness?
I'll defer to you.
Okay. Well, first of all, if I could take one step back. Let me ask you, I may have misheard, but let's just be clear about this video, the compilation video. It includes video surveillance from UVU campus from what dates?
September 10th, 2025 into the morning of the 11th, 2025.
And if you wouldn't mind just describing in a bit more detail what this compilation includes.
The compilation shows the movements of the individual believed to be Mr. Robinson on Utah Valley University campus, arriving and leaving in a vehicle, arriving and leaving on foot, and then returning and leaving, and then attempting to gain access again in a vehicle. And his movements throughout the day are included in the videos also.
Is there any footage of the alleged shooting?
There is not, Judge.
Okay, I just want to clarify
It's
that.
coming in, and we're getting it.
Ms. Nestor, given that additional information and anything further from defense?
Mike?
Mr. Burt's he's the one who's been litigating all of the First Amendment issues, if he could address Mr. Ryman's argument.
Yes, Mr. Burt, if you wouldn't mind coming forward.
Judge, I wanted to clarify one argument that was made by counsel for the media yesterday, and that was the rules, the Rule 4-202.02 does not apply to the situation we're in right now, and that is wrong. The rule says that this rule applies to the judicial branch, and 4-202.02J says the judge may regulate or deny access to exhibits to ensure a fair trial. So I think that rule does apply to our situation, and the Supreme Court in the Algier, ALLGIER case, 258 Pacific 3rd, 589, applied the rule in the context of an evidentiary exhibit. And I know the court has not mentioned, since counsel made that argument, this particular rule, but I think it does apply here. And also applicable is the Supreme Court's decision in the Kearns case, which we talked about when we argued the motion for denying access to the cameras. And that case, Kearns versus Tribune Corporation, 685 Pacific 2nd, 515, says that the standard the court ought to apply in determining whether an exhibit at a preliminary hearing should be sealed is one of a, quote, realistic likelihood of prejudice. And we rely on the evidentiary showing we've made in connection with our motion to exclude cameras, that there is a realistic likelihood of prejudice in this way. The court knows and has access to the media coverage up to the time when we litigated the motion concerning closing this hearing to the cameras. And the court knows that one feature of the media coverage has been a very pro-prosecution bias of every story that has been published on this account. The court also knows from that coverage that information is being widely disseminated, and you have found in connection with the shackling issue that the publicity in this case is likely to reach jurors who will be part of our jury pool. And we've also submitted to the court a public opinion survey which shows that the prejudicial publicity that the media has already generated in this case has affected the jury pool. And so those are all factors the court can point to and rely on and conclude that publication of this particular exhibit should not be allowed because there is a realistic likelihood of prejudice to Mr. Robinson's right to a fair trial. So under that standard and under the rule, the court ought to deny publication.
Thank you, Mr. Burt.
Thank you.
Any final argument from the parties before the court issues its ruling?
Your Honor, can I be heard on that briefly?
Yes, you may.
Thank you, Your Honor. David Ryman. I just wanted to clarify. I don't know that Mr. Burt and I necessarily disagree about what he said about the rule. What we were talking about yesterday was something different. That is the portion of the rule that classifies records that are in the court file. You know, it's not the same as what happens in a public hearing. And Mr. Burt referenced the portion of the rule that essentially just tracks the constitutional standard, which of course, you know, controls here as to whether in this public proceeding it can be closed in any way, and non-publication of exhibits as a form of closure. So I don't necessarily disagree. I would just underscore a lot of what Mr. Burt just said has been briefed ad nauseum at this point. Their position that publicity is incompatible with a fair trial. The Allgaier case he mentioned, you know, I know that case. I litigated that case. It involved a confession that the court found public because you have so many other tools to seat a fair and impartial jury. And we have cited that case repeatedly, and so has Your Honor, I think, recognized it in your ruling, saying pretrial publicity can coexist with the defendant's right to a fair trial. So the last thing I'll say is just that the constitutional standard that I think we're all agreeing applies here is weighty and difficult to overcome. And it is never satisfied, as we've explained, by just generalized assertions that there's a lot of publicity out there. It's got to be something really specific, and they just haven't made that showing. And I certainly don't think that a video that apparently just shows the defendant walking around the UVU campus qualifies.
Thank you. Anything further?
From the state, no, but I think I'd like to be crystal clear. You asked if there's any portion of this video that captures, and I believe you asked of the actual shooting. There's no video of that. There is video, however, and you've heard testimony related to this, where the shooter goes to the top of the low-C building, goes out to the edge of the building, low crawls, and then leaves after what we assume is the shot being fired. That's as close as it gets. I don't know if that makes a difference, Judge. I just wanted to make the record clear, and I want to be crystal clear with Your Honor.
Thank you. I appreciate that clarification as it is guiding for this court and making its ruling. I turn to Utah. Well, let me pull this up. So Rule 4-202.02. I go down to, well, first it says statement of the rule. 1, presumption of public court records. Court records are public unless otherwise classified by this rule. 2, public court records include but are not limited to. And I'm going to go down to 2J, exhibits, but the judge may regulate or deny access to ensure the integrity of the exhibit a fair trial, or interests favoring closure. And the court recognizes the importance of the constitutional rights of Mr. Robinson being upheld and protected. At the same time, the court also recognizes the importance of transparency and a proper balance to ensure that the constitutional rights of all parties are upheld. As it relates to this exhibit, I believe it's 12.4.
12.4, yes.
Based off the representation of what is in that, the court differentiates this exhibit from the exhibits from yesterday, namely Exhibit 7, Exhibit 8, and Exhibit 9.
Which we did not get to see.
As
So
those are
differentiated.
different in nature.
This is good for us so
And
far.
those go to issues relating to Utah Constitution, Article 1, Section 28, as it relates to the Declaration of the Rights of Crime Victims.
I owe you one, Greg.
And the court also recognizes Utah Rule of Evidence 1102, as that is the foundation that's being laid for the admission of this exhibit. Having taken in consideration all factors, the court rules that Exhibit 12.4 is admitted into evidence and shall be played in the courtroom and may be broadcast by the media.
We got it.
We can proceed.
Thank you, Judge. Agent Hall, before we actually watch State's Exhibit 12.4, I have just a few questions. Yesterday, you testified at the very beginning of your investigation that you focused on the video that captured the shooter on the top of the Low-C building. Is that correct?
Yes.
I believe you also testified that you began by working your way, and this is what I remember you saying, so correct me if I'm wrong, but you in essence testified that you began with that video and you started working your way backward and forward with the UVU surveillance video in an effort to trace the shooter's steps on campus. Is that right?
Correct.
Okay. Would you mind explaining just in a little bit more detail what you meant by that, tracking forward and backward on that video?
Yeah, we had a known when the shooting occurred, and as the officer testified, there was a video of an individual on the roof at the time of the shooting. And so the philosophy that we applied was to take what we knew and then work that forward through the timeline and backwards through the timeline to try and establish where the individual had gone from the rooftop or how the individual had come to be on the rooftop.
And did that, for lack of a better term, did that bear fruit?
It did,
Did you
yes.
actually see from, at least in part, where he came from and where that shooter went?
Yes, more so where he came from. It was very limited after the fact.
You testified yesterday that, in reference, I believe, to what's marked State's Exhibit 21, that you believe Mr. Robinson visited campus at least 4 times on the 10th and the 11th.
Correct.
And I think you reaffirmed that today. Did you do the same attempt, that is, to track Mr. Robinson through UVU surveillance video during each of those 4 visits?
Yes.
Or those other 3 visits, I guess?
Yes, on each occasion we attempted to follow the movements of the individual throughout campus.
And did you in fact see Mr. Robinson on campus in surveillance video that is not included in State's Exhibit 12.4?
Yes, there is additional footage of him on campus, yes.
Okay. I'm going to have displayed on your monitor what you're going to see is a paused or a still image. And I'm going to ask if you recognize what you see that now, Agent Hall?
I do, yes.
Okay. Do you recognize what's displayed on your monitor?
Yes, it's footage from the university that was provided to us, particularly of the parking structure.
Okay. Does it appear to be State's Exhibit 12.4?
It does, yes.
So I'm going to go ahead and I'm going to have this video run. And then if you don't mind, as it's running, I'm probably going to be asking you some questions. And so this video has no audio, is that right?
No, there's no audio on the cameras.
Okay. Let's go ahead and start the video.
Your Honor, it's just not up on the screen yet. Maybe
Let's go ahead and put it on all screens.
All right, we get it a little bit
No,
of
I
an angle.
appreciate it.
I wish we got a better
It
view
is,
here. But
so it is admitted and may be published to the screens. And just want to make sure it's on your screen, Agent. All right. All right, Mr. Sturgill, you may proceed.
Appreciate that, Judge. Thank you. Go ahead. Okay, what are we seeing here, Agent Hall?
That's the vehicle that is believed to belong to Mr. Robinson arriving in the parking garage on campus.
At what time in the morning? What time of the day?
It's approximately 8:30 in the morning on September 10th, 2025.
And what leads you to believe that this particular vehicle belongs to Mr. Robinson?
Information that was provided regards to driver's license and Department of Motor Vehicle records. The vehicle fits the description of a vehicle owned by Mr. Robinson.
Is there anything unique about that vehicle that stands out to you?
The shape of the vehicle is very distinct, but predominantly the wheels were very distinctive on this version of the vehicle.
Now what do we see?
The driver of the vehicle exits the vehicle and then walks on foot to exit the parking garage. It's the individual in the red T-shirt and the shorts and the shoes.
And do you believe you recognize who that person is?
Yes.
Who is that?
I believe that's Tyler Robinson.
All right, and where does he go from there?
He heads out of the parking garage on foot into the campus and actually goes to the quad area of the campus. At that time, he makes contact with some representatives from TPUSA.
By quad area?
Sorry, the amphitheater is what I previously referred it to.
All right. So he goes up on campus, visits the amphitheater area, the courtyard or quad.
Correct.
And then what do we see here now?
He returns on foot back to the same vehicle.
And what time is he returning back to the vehicle?
It's about 9:25 a.m.
And where is this parking structure located on campus?
It's just off of Campus Drive. It's a short walk from the amphitheater.
What do we see now?
That's the vehicle exiting with Mr. Robinson driving the vehicle.
Now what do we see?
This is Mr. Robinson returning to the campus on foot from the neighborhood to the northeast. You can see he's wearing the same clothing as in the previous video. And he's carrying a blue backpack.
Describe the clothing.
It's a maroon colored t-shirt with gray or olive colored shorts and then Converse shoes.
And what time did he return to campus?
Just after 10 a.m.
And does he leave the parking structure eventually?
He does, yes.
Okay. And during this visit, do you know where he goes after he leaves the parking structure?
Yes, we were able to track his movements on campus. He went to Chick-fil-A in the Sorensen building and purchased some food, sat and ate the food. Then, I'm sorry.
Where did he purchase the food from?
Chick-fil-A in the Sorensen Center.
And where is that in relation to the amphitheater or the courtyard?
It's kind of on the northeast side of the amphitheater. It would be on the upper back edge of the amphitheater, furthest away from where the tent was that Mr. Kirk was in.
And from there, where does he go?
From there, he moves across campus, out across Campus Drive into a wooded area on what would be kind of the northeast side of Campus Drive. Then returns back onto campus. We noticed at this point that he's no longer carrying the backpack that he was originally wearing. He moves through the Gunther building and the computer science building. And then, I'm sorry?
And then goes where?
Then goes across to the railing that gives access to the roof of the Losi building.
And from there?
From there, he comes back down the stairs and walks off campus from that point.
And about what time was that he left campus that second time? Do you know?
I believe it was approximately 11 a.m. or just after, if I recall. I could verify from my notes if you need an exact time.
Yeah, if you don't mind. That'll help you remember, refer to it. Don't read it out loud. Just let me know when you've had a chance to look at that, would you?
There's some good cameras so far. Not all of them are going to have this quality of footage. They have video footage that
Were
they're
you able
not showing
to
us.
refresh your memory as far as the time?
I was, yes.
Okay, and what time was it?
It was just prior to 11 a.m. when he walked off campus.
Okay. And before we go any further, the parking structure that he left initially, where is that parking structure in relation to the LDS Institute building?
I'm sorry, in relation to?
The LDS Institute building on campus?
I think it would be just to the north of the LDS Institute building, if I recall.
Do you recall whether it was adjacent to the LDS Institute?
Yes, it is.
Okay. All right. What do we see displayed here now? Go ahead.
This is a video of Mr. Robinson returning back to campus the same way that he did previously on foot.
And this takes just a moment.
Okay, there we go.
And why, well, let me ask you this. You believe this is Mr. Robinson returning to campus?
I do, yes.
Okay. And why do you believe it's Mr. Robinson?
The shoes are the same, and the images that we have are from my viewing and seeing Mr. Robinson on the video, it's the same person.
He's noticeably wearing different clothing.
He is wearing different clothing, and he also is walking with a gait or a limp in this video.
With a gait or what?
A limp.
Okay. Now what do we see?
So this is Mr. Robinson coming up the stairs of the parking structure. Again, he seems to be having issues walking.
And again, were you able to track Mr. Robinson when he leaves this parking structure?
Yes, we were able to.
Okay. So when he leaves the parking structure, where does he go?
He comes up around Campus Drive, as you can see on the video here. There is a cut through there north of the Losi building, and that's Mr. Robinson coming up the sidewalk. He has the noticeable gait or limp in his walk. And then he moves south across the front of the Losi building.
On the sidewalk?
Yes, correct.
Okay.
He would be the rear of the two individuals in this particular video.
So right now, if we were to break this picture into quadrants, where would he be?
Top left.
He would be in the top left quadrant, walking to the left of the image.
Now what do we see?
It's going to enter on the top right.
This is an image looking across the parking lot to the Losi building, and Mr. Robinson is appearing on the exterior staircase, which gives access to the Losi building roof and the area where the railing was.
And again, let's break that image into quadrants. Where would he be located if you broke it into quadrants?
It's in the top right, and the individual can be seen moving under the notations that are on the video.
Okay. And what time is this?
It's just after noon, about 12:15.
On what day?
On September 10th, 2025.
Okay. What just happened, or what did we just see happen?
The individual actually kind of rolls over the railing onto the roof of the Losi building.
All right. Go ahead, sir.
And again, in the top left corner, the individual is now seen running across the rooftop of the Losi building to what would be the southwest corner of the building, crouching down and then crawling to the corner of the building.
And this is at what time?
Around 12:23. I think the timestamp on the video is 12:22.
On the 10th.
On September 10th, yes, 2025.
So we're clear, this is the roof of the Losi building.
Correct.
Can you still see that individual?
Yes, you can, laying prone.
We'll have to zoom in on that one. Be in the top left-hand corner of this building with the atrium, but
You believe this to be Mr. Robinson?
I'm sorry?
You believe this to be Mr. Robinson?
I do, yes.
And how long is he out there on the edge of the building?
Just until the reported shot was fired at 12:23 and 28. The individual then stands up and then moves across the building to the north.
Is that what we're seeing happening right now?
It is, yes. They move behind the atrium area on the rooftop to the northeast corner where the white triangle is.
there he is running to the triangle.
Do you see Mr. Robinson now?
I do, yes. He's just arriving at the corner of the building, almost the top center of the image.
Climbs over the edge. He's hanging and
What are we
drops
seeing now?
down.
And Mr. Robinson lowering and jumping off of the roof of the Losi building onto the grass area, and then moving away towards Campus Drive. And he appears to be carrying some kind of an object in his hand at this time.
The angle's bad for us, and it's far away.
So he's
from the
approaching,
Campus Drive.
and again, broken into quadrants. Where is he currently?
Be in the top right quadrant.
And the time?
It's 12:24 and 42 on the timestamp.
What do we see now?
He then crosses Campus Drive and drops down into the wooded area on the far side of Campus Drive.
And that is located in what part of the video? What quadrant?
It would have been just off center on the top left side.
What do we see now?
This is the intersection of Campus Drive and 800 South. There's a vehicle attempting to turn right onto Campus Drive. That's the vehicle that's driven by Mr. Robinson.
And on the screen, where is that vehicle that you're referring to located, if you broke it into quadrants?
It's on the left side, on the upper side, the upper quadrant.
And he doesn't turn right. Decides
Now
to
what
go
do we
straight.
see?
That vehicle's now pulling away and heading east on 800 South.
And why do you believe that that vehicle is Mr. Robinson's vehicle?
When that vehicle was stopped, it actually made contact with an officer who was doing security detail.
Okay, and do you know who that officer is? or
Officer
was?
Goforth,
Okay, and do you know which department he works for?
Spanish Fork Police.
And did you have a conversation with Mr. Goforth regarding this interaction at that intersection?
I did, yes.
Okay, and what time was that interaction? I'm sorry, did I ask you that?
It was approximately 12:30 a.m.
On the 11th?
on September 11th, 2025.
So you talked to Officer Goforth about that contact on the corner on that, during the early morning hours of the 11th?
Correct.
And what did Officer Goforth tell you about that interaction?
It was an interaction that, I guess cop intuition, but there was something about the interaction that made him make a note of the license plate of the vehicle. And then subsequently, when information was available that vehicle, or a vehicle matching the description of that, was involved in the incident, he ran the information that he had obtained from the stop and was able to identify that it was registered to Mr. Robinson, and he had in fact had contact with Mr. Robinson on the morning of September 11th, 2025.
The information that he ran, do you know what information when you say that, he ran information?
Yes, he ran a partial plate.
Okay. A license plate?
Correct.
And based on that partial license plate, he was able to identify the owner of that vehicle?
Yes,
And did he tell you who the owner of that vehicle was?
he did, yes.
Okay, and who did he tell you that it belonged to?
Said there were 2 registered owners of the vehicle, Tyler Robinson and an Amber Robinson.
Did he say anything about the person that he actually interacted with?
Yes, it was a male that he believed to be Tyler Robinson.
Let's return again to what's been marked State's Exhibit 12.1. Again, you've reviewed that video.
Yes.
And the difference between 12.1, or what's been marked as State's Exhibit 12.1 and 12.4 are, if I understand you correctly, are these enhancements that we've been talking about.
Yes.
And specifically, be specific about the enhancements, and let's go one at a time.
Okay.
I think there's a reference to either red circles or red highlights. I think
Correct.
That's how Mr. Olson described it, red highlights.
Yes.
Do you know what he's, or what is he referencing by the red highlights, or what do you believe he's referencing?
I believe he's referring to red ovals or circles that were placed over the image to identify specific individuals of note.
And these red circles, are they permanent red circles? Are they temporary?
I'm
different.
I would assume they are temporary. I'm not very technological, but I believe they would be overlaid over the image.
And this is a bad question. What I mean by that is do they appear and disappear quickly, or do they linger or last for a period of time?
They're there for a notable period, but I believe they come off the video. But
All right. And other than, well, and you said that the circles, what do the circles do?
they identify an area or a person of interest within the video.
And other than do that, do the circles or the highlights, do they do anything with regards to the video itself, as far as its accuracy?
Not to my knowledge, no.
Okay. I think the next enhancement that has been mentioned that we've talked about is there's some blurring.
Yes.
Do you know what that? Tell us what that is. What blurring do you see in what's been marked as State's Exhibit 12.1 that you now don't see in 12.4?
If I recall, there were some individuals in the parking garage footage, and their faces were blurred.
Excuse me. Is anything other than faces being blurred?
Not that I recall, no.
Okay. And how often do you see the blurring throughout the video?
I believe it's just in the original sequence in the parking garage.
The other than the blurring, does the blurring, other than obviously blur out part of the image, does it change or impact the accuracy in your mind of that part of the compilation video?
Not to my knowledge, no.
And then the last thing is, I believe, is there's some zooming in and zooming out that's in 12.1 that has been removed
yes.
from 12.4. What can you tell us about the zooming in and the zooming out?
Predominantly, it's in the area that was referred to as viewing the Losi building rooftop. Mm-hmm. I believe it focuses on the area where Mr. Robinson comes up the stairs and onto the rooftop. Those portions of that particular footage were zoomed in for clarity.
Other than zooming in and zooming out, does at least that enhancement to the video, does it change the content of the video?
No.
The accuracy of the video in your mind?
No.
Okay. Are the enhancements in State's Exhibit, well, it's been marked as State's Exhibit 12.1, are they helpful in any way, or what do they add or take away from that video?
I think for people who are not familiar with the area and what's trying to be shown, they allow an opportunity for people to look at an individual who we believe to be Tyler Robinson, and also specific movements with more clarity than the original focal point gives.
So let's talk about the zooming in and the zooming out. It sounds like it's specific to the low-C rooftop, if I understand you correctly.
Yes.
Okay. And I think we've all watched that exhibit.
Correct.
4. And although you can see Mr. Robinson and his movements, is it fair to say that it's difficult to really see what's going on?
That would be fair, yes.
Okay. And the version that's in 12.1, does it facilitate at least that part of the video, seeing Mr. Robinson and tracking, I guess, his steps?
I believe so, yes.
Okay. Judge, at this point, I think in combination with yesterday, the foundation that was laid yesterday, including the written statement from Mr. Olson, which has been admitted into evidence and is, well, it's already been admitted into evidence. We believe there's enough foundation that at this point we'd also ask the court to admit what's been marked State's Exhibit 12.1. We think it would be well, beneficial for Your Honor to view it.
And publish.
Thank you, Your Honor. We renew our authenticity objection, and we also object to for admission purposes. And then we also object to the publication for the same reasons, the fair trial issues that we raised with the unaltered version that was just submitted.
And Judge, sorry, I neglected to mention the other two. Again, Judge, we believe that the presumption is that this is a public record, that it should be not only admitted, but it should be published here in the courtroom, and it should be published in such a way that the media can have access to it.
All right. I do have a question in just directing your attention to the Utah Rule of Evidence 403, to the last phrase, the last
best evidence.
4 words in that. Do you wish to address that?
Judge, I'm going to have to look at 403 specifically for those last 4 words, unless you want to share that with me.
I can read that. Or
Okay,
needlessly presenting cumulative evidence. So the court may, let me just read the whole rule.
It clarifies, it's not
completeness. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issue, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. I'm not looking at anything else other than that last portion. I recognize there is no jury. I am the magistrate. I am the fact finder, but just addressing that
fact.
last point of Rule 403.
Right.
This is not cumulative.
I don't believe that the evidence is cumulative. I think that each of the 2 videos, although they portray basically the same footage, there's characteristics of the one that has been enhanced that I think makes it easier for Your Honor to truly see what's going on, and for the public to see what's going on. I mean, we've displayed 12.4 on the video, and unless you have very, very, very good vision or you've zoomed in on that monitor, you really can't see what Agent Hull has just described. The character of 12.1 is it simply, it enhances that at least important parts of that exhibit, and it just makes it easier to see, not only by Your Honor, but also by the public. And specifically as it relates to the zooming in and the zooming out.
Okay. Anything further from the parties as it relates to 12.1? All right, well, I will admit 12.1 into evidence, but as it relates to playing it in the courtroom or on the television, well, for the media, I find that it is, well, as the fact finder, I will look at the evidence and weigh it as a magistrate is required to do, but I do not find it is.
No, you can't. You can't do that. You can't admit it and say
I don't find it's necessary
in,
to replay this video, given the representation that's the exact same video, the difference being enhancements made. If it was different in any way, or if it added to or subtracted from, that would be one factor. But because it's simply the same video, simply zooming in with circles or notations, the court does not find that the interest of justice requires it being played again. But it is received into evidence and will be reviewed by myself in determining a probable cause determination.
And I appreciate that, Judge. And just so we're clear,
You just split
State's
the baby.
Exhibit 12.1 has
It's
been
dead.
admitted.
It is received into evidence, yes.
And your
On
intent
what
is to
grounds?
review it in its entirety, but not here in the courtroom.
Yes.
Can I make one suggestion, Judge?
You can't do that.
Or maybe
Sure.
one run request. I believe the most important part of the most helpful part of this video is the zooming in and the zooming out. And that is a portion that, if you want, we could isolate that and only play that portion of the video, if you'd be willing to publish that portion of the video. And that's really the thrust of why we are trying to introduce that exhibit, because we believe that it's helpful to see it up close. And unfortunately, because of the way it's formatted and the way it's been recorded, there's no way any of us can zoom in and zoom out on this video to get a better look at what's going on. And that's the reason why we did what we did, but we had to memorialize it and save it, and then present it in that way, rather than just present it in its raw form and then have the ability to zoom in and out, if that helps Your Honor understand why we're doing what we're doing.
All right, Ms. Nestor, to the second request of not playing the whole video in its entirety, but simply the portion with the zooming in, how long is that, Mr. Sturgill?
I think it's a couple of minutes.
All right, Ms. Nestor.
We object to the prejudice of that, Your Honor, and ask the court to stand by your previous ruling on that.
Your Honor, it destroys our case.
Here's,
It destroys the defense.
thank you, I appreciate both parties. What I will do is review this video in court, and it will be displayed to the monitor's counsel table and to the court's monitor on any portion that you wish to play for me to look at, so all parties can see clearly that the court is reviewing it in court. But I do not find that it is necessary for its publication, because this is the exact same video. I recognize
You can't
it's zooming,
do that.
but in balancing constitutional rights, there is nothing on this video from what's been represented that the public hasn't already seen. It's simply zooming in, and I don't find that that is necessary.
Media stand up.
And so in balancing the constitutional rights of all parties, I'll view it on the monitor. Counsel's free to view it with me as I'm looking at it, but it will not be broadcast in the courtroom or by the video camera.
I appreciate that, Judge. I respect that. I think there's a natural break where we can start. And what I'm going to ask is just we simply play the most.
He's been the judge for less than a year.
You will have this entire exhibit in evidence, though.
Thank you.
Is that right?
Yes, I will. All right, whenever you're ready. Counsel, as it relates to your monitors, just as a caution, if you don't want it to be wished to be picked up, and I'm not saying it will, I know there are camera operators being diligent in ensuring they're complying by the rules, but in abundance of caution, this is just your moment to take care of your screens if you feel the need to do so.
Sure, if I could just have one moment. Hold on, Kimberly. Not sure where the power button is on that.
I can't begin to put words on this. It was just admitted.
There we go.
The public can see it, but he's ordered
All
the
right,
media
counsel
can't.
for defense, are we prepared?
He just
And for
straight
the state?
attacks the Constitution.
All right. Thank you. Having heard from both counsel, I'll go ahead and review it on my screens. It is not being displayed in the monitor in the courtroom. And you may present 12.1, the portion you wish for me to view.
There's a presumption that this is a public record. That's Utah rules in court. This is a presumption this is public. The judge is basically saying, yes.
And just for the benefit
it's
of the record,
important
you
for me
want
to
to
see
put
it.
on the record the timestamp of what you're playing, at what point you're starting and stopping, as we go, or when we finish is fine. I just want the record to be complete.
The media lawyer should be drafting a motion right now.
The difficulty in doing that is because we've zoomed in, it's removed the timestamp on it. And so-
Well, you can just give me the
count
The
on the
count
video?
on the bottom. There's a timer at the bottom of the total length of the video, so that's fine. I'm just trying to create a record of what exactly I'm looking at.
I realize this is unfortunate right here for us. I'm worried about trial. If the judge determines that the jury shouldn't see that because it's cumulative, we have a whole new batch of problems on our hands.
Whenever we pause on the court system,
Oh, I see. No, it's limitations of technology sometimes. Thank you for letting me know.
So the count on the video is just before 6-minute mark, Judge.
All right.
And just so the record's clear, this is State's Exhibit 12.1.
Thank you. I have it on my screen. It's so it looks like it's been paused at 6 minutes and 9 seconds.
Agent Hall, can you see it?
Yes.
Okay, well, let's just, I'm good with playing it. And we'll play it. Go ahead, Kimberly.
It's playing.
So they're playing this video, which we can't see. It's the same video we just watched, but zoomed in. So you can see, instead of taking saying it's up in the upper left-hand quadrant, they took that quadrant and blew it up to the full screen. And that's what the video is, or a little more. And it's like, so they didn't enhance, they didn't use AI to generate. All it does is it makes the pixels bigger. Okay? Instead of being little tiny pixels and little tiny pixels making up the suspect they think is Tyler Robinson, now the pixels are bigger, and now it's a Minecraft character we see in the video. That's it. The judge admitting this into evidence, saying, yes, this is important for the court to review in this case. I deem it is admissible. Yes, the public has the right to see it. No, the media can't. This is screaming goat time, Ladybug's mom. I'm calling it. That's a bad ruling. That's a bad ruling. His reasoning, I'm sure, is to protect the constitutional rights of Mr. Robinson, which specifically he's looking at right to a fair trial, as we still have the duty to pick a jury out of this media market. But the whole idea of, Your Honor, we can't let evidence in because it makes my client look bad. Maybe he shouldn't have done something that made him look bad. This is not a balance. This is not a balance between the right of the press, the freedom of the press enshrined in the Constitution, and Mr. Robinson's right to a fair trial. This is error on the side of caution to the extreme for Mr. Robinson's benefit.
All right, and it's been paused, it looks like, at 6 minutes and 23 seconds.
I'm sorry. Judge, at 8:23, we stopped the video.
Oh, at 8:23, okay.
8:23. That's the count on the video itself.
Thank you.
Okay.
All right. Thank you, Mr. Sturgill.
Agent Hull, you were able to watch that zoomed-in version. Is that
Yes, sir.
right? Okay. And was there anything that stood out watching that zoomed version?
For me, on the zoomed version, it's apparent that Mr. Robinson, the individual jumping off the roof, is carrying an item.
Okay. And you can see clear the clothing that he's wearing. Strike that.
Mr. Sturgill, do you want to respond to the objection?
Judge, it is leading.
I'll go ahead and sustain the objection, and that you may move forward.
Is it easier to see? Well, strike that, Judge. I'll let the video speak for itself. Judge, I have nothing further with Agent Hall.
All right. Ms. Nestor,
Just one moment, Your Honor, if I may have the court's indulgence.
All right, this is the judge just ruled that some people get to see, but other people don't. And how you can decide who gets to see and who doesn't when members of the public get to see, I don't know. I don't know how he can legally base that ruling.
And I was just going to suggest that. It seems like right now is a good time to take our morning break. It is 10:15. Let's come back at 10:30, and we'll resume with cross-examination of Agent Hull. Court is now in recess.
I'm not happy. The media lawyer is probably blowing smoke out his ears right now. That ruling, from my vantage point, was terrible. If it's admitted to court, there's a presumption that it's public. Period. For it not to be public, it has to fall in a very limited, very, very limited exception. The judge ruled that the very graphic videos of close-up of Charlie Kirk, blood getting the shot, the moment he got shot, that met that exception. And then he ruled that the security camera from 400 yards away also meets that exception, even though it doesn't see anything graphic. You can't even tell that a shot was fired in this video, even zoomed in. Got somebody calling. Hang on 1 second.
Call from Dr. Bullbutter.
Hey, Dr. Bullbutter. How are you doing?
Hey, Scott, how you doing?
Oh, man, I'm angry right now, but I'm trying to contain
I know.
it.
You're angry. I'm angry. I think this judge is thinking too much about the appeals that are going to be coming. Because, listen, Tyler Robinson is going to appeal. There are going to be appeals.
Well, if he's convicted in a death penalty case, it's automatic. It happens as literally automatically.
And he's going to be convicted. I can't see a world where he's not going to be.
Well, imagine one where some critical evidence is not allowed in because it makes him look bad.
Yeah, but this is the prelim. And the thing is...
But more should be allowed in here.
It was allowed in. It's just the public wasn't allowed to see it. And the problem that I see with this is that there have been conspiracy theories about CK getting taken out the way he was. Judicious about the way I say this.
Yeah, there are people out there that think that there was one of these Rode wireless transmitters that he was wearing inside his shirt with the magnet on the outside, and it was somehow a shaped charge that fired. It's that this process fixes that. As long as it's open.
I wanted everything to be laid bare, and I think, he was taken out in such a public way. And I'll never be the same. I've been following Charlie Kirk since he was 18 and came on the scene. I admit I'm a fan of his. I admit that. And so I'll never be the same after seeing the video of him.
Any video where someone is murdered in cold blood it offends our spirits, right? It offends our souls. It's wrong.
President Kennedy and the Zbrigger. What's that film? I can't say the name correctly. Of Jacqueline Kennedy sitting next to her husband as he dies. I'll never be the same after seeing that either. But
seeing this, I'll never be the same. And so I think this should be laid bare, because I think that would take away a lot of the problems of this. But listen, the reason I called in was because I happen to be a podiatrist and I study gait. And so we were looking at the video, and Tyler Robinson, the video of him walking, that was hysterical. As soon as I saw it, I mean, that's hysterical.
I think what they're trying to show us there is that it's possible that he couldn't bend his leg because there was something shoved down his pants, like a long
absolutely.
rifle.
I mean, I could see that from like a mile away.
It's a very.
I didn't miss.
It's not an injured walk at all.
No.
Yeah.
No. Because he doesn't look like he's in pain. I mean, there's a certain way you look when you're in pain and you're limping, and that's not that look. So either he's disabled and he always limps like that, or there's something going on. And yeah. But I find it really interesting. Yesterday, Nestor was talking about what was being carried, and the cop was saying it was long and thin and covered by a towel, and he now has something in this video that's down his pant leg and he can't bend his knee.
Yeah.
So I think it's going to be really easy to connect. I mean, because anybody that looks at that immediately is going to say rifle. I mean, immediately. It wouldn't even.
I would say it's a reasonable conclusion. It's not visible that we can see. I have not seen the zoomed-in video where I can't even see an object in his hand as he's walking away. I haven't seen that.
Right.
I've seen parts of it. I've seen the zoomed-in part where he jumps off the roof and everything. That's been out in the media quite a bit.
But if you're a person who's thinking there's a high-profile event happening on a college campus, you're going to be thinking, what do I have to think about? It's going to be one of the top things you would think. I would think, because I would think it, and I'm not law enforcement. I would think rifle.
Yeah. Dr. Bullbutter, I've got to go. We've got to focus here on the court here a little bit and what this ruling was. I'm frustrated. I'm trying to figure out what the fix would be right now. And I know the media lawyer didn't make his appearance in court. He's not a party. Technically, I don't think the judge even should be recognizing him. I'm glad he has these last 2 days, but I think he needs to stand up again and say, Your Honor, you're in the wrong. And that's a fine line to walk. So
He's drafting something right now, Scott.
I hope so. I hope it's strongly worded.
Maybe he needed to do something. And I was also thinking maybe there's a possibility that Tyler Robinson is going to plead if they can take the death penalty off the table.
Yeah.
And so maybe there won't be a trial and this will be it. And that's why they're fighting the way they're fighting.
I know Utah, the prosecutor has an appetite for the death penalty here. I'm not saying he just wants to kill people, but in this case, there has been a lot of pressure on them, and they announced that there was death penalty almost before they had caught the guy. They are going for the death penalty, so they won't be offering a plea. If the death penalty is off the table, it will be because of the prosecution violating a rule, being sanctioned, and that being stripped from them by the judge in the form of a sanction. That's the only way it's going to anything less than the death penalty, in my opinion. And if that happens, I can then see it plea, but it would end up with him life without parole. Period. They're not going to listen.
You don't think there's going to be a Koberger move? That's what I wanted to ask you.
I don't think that the prosecution is going to offer a plea. I think the defense would love to get life without parole instead of the death penalty. They would take that today in a blink. We don't even need to consult with our client. Judge will take it. But that deal is not being offered. Now, the prosecution, if they don't offer it, defense doesn't get it, period. Dr. Bullbutter, thank you very much. It's good talking to you. It's been too long.
Thank you, Scott. I really appreciate it. Thank you for taking my call.
We'll catch you again
please
soon.
say hi to Mrs. R.A.
I will. She's
Thank you
teaching the
so
kids
much.
Spanish right now. So, all right. Thanks a lot. We'll see you.
Take care.
Bye.
All righty. Bye-bye.
Yeah, the state is not going to take the death penalty off the table willingly. It will be taken from them if it goes at all, and I don't think it will. They're being very careful. They already had one sanction where they were held in contempt. That was Mr. Ballard for talking to the press. They're going to be very, very careful going forward about this. But this ruling by the judge, I'm struggling with this. This is so bad, is what it is. I just okay, hang on. I'm gonna try to fix this myself. Let's do inspector video reset, and another reset. I might fix the camera angle myself. So let's see if we can do this. I'm using DaVinci Resolve to adjust the camera to fit as if we were looking straight on the TV. It's a tool called the perspective positioner. That's what we're using here. All right, we're in a little bit of a break here. No. The judge just made a ruling. If you're confused about what just happened, the judge just made a ruling that this video, what the state struggled with, and this is the state's fault initially, right? Yesterday, the state tried to admit this video, which was a compilation of the security camera footage of Tyler Robinson on campus. Showing up, walking around, getting food, climbing up on the LoC building, climbing down off the LoC building, running away, running off campus and across Campus Drive. All of this, they put together a timeline, not a complete timeline. It cut out the Chick-fil-A part for some reason. They didn't want to show him eating his nuggets, but they put this together, and the video included zooms where there's a big wide shot of, like, you can see most of campus in the picture. They have to zoom into a little part to say, that little dot over there, that's him. They zoom in for that. And they put some circles to say, now look over here, this is the area I want you to focus on. Because they did that, defense successfully managed to keep this from coming in yesterday. The state scrambled, kept this witness on the stand saying, we have to break early, we're going to go back, we're going to re-edit this, we're going to take out all those corrections and stuff and just show the plain original video, and then it's our intent to show the other one after so you can see why we have the two. So the second one makes the first one make sense. And the judge ruled that that second video, while probative and admissible as evidence, and able to be shown to the court on the monitors, he now made a new ruling where sometimes if we show it on the monitors, you can't see it. And the media can't film it. For what reason? What articulatable reason did the judge offer that allows him to not let the media see something, but the public can? And he didn't meet that burden at all, period. End of story. This is a new judge. It is his very first death penalty case. He's only been on the bench for about a year. So, frustrated. Pantuflay, to overcome my own bias, I'm pretending that CK is a figure I adored. It's helping me focus on court rulings, regardless. No one deserves to be assassinated. Thank you, Pantuflay. Yeah, we're staying away from the politics of this one side or the other. The court proceedings, the trial itself is what we're focused on here. I realize that you may like him, you may love him, you may hate him, or just you might not even know anything about him. And that's okay. Well, we can still watch the court. We love the justice system, like watching it work. I just don't think it worked well today, just now. That's the frustrating part. And part of the frustration is the judge talked about the openness and why the media is important in this when he made the initial ruling that media would be allowed in this hearing, that it would help get rid of speculation and rumors and stuff, which are problematic for jury selection as well. And then he goes and closes parts of the testimony, the evidence that are probably the most beneficial in saying, oh, there was somebody else up there with him. Well, now that can still run rampant because we can't see the video that shows it was just one person. Oh, he must have had a tripod and a scope and a sniper, set up and everything. Well, now we can't zoom in and see what he had. So this is creating more problems than it fixes for sure. Time's up. Thanks, Lois. I appreciate you being the official keeper of time in the court. The judge has been fairly prompt, so any minute now. Any second now, we expect him to come back and bang his gavel again, as he does. Let's see. I don't know how this case got assigned to Judge Graff. I don't know if it was just a rotation. He was the next one up. But I think he has the right demeanor for this case. I'll give you that. That he's calm, cool, and collected and doesn't get riled up when there are some very passionate arguments being argued in front of him. But just some foundational depth might be a little short. All right. Pamela Marie, love the discussions during break. This is my first time on this channel. Hands down, amazing. Thank you. Pamela, thank you. Appreciate it. We try to keep the conversations, we say pickles, not politics, right? There's plenty of things that will divide us, that we can disagree on. I'm sure if we sat down, Pamela, we could find something we could argue on that you thought one way and I thought a different way. That usually isn't productive. I'm not going to convince you and you're not going to convince me on some of these things. So why waste our time spinning our wheels? Instead, we can find some things we both enjoy, which I think true crime might be one of them, and watch this together and learn and understand together and listen. And, maybe I will change my opinion on something that's, relative to this case, or maybe you will. I think that's a better method to have the conversation. I try to be an example of that. As the host on the channel, and we ask you guys try to do it as well in chat, and our mods will help us out a little bit. Sometimes they have to correct me even. This is a high-profile case. Why the heck didn't they get a way more experienced judge? Crazy to me. I don't necessarily want every high-profile case to go to who's been here the longest. I think rotation is important, but I don't know. I've got questions, and I don't have the answers on these ones. I've liked a lot of the judges' rulings. This is just one that, affects me personally. As member of the media, I feel like I've been slighted on that, and it just doesn't make sense based on what we know from following the law and reading the law. It's chocolate day if somebody needs something good to agree on. Is there a chocolate day? Is there ever a not chocolate day? I've got a Milky Way somewhere that's got my name on it. A little bit of shake on the camera. It looks like things might be happening. People coming back in court, so we are a little delayed. It's 12:31 right now, getting close to lunchtime for us on the East Coast, but they'll have a little bit longer before they have lunch in Utah. Sua Spontaneous, I love the name, by the way. Andrea Burkhart loves this judge. I think he's being just a little extra cautious because it's a death penalty case. We haven't heard it yet said, but
We'll
death
go ahead
is
and pick
different.
up where we
right?
left off. I note that the parties
Death is different.
for each side are present in the courtroom, and we're picking up with cross-examination of Agent Hull. Ms. Nestor, your witness.
May it please the court, thank you. Good afternoon, Agent Hall.
Good
You
morning.
and I have met before, but just to remind you, my name's Kathy Nestor. I'm one of the attorneys representing Mr. Robinson. So, when did you leave the SBI?
The State Bureau of Investigation?
Yes,
March of this year.
March of this year?
Yes.
So you were involved in this investigation from September to March, basically.
Yes.
And your new position at Post, what is your new position?
I'm an investigative sergeant.
So you investigate potential wrongdoing of police officers?
Correct.
Okay. So when you were first brought into this case in September, is it my understanding from your testimony that you were not engaged in any way with this event prior to getting a call after the shooting? Is that correct?
Correct.
Does the SBI on occasion assist other agencies with preparing for big events like this or not? Is that not typically something you do?
Not something that I've ever been involved with, no.
Okay. And what time did you arrive on campus that day?
I believe it was shortly after 1:30.
So approximately an hour after Mr. Kirk had already been removed from the...
Approximately, yes.
Okay. And were you involved in putting up any drones into the air? Were you part of that, or were you not
It's
involved in
not,
that?
no.
So how quickly after you arrived on scene did you become aware that you were actually going to be in charge of the scene?
I believe it was approximately an hour after, so what would have been approximately 2:30.
So for the first 2 hours, you were not in charge?
For the first 2 hours, I wasn't. I didn't arrive till 1:30, so no.
Okay. And once you came from on high that you were basically going to be in charge of the scene, what was your first priority? What were you focused on?
We were focused on, through our major crimes team and our lieutenant, putting together an investigative team and developing initial assignments and a plan as to what we were going to do moving forward.
And part of that is protecting any potential forensic evidence that may be found on the scene. That's clearly important, right?
Correct.
Preserving the scene, right?
Correct.
But it sounds like that's not really your area. That was more maybe Agent Falmina's area.
Agent Falmina was assigned to process and document the crime scenes. It was my understanding that the known scenes at that time, amid the chaos, had been contained and had been secured by the on-campus officers who were already on scene.
And what's your understanding of what the known scenes were? In other words, the area where there might potentially be evidence that you needed to process.
I know that the amphitheater area was cordoned off and managed as best it could with the number of people that were there. I was also made aware that there was a rooftop area that had been secured and also an area off of the side of that building that had been secured by an officer.
And that building was the Losi building.
Correct.
Wasn't there also a bullet found on another building?
I believe an unfired bullet had been found on another building at some point during my time there on September 10th, yes.
Which building was that, sir?
I don't recall.
Was that considered a scene that was worth preserving?
It was not. My recollection is that that was accounted for as an ejected cartridge from an officer who had cycled his rifle.
Okay, I thought you said it was an unfired bullet, and now you're saying it was a
correct.
cartridge?
When a weapon is cleared,
Uh-huh.
an officer would make his rifle ready, which would chamber around.
Oh, I got you.
My understanding was that that's how that was accounted for.
So an officer claimed that bullet belonged to him or her?
That's my recollection, is that was how it was accounted for.
And when was that accounted for?
I don't know specifically.
Do you remember what type of bullet that was?
I don't.
Was it a 30-06? Do you remember?
No.
I don't.
It's not going to be 30-06.
Do you know where that bullet is
Maybe
now?
a 233.
I don't.
Okay. So you had the amphitheater area that had to be preserved. And how far out did that stretch? The entire amphitheater or just the area around the tent or what?
My understanding was the entire amphitheater area was cordoned off, and there were attempts to secure the campus itself with a perimeter of officers who were monitoring or preventing people coming and going.
When you arrived on the scene, were you aware that an individual had been taken into custody?
I had heard that, yes.
Did you ever have any interaction with that individual?
I did not.
And were you advised at any point that that person was no longer a person of interest?
Information was passed down that the individual was not considered to be a suspect in the shooting.
And when was that, time-wise?
I don't recall specifically, but I know I was on campus when I had heard.
So whoever arrested him as a potential suspect got that wrong. He wasn't the actual suspect, right?
Sorry, got what wrong?
That he was the shooter.
The person I believe to be the shooter was not the individual who was taken into custody, correct?
And then was there anybody else taken into custody as a person of interest?
There were several people who were detained for questioning and who were interviewed throughout the investigation.
And none of those people were they were all ultimately cleared by you or somebody connected with you?
Correct.
And were there any other guns confiscated on the scene that day?
There were other firearms that were located on the scene, yes.
How many guns were confiscated that day?
I don't know specifically confiscated, but I know that there was a firearm found in a backpack that was accounted for during the day.
What type of firearm was that?
It was a handgun.
Any other guns that were found on the scene?
Not that I recall.
It's legal to carry a concealed weapon on campus
Do you
there.
recall an individual named
There were a lot of guns there.
Noah Gonzalez being interviewed?
I don't recall that name specifically.
Let me see if it refreshes your memory that he was an off-duty, I think maybe trooper that was on the scene that day and that was involved in recovering the holster. Does that refresh your memory?
I know that a trooper was interviewed having been on scene. I don't recall if it was Gonzalez. I don't recall the name, but I do know there was a trooper that was interviewed, yes.
Okay. And just a moment, Your Honor. And do you recall the trooper that was interviewed saying that there was actually a gun found in that holster?
I do not.
You do not?
No.
Okay. Can we pull up? Exhibit Hole 13 and just show it only to the witness for right now? All right, can we go to page 2 of that report? Do you recognize this report? Have you reviewed it as part of your investigation duties?
I do recognize the report now, yes.
Okay, and this is a report prepared by actually Mr. Davis, who's going to testify later in this matter. Is that right?
Correct.
Okay, and on page 2, this is the interview of Noah Gonzalez. Is that right?
That's what it stated on page 1, yes.
And he's an off-duty trooper who happened to be there that day?
Correct.
And do you see on the second paragraph, does that refresh your memory about whether Trooper Gonzalez believed there was a gun found in a holster in that area of the amphitheater?
Trooper Gonzalez included in his report that there was a gun, yes.
Okay. Thank you. When did you first personally go up to the roof of the Losi building? Do you remember the time of that?
I don't recall. I know it was dark when I went up to the roof, so it would have been later that evening.
And at the time you went up there was already crime scene tape that had been placed around it?
There was an officer standing security.
Right. And to your knowledge, as the head of the investigation, did they ever find any bullets or casings anywhere on the Losi roof?
Not to my knowledge, no.
Did they ever find any bullets or casings anywhere around the Losi building?
When you say around the Losi building, you mean how close? Like immediately around the Losi building?
Correct.
Not to my knowledge, no.
Okay. And then you've been talking a lot about a timeline here that seemed, you talked about it when you were watching the video, but you also talked about the fact that you developed a timeline, is that right?
Correct.
And
preliminary
can you pull
hearing.
up hole 1, please? I'm pulling up on your screen your report that you prepared. Do you recognize that?
I do, yes.
And what's the date that you drafted that report?
It looks like September 14th. It says date created.
And that's the place where, if you could go to page 2, please. Do you see down at the bottom where you summarize Sergeant Bricker's report listing the timeline?
Yes.
Okay, and so it was actually Sergeant Bricker that prepared the timeline, is that right?
He prepared a timeline.
And you incorporated that into your report?
No, I created a timeline.
You created your own timeline?
Yes.
Separate from the one that's in this report?
Yes, using information obtained in the investigation.
And when did you create that timeline?
Over the course of the investigation, over a long period of time, after a lot of reviewing video and investigative time.
So, as of September 14th, Tyler Robinson had already turned himself in to the authorities, is that right?
Yes, I believe he turned himself in on September 11th.
So, prior to the time that Tyler Robinson turned himself in, had you all prepared a timeline?
A documented written timeline?
Yes.
Not to my knowledge. I don't know when Sergeant Bricker produced his specifically.
And isn't it fair to say that as of the moment that Tyler Robinson voluntarily surrendered to authorities in Washington County, as of that moment, you all did not know who the shooter was. Is that right?
We had identified a person of interest, but we did not specifically know who the shooter was at that time.
Okay. And you became aware that Mr. Robinson was voluntarily surrendering how? How did you become aware of that?
That information came originally, I believe, from the Washington County Sheriff to the administration at the control center at the university on the evening of the investigation, or the second evening of the investigation.
All right, we're going to get back to that in a minute, but I just wanted to get the timeline down. All right, now I want to go back to the videos that we've seen and the question that I just asked before, which is it fair to say that nothing about the video of the individual on the roof revealed to you, you couldn't see facial features, you couldn't see what they were wearing, correct?
Of the individual on the roof?
Correct.
I know that there was a meeting to discuss perhaps a pattern on the front of the shirt that was observed when the individual was jumping off of the roof.
Okay, that's fair. But at that time, as of the 11th, before Mr. Robinson turned himself in, you all had not been able to determine that, is that right?
Excuse me. Determine who he was, or
No.
determine distinguishing features?
Determine distinguishing features of the video
Yeah.
of the person on the roof.
Yes, we had a person of interest, and those images were released to the press.
You're talking about the ones in the stairwell from the...
Correct.
From the parking garage.
Correct.
But the video on the roof was not distinguishable, fair?
That video as a standalone?
Yes.
Was not, no.
Okay. And in fact, the video on the roof, well, strike that. Is it true that you had some spectators that you interviewed that had gotten a photograph a few seconds before the shooting of someone on the roof?
Sorry, I'm not sure I understand the question.
Did you, at some point in your investigation, collect from two young men who were present at the event a video that they had taken of someone on the roof about 10 seconds before the shooting?
Yes, a video, yes, not photographs. A video was collected from an individual who had a video.
And ultimately, some screenshots were taken out of that video, is that right?
By
you?
Not by me, no.
Okay. That's fine. It could have been someone else.
Okay.
But did you see the video that those young men took?
If you're referring to the video that is looking north and shows an individual dressed in dark clothing on the corner of the roof,
Yes.
if that is the video, I have seen that video, yes.
Did you review the interview of those young men?
I did not.
Do you know how they described the person on the roof?
I don't know if I read it or if I heard it, but my understanding was they believed it was Overwatch or some kind of a police Overwatch for the event,
Okay.
if that's my recollection.
And do you remember anything specific about the person's build that they discussed when they described the person on the roof?
I do not know.
Okay. There is a portion of the video after the individual jumped off the roof, which we all saw here, where the individual crosses, I believe it's Campus Drive. Is that right?
Correct.
And there's a moment where the individual waits and there's two cars that pass in front of him, right in front of him.
Correct.
And is this the moment where you are submitting that he was holding a gun in his hand?
As he crossed the road?
Yes.
From my observations, would show that he's carrying an object in his hand that's concealed or in a bag, and it is long and has the appearance, based on my training and experience, it could be a firearm.
But do you see a gun anywhere? The actual gun?
In the video?
Yeah.
No.
All right. And did anybody that was driving by on Campus Drive that day report to you or any other investigative entity, hey, we just drove by a guy with a gun who was leaving campus and he was standing right by my car?
We did not receive any reports to that effect, no.
Okay. Also, when you were revealing the timeline, exactly how long was there between when the person was prone on the roof and when the shot was taken? Do you recall?
If you would like to replay the video, I can time it for you, but I don't recall. It was my guess, I would estimate between 15 and 30 seconds.
So between 15 and 30 seconds to lay flat, take a shot, and get up and run off, right?
I think you asked how long he was prone.
Right.
I think it took longer for him to crawl into position.
Okay.
And then establish a position,
Oh.
and then take the shot. He appeared to be in prone for approximately 15 to 30 seconds, but the video would verify that.
Okay, thank you. All right. I want to talk to you for just a minute about the video that was taken. And I'm not going to get into I'm not going to show it, just so that in case anybody's concerned about leaving the courtroom, I'm not going to show it. But there was a video that was taken by Mr. Ty Phillips from behind the individual that was speaking to Mr. Kirk.
Correct.
And it showed like a dead-on view of Mr. Kirk and his parts of his security team. Is that right?
Phrasing, Miss Nestor, come on.
And then you also have video that you described that shows the back of the tent at the moment the shot happened. Is that right? Behind Mr. Kirk.
You're referring to the UVU video in the breezeway?
Yes.
We have that video, yes.
Okay. And can we pull up the last video, the last clip, 49? I want to show you, just you, this clip. That is a little clip from that video under the breezeway that's behind the tent, right?
Correct.
And just to be clear, this area behind the tent would not have been visible to anybody that was on the Losi building. Is that fair?
I can't answer that question.
Looks like an objection.
Yeah, sure.
The camera panned up because they were shown on all the monitors.
And Ms. Nestor, as you're playing this, are you just being cognizant if the sound is on or not?
I don't want the sound. Please.
Okay, I just wanted
not-
to
Thank you for bringing
clarify.
that. Thank you.
All right.
No sound. I just want only the witness to look at it. So can you just watch this clip for just a minute? This one little clip of behind the breezeway at the time of the shot.
That's fine. And so just as a reminder to all the parties, if it's on your monitor, please be cognizant of that. It will not be displayed on the main monitor. Ms. Nestor, you may proceed.
Thank you. Is it playing? Okay. Do you remember that? Does that refresh your memory of what's in that clip?
Yes.
And having reviewed that, at the time the shot was fired, there was no one standing directly behind the tent. Is that correct?
You'd have to show me it again. I wasn't specifically looking for that.
Okay.
But I can answer that question if I can view the video again.
Okay. And just before you do that, I think you testified before that Mr. Kirk would have been dead center behind that banner. Is that right?
Approximately.
Okay, so what I'm asking is if anyone behind that banner, dead center behind Mr. Kirk, if there was any people standing there.
She likes that word.
Go ahead.
I think she's doing it on purpose.
So there's a videographer on the right side of the tent, and then I can only see as far as the video allows me to, so I can't speak to whether there's anybody out of frame who could have been behind the tent.
But what you can see, is there anyone directly behind the middle of the tent?
Yes, there's a videographer stood behind the tent.
To the right?
Yes, behind the tent.
Correct. But directly in the middle of the tent, is there anyone standing?
There's no one stood in the middle behind the tent, no.
Thank you. All right, I want to talk now about the TP. You can take it down off of the screen. Thank you. I want to talk now about the TPUSA video that you got. That was the angle that was taken from behind Mr. Kirk while he was talking, looking out at the audience during when the shot was fired. Do you remember that video?
The visual impulse videos?
Yes.
Yes.
All right. Is it true that Visual Impulse provided 4 videos?
Yeah, I believe there were 4 total videos that encompassed everything that they provided to us, yes.
But the one that you showed, that's only one of the 4 that they provided to you?
That one that was shown had a Bates number. It was an item that was provided by Utah County Attorney's Office.
Okay, but were there more that you haven't seen in this courtroom, in this prelim, that you got from?
There's the original footage.
Okay. But were there other angles that are not shown here in this prelim?
Yes.
Okay, that's what I was trying to get to. Thank you. All right.
I just posted on Twitter the
Were
corrected
you
security camera
involved
footage.
when the gun was located in the forest area?
Wow.
I was not
Right in
involved
front
in
of the
the search for the gun, no.
Did you get notice when it was located?
Down in front.
From the footage that we reviewed, we identified an area that we believed could be potentially of evidentiary value, and then it was secured, and then I was notified that as a result of that search, a gun had been located, yes.
Were you involved in the processing of that gun? In other words,
I was not.
boxing it, shipping it, sending it wherever it was going to go to be
I
analyzed?
was not, no.
Okay, thank you. All right, now I want to shift to the autopsy for just a moment. You were not present at the autopsy, is that right?
I was not.
Okay. So anything you know about the autopsy was not from personal observation?
No, other than from my meeting with the medical examiner and his report, no, I was not present.
Did you meet with the medical examiner after he had conducted the autopsy?
I did, yes.
And when you met with him, did you provide him information about what you all had learned in your investigation so far?
We didn't have any reason to provide any investigative information to him. The purpose of the meeting was to establish what information he could provide to us.
Well, in fact, on the front page of the medical examiner's report, he talks about the investigation and information he learned. Did he learn that from you, or did he learn it from someone else?
It would be my recollection that he did not learn that from us, but I couldn't speak to how he did learn about it.
Okay. So you didn't share with him your conclusions about what happened or how Mr. Kirk was injured or anything like that?
That's my recollection.
Okay, thank you. And isn't it also true that fingerprints that were taken from Mr. Kirk and autopsy photos were provided to you on a CD?
Yes.
Was there anything else provided to you from the autopsy other than that?
Other than the CD and the report?
Yes.
Not to me, no.
You did mention not to you. Were you aware of anything else from the autopsy going to anyone else?
I believe standard practice is anything of evidentiary value that the medical examiner collects is transferred through a chain of custody.
And are you aware of anything that was transferred after Mr. Kirk's autopsy?
I'm aware that there were items transferred for evidence, yes.
What items?
I believe some fragments of a bullet casing. I know Mr. Kirk's personal items to be returned to the family. That's all I can recall off the top of my head.
Do you know how many fragments from the bullets?
I don't.
Now, I'd like to talk a little bit about the Ring camera that you obtained, and you interviewed a woman named Ms. Noble, is that right? To get that Ring camera that we watched with the car on the outside?
We interviewed her to verify the authenticity of the video, yes.
And were you involved in that interview?
With Miss Noble,
Mhm.
yes.
And do you recall what they told you about what they remember seeing in and around that car that night?
I don't recall. I just know we were there to verify the video. I didn't conduct an interview with Miss Noble at that time.
Okay. Can we please bring up whole... Sorry, just a moment.
At the next break, I'll show you the enhanced video. If you don't have Twitter, I'll pull up what I just
Whole
posted over there.
48?
I didn't do any zooming. I just reframed it so it doesn't look like you're looking from the side of the room. I made it so you're looking straight on. I resized the picture for that so you can see it a little clearer.
All right, do you remember that, looking at that interview? Does that refresh your recollection?
I remember reading the report at some point, yes.
And do you remember that the Nobles told you that the driver of the vehicle was bald?
I do remember that being in the report, yes.
And you didn't mention that today when you were talking about that Ring camera, did you?
I did not.
And did they also tell you there were 3 other people in the car?
Yes, I believe they thought that was the case.
I want to go back, if I can, to the scene itself, the preservation of the actual scene where Mr. Kirk passed. Did you all have canine dogs at any point that sniffed that area?
I don't know specifically that area, but I do know that canines were present, or a canine was present on the day.
But you don't know what task the canine was given?
My understanding was that it may have been used in an effort to track an individual that had jumped off the roof, but I don't know for certain.
And obviously that didn't produce any results, or we would have heard about that, right?
Yeah, not that I was made aware of.
Okay.
Is canine dog redundant?
Do you know when the tent and the stuff was actually removed from the scene?
I don't. I would imagine it had been at least a couple of days, if not longer than that, before anything was removed from the scene.
You didn't have to give permission to remove the tent?
Me, personally?
Right.
No.
So you're not sure when it was removed?
No.
And were you involved in the decision to pave over the dirt that was under the tent?
At UVU?
Uh-huh.
No.
Did you know that happened?
Only because it was in the news.
All right. But you don't know when or who ordered that?
Nope.
And it's true that during the time before Mr. Robinson turned himself in, you all received lots and lots of tips from the public. Is that fair?
Correct.
You received tips of death threats that Mr. Kirk had received before, the day before the shooting. Is that right?
I'm sorry, did we receive threats that Mr. Kirk had received before the event, or?
Let me clarify. That
Thank
was
you.
a confusing question. As you were going through tips that the public was giving you, did you receive tips about online death threats that had been made against Mr. Kirk prior to his death?
There was a huge variety of tips and information and suggestions that were being provided by the public.
Okay, and a lot of those, some of those filtered through you, right?
Some of them filtered their way down to us, but predominantly that was being handled by our State Information and Analysis Center that had been set up.
And you also got multiple tips about potential suspects, people who thought they recognized people in the picture, right?
Yes, there were different calls and information provided by the public.
And you had quite a few of those.
Correct.
And then Mr. Robinson turned himself in, right?
Yes.
And is it your understanding that the individual they used to facilitate Mr. Robinson turning himself in was someone known to Mr. Robinson personally that had been connected to law enforcement?
I know he was known to the family. I don't know his connection specifically with Mr. Robinson, but I am aware that someone was used to facilitate Mr. Robinson turning himself in.
And were you aware that he was one of his Boy Scout leaders? Did you know that?
I think I had heard that at some point. There was a connection. I didn't recall specifically what it was.
And Mr. Robinson, in fact, no police went to go arrest him. He drove himself, or he was driven with his parents to the Washington County Sheriff's Department, correct?
That's my understanding, yes.
And he voluntarily walked in.
That's also my understanding, yes.
And that was the first moment you ever knew his name connected with this case.
Yeah, aside from the image that we had, that was the first time that we had a name of an individual who had taken responsibility, yes.
And did you personally ever meet with Mr. Robinson?
I did not.
And as far as you know, Mr. Robinson did what he said he was going to do. He told the police he was coming peacefully, he was coming with his parents, and that's exactly what happened.
I don't know any of the specifics of how he was arranged to turn himself in terms of what you've described. I just know that it was being facilitated with the sheriff's office.
Okay. Court's indulgence for just a moment, Your Honor.
Yes.
Might be done with the second witness unless there's some more redirect. Can't believe we're only 2 witnesses deep in this. Looks like we've got a strategic coffer in court.
Thank you, Agent Hall. I tender the witness, Your Honor.
Thank you. Redirect by the state.
Going to go back to a few things that Ms. Nestor asked you about. First of all, the unfired bullet that you referred to. It's your understanding that that bullet was accounted for?
That's my recollection, yes.
Okay, and it possibly belonged to an officer that could have maybe been clearing his weapon.
Yes, that's what I recall being told about that particular item, yes.
Are you aware of if on the 10th there were police officers present that were actually securing buildings and securing rooms there at UVU?
I know prior to my arrival, it was a dynamic and active scene that I believe was originally being treated that there was an active shooter on campus. Mm-hmm. So there was a large, rapid response of law enforcement who were actively trying to clear, secure, and ensure that the campus was safe. If that answers the question.
The entire campus?
Yes, correct.
Okay. And what types of officers were there clearing the campus?
Originally, there would have been probably local units who would have responded, but subsequently specialty teams would have been deployed to do a more methodical search of the campus and what we would call a clearing of the campus.
And those specialty teams and any other officers, how were they equipped? Like what type of equipment were they carrying?
I believe most officers carry a sidearm, a handgun, and most officers in this day and age are equipped with a rifle platform as well.
Okay. When you said that it was possible that round was from an officer clearing his weapon. What exactly do you mean by that?
Our standard practice in our department is to carry a rifle cruiser ready, which
I'm sorry?
we carry our rifles in a situation which is called cruiser ready.
What does that mean?
It means we don't have a round chambered. So if an officer deployed with his rifle, he would chamber a round. Once he had done whatever task it was that he was doing in order to put that weapon back, he would eject the magazine and eject the round. Sometimes in doing so, rounds are dropped or not accounted for.
Okay. Have you personally done that yourself?
We do that at training, and I've done that in the field as well, yes.
Okay. And you're aware of, is that something that's common among police officers in this situation?
I believe for most agencies, that's how they carry their weapons, but I can't speak specifically to agencies outside my own.
Do you have any idea how many officers were dedicated or sent out to clear the campus?
I can tell you I had to park on University Avenue and walk all the way onto campus between hundreds of police cars, so I would say hundreds, if not 1,000 officers, high hundreds would have responded to the campus that day.
Now I'm going to ask you about, Ms. Nestor asked you about your observation of seeing Mr. Robinson with something in his hand. And I think she was asking you about Mr. Robinson just prior to crossing Campus Drive, following the shooting. Do you remember that question?
Yes, I think I was asked whether he had a gun or I had seen a gun in his hand in the video.
And you said that you did see something in his hand?
Correct.
Okay, I want you to go back as far as you can remember. At what point, after Mr. Robinson stood up on top of the Losi building and ran across, I believe to the northeast corner, when did you first notice in that video something in his hand?
The first time you can clearly notice he has something in his hand, without a doubt, is when he's on the white triangular portion on the northeast corner of the Losi building preparing to jump. It is very apparent he has an item in his hand.
Okay, and that's based on your observation of the videos?
Correct.
Okay. And is it easier to see in that enhanced video?
The zoomed version of the video makes it a lot clearer to see, yes.
Okay. And then
We didn't get to see
after
that.
he drops down off of the roof of the Losi building, is there any time between that point in time and making his way to Campus Drive that you believe you see, again, something in his hand?
As Mr. Robinson lands on the grass, it's almost like he either drops it or goes into a crouched position, and then when he returns up from that, it is again clear that there is some kind of an item in his hand, yes.
Okay. Can you be more specific or describe in more detail
It
what
appears
that item might
it
be?
appears to be black, and it appears to be longer.
Okay, anything else about that item?
No.
Okay. I believe it was Exhibit 9.
Somebody's
State's
tummy
Exhibit 9
rumbled.
that Ms. Nestor pulled up on the screen, and she had you look at that. And I believe what you looked at was beginning a still image, but then a few moments or a few seconds of that video. And that's the UVU tunnel video, is that right?
The breezeway underneath the Hall of Flags, yes.
And the view is from behind, where I believe you testified that Mr. Kirk was on the other side of what appears to be a banner.
Sure.
In that tunnel view.
Yes.
And on the other side of that banner is the tent and then the rest of the courtyard. Is that fair to
Correct.
say? Do you remember seeing the banner
Yes.
in the video? Okay. And
You're referring to the back of the pop-up tent?
correct, yes.
Okay, yes.
Okay. And do you remember, what do you remember about that banner?
It has some kind of an emblem on it, and it forms the back portion of the pop-up tent.
Is it opaque? Is it transparent? How would
No, you
describe
can't see through it. It's white,
Right.
and you cannot see through it, no.
it? And how much of the tunnel does that banner, I guess if it's opaque, obstruct?
I couldn't say. I'm assuming it's a 20 by 20 gazebo, so it would block out the area of the back of the tent that you can see. You would not be able to see through it. You would not be able to see through it from the audience side of the amphitheater.
And what about the tunnel side of that banner? Can you see through the tunnel side in the opposite direction?
You cannot, no.
Can you see Mr. Kirk on the other side of that banner?
You can't, no.
Okay. Well, we exhibited, or Ms. Nestor had you watch just, I believe, just a brief few seconds of that video. That exhibit is actually much longer than what we just looked at, or what Ms. Nestor had you look at. Is that right?
Correct.
Okay. And leading up, and again, I'm referring to that view, that tunnel view of that surveillance camera, leading up to the shot, what's going on behind that banner?
There are representatives, I believe, of TPUSA, but there are representatives of TPUSA, there are law enforcement representatives. I don't know if there's any student body, but essentially people are moving to and fro behind that area. A couple of individuals are retrieving items from a vehicle, but there's consistent movement behind and in that area.
Okay. Directly behind the banner?
Correct.
Ms. Nestor asked you about the wooded area that Mr. Robinson entered. Well, Ms. Nestor brought that up, and I believe your testimony has been, between today and yesterday, that you witnessed Mr. Robinson enter a wooded area on at least 2 occasions. Is that fair to say?
Yes, on his second visit to the campus and on the visit where the incident took place.
At least on those 2 occasions, did the wooded area that he entered, were they different parts of the wooded area, or was it the same parts of the...
They appeared to be the same.
You're aware that a rifle was eventually discovered?
Yes.
And was it your understanding that that rifle was discovered in a wooded area?
It was in the wooded area where we believe Mr. Robinson entered the wooded area, yes.
And that rifle was discovered on the 10th?
Yes.
Ms. Nestor asked you about a variety of tips including threats to Mr. Kirk, I think before the event?
Yes.
And did you follow up on those tips?
After tips have been put through a process and been analyzed and screened, anything that appeared to have relevance to either the investigation or a credible threat was managed by the various entities involved, yes.
Okay. So managed by law enforcement, so...
Correct.
Did you personally follow up on any of the tips?
I don't think I personally did, but I worked closely with people who did.
The point is, I guess, is that those tips were followed up on. Is that fair to say?
To the best of our ability, yes.
Okay. And then Ms. Nestor also asked you about tips, I believe, of people reporting to police that they felt like they knew who the shooter was.
Yes.
Okay, so identities of possible shooters.
Correct.
Did law enforcement follow up on those tips as well?
They did.
Ms. Nestor, finally, Ms. Nestor asked you, she asked you whether Mr. Robinson voluntarily went to the sheriff's office down in southern Utah. Is that right?
Yes.
Okay. And that was a Washington County Sheriff's Office?
Yes.
Okay. You understood that he turned him, well, he showed up there voluntarily. Is that right?
Correct.
What was your understanding as to why he was showing up there voluntarily?
He had informed, I believe, his immediate family that he had been involved in the shooting and that he wanted to turn himself in.
Okay. Nothing further.
No objection, because that's a hearsay statement by the defendant, out of court statement against interest. Can't object to that.
In the video that we've already talked about, the video where Mr. Robinson stands up and runs across the top of the Losi building, do you notice whether at that point, after he stood up until you see him last, at least in that part of the video, do you notice whether he's walking or running with a limp?
He is not from the time he left after going over the railing. When we see him on the video move out to the position.
Correct.
And then leave the position, there is no longer a visible limp or gait.
Thank you.
Ms. Nestor.
No follow-up, Your Honor.
All right. May Agent Hull be excused?
Yes, Your Honor.
All right, Agent Hull, thank you.
Thank you, Your Honor.
So we need the timeline.
All right, let's take a 5-minute break and allowing parties to confer. Court is in a brief recess.
We need the timeline. Did the limp start because he jumped off the roof and hurt his foot? I thought that was, I don't know. Didn't have a rifle barrel down his pants. Like, I don't see it. Maybe he was hurt. Okay, well, we've got a little break. I'm going to take you over to a video I just posted on Twitter earlier today. In court, the prosecution showed a video, a compilation of the security camera footage that was put together from UVU. This is, let's see, let me take you right over here. Let's go full screen. Okay. We're going to go to 3 really quickly. So can you guys see this? Take the objection counter off. We're going to back it up. This is going to be the security camera footage that I've corrected. Sorry, let me back up a little further. Okay. So we can show you how this looks with Tyler Robinson's Challenger, Dodge, what it was, a Charger? That car with the distinctive wheels. We've just corrected the angle. That's all we've done. I'll take my face off the screen too so you can see it all without me. There's audio here if you want to hear it. They're talking in court.
And Department of Motor Vehicle Records, the vehicle fits the description of a vehicle owned by Mr. Robinson.
We'll keep that going quietly.
Is there anything unique about that vehicle that stands out to you?
The shape of the vehicle is very distinct, but predominantly the wheels.
It's about a 10-minute
are very
video
distinctive
here.
On this version of the vehicle.
Now what do we see?
So he parks. Now Twitter doesn't
The
want to
driver
play
of the
nicely.
vehicle exits the vehicle and then walks on foot to exit the parking garage.
This is when he
That's
shows
the
up and gets
individual in
Chick-fil-A.
The red T-shirt, shorts, and shoes.
Twitter doesn't like playing
Do
this
you believe
video.
you recognize who that person is?
Yes.
Who is that?
I believe that's Tyler Robinson.
All right, and where does he go from there?
He heads out of the parking garage on foot into the campus.
Wearing those
and actually goes to the quad
Converse
area of the
shoes.
campus. At that time, he makes contact with some representatives from TPUSA.
By quad area?
Sorry, the amphitheater is what I previously referred it to.
So he goes up on campus, visits the amphitheater area, the courtyard or quad.
Correct.
And then what do we see here now?
He returns on foot back to the same vehicle.
He may have actually got information about where Charlie would be set up.
About 9:25 a.m.
It's a Challenger. Charger's the 4-door. Yeah, made contact with TP Turning Point USA, which is the organization that Charlie Kirk was part of, was founder of, leader of, I guess. So it sounds like he went there and found out, asked where's he going to be.
Where's this parking structure located on campus?
It's just off of Campus Drive. It's a short walk from the amphitheater.
We're still in break in main court. We'll jump back there. We've got the audio live. So as soon as they come back.
That's the vehicle exiting with Mr. Robinson driving the vehicle.
Now what do we see?
This is Mr. Robinson returning to the campus on foot from the neighborhood to the northeast. You can see he's wearing the same clothing as in the previous video. And he's carrying a blue backpack.
Describe the clothing.
It's a maroon colored t-shirt with gray or olive colored shorts and then Converse shoes.
And what time did he return to campus?
Just after 10 a.m.
And does he leave the parking structure eventually?
He does, yes.
Okay. And during this visit, do you know where he goes after he leaves the parking structure?
Yes, we were able to track his movements on campus. He went to Chick-fil-A in the Sorensen building.
Yeah, so they're going to talk for a
purchased
minute.
some food, sat and ate the food. Then, I'm sorry.
Where did he purchase the food from?
Chick-fil-A.
Chick-fil-A. I'm going to fast forward a little bit because it takes a minute for him to.
And
There we go. Okay. Now they talk for like 5 minutes. So now he develops a limp.
And why, well, let me ask you this. You believe this is Mr. Robinson returning to campus?
I do, yes.
Okay. And why do you believe it's Mr. Robinson?
The shoes are the same, and the images that we have are from my viewing and seeing Mr. Robinson on the video, it's the same person.
He texted somebody as well. I'm sure we'll
He's
get that.
noticeably wearing different clothing.
He is wearing different clothing, and he also is walking with a gait or a limp in this video.
With a gait or what?
A limp.
Okay.
Peeks around at the camera. Is there a camera? Yep, there it is.
Now what do we see?
This is Mr. Robinson coming up the stairs of the parking structure. Again, he seems to be having issues walking.
Maybe he was just trying to pretend to be somebody other than the other person that he just saw on camera. Look at this. He walks with his heel like way down and the toes up.
And again, were you able to track Mr. Robinson when he leaves this parking structure?
Yes, we were able to.
Okay. So when he leaves the parking structure, where does he go?
He comes up around Campus Drive, as you can see on the video here. There is a cut through there north of the Losi building, and that's Mr. Robinson coming up the sidewalk. He has the noticeable gait or limp in his walk. And then he moves south across the front of the Losi building.
On the sidewalk?
Yes, correct.
Okay.
So he's the
He
guy
would
in
be
bad.
the rear of the two individuals in this particular video.
So right now, if you were to break this picture into quadrants, where would he be?
I would be in the top left quadrant, walking to the left of the image.
Now what do we see?
This is an image looking across the parking lot to the Losi building, and Mr. Robinson is appearing on the exterior staircase, which gives access to the Losi building
It's
roof
right by
and the area where the railing is.
CS in the words at the top of the
And
right
again, let's break
screen.
that image into
It's going right
quadrants.
underneath the letters.
Where would he be located if you broke it into quadrants?
It's in the top right, and the individual can be seen moving under the notations that are on the video.
Okay. And what time is this?
It's just afternoon, about 12:15
On what day?
on September 10th, 2025.
What just happened, or what did we just see happen?
The individual actually kind of rolls over the railing onto the roof of the Losi building.
Sort of running across the roof there on the left.
And again, in the top left corner, the individual is now seen running across the rooftop of the Losi building to what would be the southwest corner of the building, crouching down and then crawling to the corner of the building.
No, he's only there for about 15
And
to
this
30
is at what time?
seconds. This is 12:22:35.
Around 12:23. I think the timestamp on the video is 12:22.
On the 10th.
On September 10th, yes,
So
2025.
we're clear, this is the roof of the Losi building.
Correct.
I'd be watching other people if there are any
Can you still see that
pedestrians.
individual?
Watch for
Yes,
a
you can,
reaction
lane
to a
prone.
gunshot.
You believe this to be Mr. Robinson?
I'm sorry?
You believe this to be Mr. Robinson?
I do, yes.
And how long is he out there on the edge of the building?
Now somebody starts running.
Just until the reported shot was fired at 12:23 and 28. The individual then stands up and then moves across the building to the north.
Is that what we're seeing happening right now?
It is, yes. They moved behind the atrium area on the rooftop.
He's going to go to
the
the little
northeast
white
corner where the
triangle,
white triangle is.
Middle center of your roof. Little dots running across the screen.
You
He's
see
tiny.
Mr. Robinson now?
I do, yes. He's just arriving at the corner of the building. Almost the top center of the image.
Still waiting for court to come back from break.
What are we seeing now?
And Mr. Robinson lowering and jumping off of the roof of the Losi building onto the grass area, and then moving away towards Campus Drive. And he appears to be carrying some kind of an object in his hand at this time.
So he's approaching,
Campus Drive.
and again, broken into quadrants. Where is he currently?
Be in the top right quadrant.
And the time?
It's 12:24 and 42 on the timestamp.
What do we see now?
He then crosses Campus Drive and drops down into the wooded area on the far side of Campus Drive.
And that is located in what part of the video? What quadrant?
It would have been just off center on the top left side.
What do we see now?
This is when he comes
This
back.
is the intersection of Campus
try to
Drive
get
and
the
800
gun.
South. There's a vehicle attempting to turn right onto Campus Drive. That's the vehicle that's driven by Mr. Robinson.
And on the screen, where is that vehicle that you're referring to located, if you broke it into quadrants?
It's on the left side, on the upper side, the upper quadrant.
Now what do we see?
That vehicle's now pulling away and heading east on 800 South.
And why do you believe that that vehicle is Mr. Robinson's vehicle?
When that vehicle was stopped, it actually made contact with an officer who was doing security detail.
All right, so that's the video. We corrected it so you could see it without being distorted like you're looking from the side of the room. All right, we are back. We're about to come back from court. Give me just 1 second here. Let's get rid of that blue. We use the replay machine to do that, actually. Fun fact. Let's go back. We need our counter. We're only up to 58. 58 objections. That whole clip is available on X if you need it. It's out there. So imagine we could probably zoom in, but the quality of filming a TV, you lose a lot. So it would be terrible. It would literally be Minecraft video if we zoomed in. I'm hoping that that one day, maybe after this hearing, or maybe, well, probably during the real trial, we'll get to see the actual footage that was zoomed in. Thanks for the kind words, Shannon. It's fun. The technology is fun. DaVinci Resolve has all the tools to do that. Meanie Banana member for 35 months on the jury. Oh, gee. Good luck getting a jury who hasn't seen the video of the shooting. I don't get this judge throwing out all the video. Yeah, he hasn't thrown out video. I don't think there's any video now that he hasn't allowed in, with the exception of some of the compilation with the red circles and the zooms. Some of that didn't come in, but well, no, all that came in. We just didn't get to see it. We only got to see a part of it. We've seen those videos. They've been on the news. They have been leaked or released, depending on how you view it. Just a couple minutes here, and we're expecting to come back. If you haven't seen video of the shooting, I realize there are some people who want to see it and want to analyze it and say, I need to see it from my own eyes to understand what happened. If you're not that type, I'd recommend you probably don't seek it out. because it's not something you can unsee. It sticks with you, and it doesn't leave you with a good feeling. So, if you manage to escape it thus far, I'd continue escaping it. Count yourself fortunate. It's tough to watch, extremely tough. All right, we're just waiting on the judge now and the court to come back in session. Oh, what's therapist you know? Awesome. When we come back, we'll have a next witness on the stand. I forget how many witnesses the prosecution said they were going to have. They had a handful of expert witnesses as well as some police officer, and I thought a couple lay witnesses, if I remember correctly. It's a very long 5 minutes. Maybe the judge is rethinking his decision. I hope he got a phone a friend moment from maybe a chief judge who said, you might want to not do what you just did. It said 4 just yesterday, but I'm not sure if that was a full list or if it was 4 police officers, or we'll see. It's going to be about 40 exhibits, and we're up to, 12.4 right now was the last one, 12.6, 12.8. This is the longest 5-minute break of my life. I think he's digging through case law. The 4 was supposed to be just for yesterday. Well, that didn't happen. I'm glad the prosecution got up this morning and made sort of like the suggestion to the judge, which we were hoping the judge would do, which would be inform Ms. Nestor that he has heard the objection. There is a stand-in objection. It is on the record, and it does stand for the duration of the hearing. That has sped up a lot, but we really haven't had too many exhibits since then. So we're still going to get objections to the exhibits the state wants to produce going forward. Silly Rabbit, welcome. Mostly I lurk because I watch on TV. I love it here. Thank you very much for the generous support. Laura, I turned them off. You guys made sound effects during court. I turned them off for a little bit. When you're good, I'll turn them back on. You're being punished collectively. When did it happen? I didn't go look for it. They aired it on TV. I was shocked to say when it happened. Yeah, it was a lot to see when it was everywhere. You can still find it, obviously, on a lot of platforms. Some of them have tried to clean up their historical footage. So there are some social media platforms that have taken down those videos, but there are others that it still gets reposted every day. How the heck is there 58 objections in only 2 days? Well, I can tell you that it wasn't the state. Yeah, that's why I said we're being collectively punished, Laura. It wasn't you. It was we played. We'll have sounds on when it's appropriate times. Lisa Frampton says, I was watching live through someone's live stream who was close to where Tyler was, so the shot was very loud, so he jumped while filming, so I didn't see the details of Charlie being hit. That's fortunate. Natural reaction. If you watched yesterday, the live stream here, we watched the judge possibly watch the video for the
we
first
left
time.
off with
And he jumped.
Agent Hall was excused, and we are proceeding. Mr. McBride.
Yes, Your Honor. We intend to call Jennifer Falmuina, but before I do that, I'd move the admission of State's Exhibit 5.1, if I can approach the bench.
Yes. Thank you.
Your Honor, there will be an objection, and we want to be heard on the objections. And I didn't know this was coming now. It could be a lengthy call.
All right. Let me just
buckle up, they say.
Do you wish to identify what State's Exhibit 5.1 is?
Yes, Your Honor. Exhibit 5.1 is a self-authenticating 1102 statement issued by David Englehart from Turning Point USA.
Self-authenticating.
All right.
And again, I say it's a self-authenticating document. As you can see there, it's got the admonition on page 1. The body of the 1102 statement is there on pages 1 and 2. I would say number 4 is kind of the foundational statement, paragraph 4, but the self-authentication portion is the notary acknowledgement on page 3.
All right. Turning to Mr. Novak.
Thank you, Your Honor. Thank you, Mr. McBride. So the court, obviously, because the court can decide how much of this we discuss in open court, how much we discuss at the bar, so to speak, sidebar. There's initially a fundamental relevance problem with this 1102. There are other issues, but I think that just to help the court parse the evidentiary issues, we should start with the relevance.
Why don't you throw everything at the wall and let's see what you got.
There are sub-issues. There's also a problem under 1102 because if the court looks at the last paragraph of this, Mr. Engelhardt, who is the purported author, refers to himself in the third person, so it's not clear to me who actually wrote this report. And as Your Honor knows, 1102 says that prosecutors are not to assist witnesses in writing their own 1102 reports.
So foundation.
That's not my primary concern, although I think it is an important issue because that's what the rules require. But the real question is relevance. And I guess the question is, does the court want me to do the speaking objection? Because the court said no speaking objections. Should we approach sidebar? How does the court want to handle it? The people can move their exhibits into evidence whenever they wish. I wasn't aware we were going to do it at this moment. I'm ready to proceed, but the question is how the court wants to handle these objections. I'm prepared to keep going in open court, but it's what the court referred to as a speaking objection.
No, I appreciate that. As it relates to, well, so here's my question for you, Mr. Novak. As you're, and again, I appreciate your discretion in highlighting that point. Do you anticipate your argument being of the nature that would
be sensitive,
defeat the purpose of, if the court does not admit this, that you've already let the cat out of the bag with your argument, or do you feel that you can make your argument without compromising what is in the 1102, so the purpose of if excluding it is still preserved?
I'll go as far as I think we can go, and then we'll just see. I mean, I do think I am not trying to conceal from anybody in the courtroom or the public our concerns about relevance. So why don't I, taking the court's lead, go forward publicly with my concerns about relevance, and if we reach a moment where it feels like further argument may deprive Mr. Robinson of his fair trial rights, we can approach.
All right, we'll proceed.
Okay, so then what I'm going to do is I'm going to point out that this proposed exhibit, which is the 1102 statement of Mr. Engelhardt, is basically 4 paragraphs. The 4th paragraph identifies Mr. Engelhardt, although I say in the third person, as a pastor and as an attorney who was a friend and a counselor to Mr. Kirk and was involved in leadership of Turning Point USA. So that identifies who the author is. Beyond that, it's not really relevant to any of the issues before this court. Paragraphs 1, 2, and 3, paragraph 1 talks about Turning Point USA's status with the Internal Revenue Service, the purposes of Turning Point USA, within the context of the Internal Revenue Code, and sort of what I'll just refer to generically as the goals and objectives of Turning Point USA. And it also then talks in the second paragraph about Mr. Kirk's relationship with TPUSA. None of this is unknown information, that he was a founder, that he was the chief executive officer, that he was the president of the board until his death. So I'm still not sure what the relevance is, and I guess actually what I should say is I don't believe there is any relevance of any of this information. Paragraphs 2 and 3 are, and actually I'm going to preface this. My discussion of this is within the context of the rules of evidence, and there's nothing that I'm going to say here that is meant to derogate, criticize, question Mr. Englehart's beliefs. What he says were Mr. Kirk's beliefs.
Denigrate, derogate?
What Mr. Englehart says he believes are tenets of Christianity. That's not what we're talking about. What we're talking about is whether this document is admissible in this proceeding under the rules of evidence. Okay. So paragraphs 2 and 3 include not only Mr. Englehart's opinions, and now I'm going from relevance to opinion evidence. It's not clear to me whether it's lay opinion evidence, whether it's expert opinion evidence, but it's Mr. Englehart's opinions about a branch of Christianity, his opinions about a portion of the Bible. He quotes the Bible, and he talks about Mr. Kirk's religious beliefs. And I could go into more detail, but the court has the exhibit in front of it itself. So none of this is relevant. If the court looks at the information, that is the document which lays out the allegations against Mr. Robinson, when I use the word information, I'm talking about the court document. There are, with respect to certain counts, what Utah Code refers to as a victim targeting enhancement. That is alleged with respect to count 1. It is alleged with respect to count 2. It is alleged with respect to count 7. And may I step away just to get my laptop?
You may.
Okay, I think he might have some points here. There's a lot of information here that might be relevant to a murder trial. It might be accurate information, or it might be personal opinion. But
and as the court knows,
how does it enlighten the judge in this case?
But I want the record to be clear. When I refer to the what the information calls the victim targeting enhancement, that's Utah Code Section 76-3-203.14, which the code calls the victim targeting penalty enhancement. The information alleges, and this is, I'm emphasizing this, that Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's belief or perception regarding Mr. Kirk's political expression. And I'm going to focus, if I may, the court's attention on two things. One is, whose state of mind are we talking about? Or whose state of mind is the statute talking about? And what aspect of the victim targeting enhancement is being invoked here?
think that's the general belief that it was,
The
it was
latter
targeted for that
is
reason.
the state invoking Mr. Kirk's political expression, and now I'm quoting the statute, as the personal attribute that the state alleges is the gateway to this penalty enhancement. And if the court will bear with me, because there's a reason why we have these hearings in public, there are various categories for alleging, I should say, there are various categories of personal attributes, that's the phrase the legislature uses, which authorize the pursuit of a penalty enhancement. And those personal attributes are listed in the statute A through R. I'm not going to read all of them because the court knows the law, but political expression is subsection K. That is separate and distinct from the personal attribute that the legislature calls religion, which is subsection M. So what we have is an allegation that the personal attribute, which is one of the elements of this enhancement, the allegation that Mr. Robinson selected Mr. Kirk was based on his political expression. That's actually the exact same phrase, political expression, as is in the statute subsection K.
This is the Victim Targeting Penalty Enhancement Law from 2019.
The 1102 statement is predominantly about what Mr. Engelhardt describes as traditional Orthodox Christian values that he believes in, that he believes Mr. Kirk believed in. And I understand in today's world that there is a crossover between religion and politics. I think we can all acknowledge that. But the legislature and the information here are focused on political expression. So I'm concerned that the 1102 statement of Mr. Engelhardt goes far beyond the scope of what would be admissible if the state has it to prove that Mr. Robinson targeted Mr. Kirk because of Mr. Robinson's belief or perception concerning Mr. Kirk's political expression. The second element of this is that the victim targeting enhancement focuses on the allegation of what is in Mr. Robinson's state of mind, not what is in Mr. Kirk's views or deeply held beliefs, sincere religious beliefs. And so the evidence that the state needs to present is not what Mr. Kirk believed or said or what TPUSA stood for. It's what was in Mr. Robinson's head, if anything, about selecting Mr. Kirk because of Mr. Kirk's political expression, because that's the information. So why TPUSA exists, what its founding beliefs are, what its leaders' beliefs are, what Mr. Engelhardt believes Christianity is or is not relevant. And that's why we think it should not be received into evidence. There's a second level here, which is Mr. Engelhardt's statements about what is in the Bible, specifically Matthew chapter 9. And so I would just ask this court the hypothetical question. If the state asked the court to take judicial notice of a portion of the Bible in order to prove this enhancement.
It does sound absurd, right?
Because I can't see where else it fits into this case. I think, if I may, the answer would be no, it's not relevant. So instead, what we have is the state trying to use the affidavit of Mr. Engelhardt pursuant to 1102 to get the court to essentially receive into evidence the same information. It doesn't really matter here in this proceeding what the book of Matthew says. It doesn't matter what Mr. Engelhardt thinks, and again, I say this with all due respect to Mr. Engelhardt, who I've never met, the book of Matthew means, or how one reconciles the book of Matthew as he sees it with other views on the topics that are there. I mean, I want to be careful and not suggest what other views are, because I shouldn't be testifying about different perspectives within the sort of the heading of religion. But it doesn't really matter for this proceeding what Mr. Engelhardt's views are, what Mr. Kirk's religious views were, what religious views TPUSA endorses, seeks to encourage others to adopt. None of that really matters. There are multiple opinions in this 1102 from Mr. Engelhardt, and it's not clear whether the state has thought about whether it's expert opinion or lay opinion. I happen to think that it's expert opinion that is not helpful to the trier of fact in this proceeding. That's your honor.
He's dancing
There's
around
nothing
something.
in this that helps the court resolve with respect to the victim targeting enhancement, whether Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's beliefs or perceptions regarding Mr. Kirk's political expression. If the state comes back up here and says, no, it's lay opinion, we still have the question of whether it's helpful to this court, because the court has to decide whether there is evidence of the targeting enhancement in the way I think I've structured it. So
he may
it's
have
not
an argument
relevant.
there.
It's not admissible lay opinion. It's not admissible expert opinion. There are two aspects of Rule 403, one of which I'm prepared to talk about publicly, and one of which I think is appropriately discussed at sidebar, because it does get into undue prejudice. The 403 here is that receiving this document into evidence is going to create confusion. It's going to create chaos, not by the trier of fact,
mass hysteria,
but by the future jury pool in this case. For this court to make a ruling that Mr. Engelhardt's opinions about religion, about TPUSA's views on religious matters, that Mr. Kirk's views on religious matters are in any way what this case is about, is going to create significant confusion. And even if this court doesn't show the 1102 in open court, or the reporters who are here don't get to see it, or if the public doesn't get to see it, receiving it into evidence in light of the victim targeting enhancement that the state drafted and charged is just going to create confusion.
I see a little differently.
There
but I can
may
also see his
be,
point.
outside of this case, litigation where TPUSA's purposes and its mission and its adherence to its mission are important, and Mr. Engelhardt's opinions about that may be important in some other context, in litigation, in public discussions. It's not important here. And when I say important, I'm saying it's not relevant. So there's a 403 issue with respect to confusion. There's a constitutional concern that this type of evidence being sanctioned by the court is going to suggest to the jury pool that this is a case about religion. This is not a case about religion. The state doesn't even allege this is a case about religion. The state alleges one enhancement based on Mr. Robinson's perceptions of Mr. Kirk's political expression. So I'm very concerned that this document, even being sanctioned by the court as admissible for any purpose in this proceeding, is going to interfere with Mr. Robinson's constitutional right to a fair trial, which I think is a, sort of an umbrella over parts of Rule 403. If at the time, if there is a trial, if Mr. Robinson is bound over, and if there is a trial, and if the state wants to proffer Mr. Engelhardt for some specific evidentiary purpose that I'm missing, then we can engage in that. But it seems to me that it's, again, a mixture of lay and expert opinion, which at this stage is more prejudicial than probative. The other part of the 403 issue we can discuss at sidebar whenever the court's ready.
Thank you,
I
Mr.
see it a little
Novak.
differently. I think the state needs to
Turning to
prove
the
that there
state.
was something there that could be a targeted enhancement.
Just to give an overview,
But also
what I'm
have to
intending
prove
to do is
Tyler's
address
intent
what
for that reason.
Mr. Novak has presented, the state respond. I may have some questions limited to what's been presented now. Of course, that doesn't preclude addressing the second portion of that in whatever means is necessary to protect constitutional rights. But we're just focused on this portion right now.
Understood.
Thank you. Mr. McBride.
Your Honor, the evidence is relevant to 2 points. One is to the defendant's motive, which is not an element of the offense, but nonetheless is powerful evidence, persuasive evidence. And 2, it is relevant to the victim targeting enhancement, which has been described and appears in the information. The statement clarifies what Turning Point USA, what Charlie Kirk's business was. And I think as you read this statement, it's clear that Charlie Kirk presented both religious and political arguments and positions in his presentations. And that is what paragraph 3 says, that he engaged others in debate, discussion of traditional family values, Orthodox Christian views on sexuality, marriage, gender, sex, America's founding principles, political doctrines, and so forth. He often spoke specifically and attempted to persuade attendees to follow a mindset rooted in Orthodox Christian and politically conservative values.
Excuse me, Your Honor, can I lodge an objection to Mr. McBride reading the exhibit which we are discussing the admissibility of? And I'd ask the court to strike his statements and admonish him.
All right. So as it relates to reading from the actual 1102, because it's not admitted into evidence, I will, well, before I do that, let me turn to you about the objection to make sure that you are heard as well.
Yes. Rule 104 requires the court to consider evidence before determining its admissibility. How can you determine whether an exhibit is admissible without knowing what is contained in that exhibit?
Bingo.
That's what I'm putting in front of Your Honor, is explaining this is why the exhibit is admissible, because it contains this language that is relevant and probative. I don't know how I can make an argument that something's relevant and probative without saying this is what the exhibit says.
Well, Mr. Novak, and I want to make sure I do see you have a microphone. Go ahead.
Oh.
Your Honor is not a jury. Your Honor can look at the exhibit and determine for itself whether it's relevant, whether it meets other criteria for admissibility. It's not necessary for Mr. McBride to read aloud in open court an exhibit which the court has available to it. I'm not saying that the court shouldn't read it. I'm saying that it's not admissible. I understand that the court has two roles, one under 104 and one as the magistrate, but that doesn't require Mr. McBride to read in open court the exhibit which we are discussing the admissibility of, especially where I have just expressed our concern that the exhibit has a tendency to confuse the issues in this case and create fair trial risks for Mr. Robinson.
All right, thank you, Mr. Novak. Any final thoughts before I rule on this specific issue about reading from the 1102 by Mr. McBride?
Yes,
The
Your
state
Honor.
wasn't done.
I have to be able to argue here. I have to be able to refer to the exhibits. I can't do my job as an attorney without being able to refer to the exhibits. If the court doesn't want this to be in public, then we've got to close this proceeding. But I have to be able to argue the exhibits. I don't know how I can make an argument without actually pointing to the language of the exhibits, unless I want to say, you know what I mean, or referring to line 13. It's just so cumbersome to do, Your Honor. And I think my job and my duty to my client, which is the state of Utah, and to their right to fairness, requires me to make a good and powerful argument, and that requires me to refer to the exhibit. And I'll submit it with that.
All right. Thank you to both of you. In looking at this, typically in court, when evidence is being taken, until it's admitted, it doesn't come in. For example, if there's a witness on the stand and one is trying to get a piece of evidence in, that witness cannot read from the document and prior to it being admitted into evidence. And so the court applies that same principle here. However, the difference is, in noting Mr. Novak was drawing points from this specifically, he mentioned Matthew, I believe, chapter 19, and talking about certain points in here specifically. There is room for it to be mentioned in argument in order for the court to fully consider what's before it. I'm going to sustain Mr. Novak's objection and simply say, if you want to talk about it conceptually, talk about the points, you certainly may, but simply reading from it exactly, saying, and I understand, I don't want to constrain either party from being able to make their full argument, but quoting from it in open court, I fear does risk issues to the constitutional rights of the parties. If the parties prefer to go into a closed evidentiary hearing on this issue in order to be unrestrained, and it appears Mr. Novak has requested that for a second portion of his argument, we certainly can do so, because I do not want to put out evidence that is not admitted in open court until the appropriate time, until the court has gone through its decision-making process on whether it should be admitted or not. So to the parties, if you feel you can move forward on this first portion of it, I'm happy to entertain that argument. If the parties feel at this point, at this juncture, that a closed evidentiary hearing is needed in order to fully explore all the issues, I will leave it to the parties, because I don't know your arguments, and I don't want to constrain you from saying, well, I don't know what you're going to say, but
yeah.
I can't read your minds, and the court will stay in its lane to ensure that it's in the proper judicial role. So the objection has been sustained to Mr. McBride. In regards to your response, the rebuttal to the argument by Mr. Novak, what is your request?
Yes, Your Honor. I do not believe it's necessary to close this hearing. I would argue against closing the hearing on the admissibility of this exhibit. However, the court needs to rule on that issue before I launch into the fullness of my argument, because I do not want to be admonished for discussing an item that I'm asking to be admitted into evidence in public. So I would ask the court to make a ruling on the closure of the argument about the admissibility of this hearing so that I can make that argument unconstrained. And after that time, after the court rules on that, I will make my full argument.
You drew a line in the sand.
All right, well, what I'm trying to do is, you've heard the reasoning of the court. I don't want to constrain you. If you're saying, as you stated, that you want to best represent your client, and every attorney should be doing that, that is your duty, I don't want, if you feel that closing this hearing to the public is necessary in order for you to fulfill your duty, the court will entertain that. But I can't have it both ways. If you want me to close the hearing in order for you to be fully, be able to argue freely as you feel you need to, I will entertain that. But I don't want to say, well, I'm not going to close the hearing, and then suddenly the issue is, well, I wasn't able to make a full argument. And so do you need a closed hearing to make a full argument to best represent your client?
I think defense counsel is asking to close the hearing so that the argument can be made without the public seeing it. I do not want to close the hearing. I do not believe it's necessary to close the hearing. That's not my motion. I do, however, want to make a full argument that requires me to rely on the evidence and quote the evidence as I have done. That's my position. If I am not permitted to quote the evidence in my argument, then we need to decide whether or not this hearing should be closed. I would oppose closing it, but I do think it's necessary for me to quote the evidence.
All right. Are you able to make your full argument to the best of your ability to best represent your client by simply referring to the paragraphs and to the lines so it is clear to the court what you're talking about? There's no ambiguity without quoting it verbatim in open court.
If he says no, he's being stubborn. I think he can. It'll be cumbersome.
No, I don't think so.
He's being stubborn.
All right.
Your Honor, if you're going to make a closure
you can't close it.
All right, I'll hear from you.
Here's
as
the
well.
media.
If you would like to
close
come
it because there has
forward,
to be a closing.
again,
A whole hearing has to be held about closing.
For the record, for the clarity
Because the
of
media guy.
Sure, thank you, Your Honor. David Ryman again for the news media. We have briefed this issue a couple different times so far. Sometimes there is a misconception that I think is running, particularly through what Mr. Novak argued, that suppression hearings, because the evidence may be suppressed or excluded, or in limine hearings, need to be closed unless the evidence is deemed admissible. That is the opposite of the law. That has been settled since the United States Supreme Court decided Waller versus Georgia. You can see it in Kearns Tribune, which dealt with a preliminary hearing and access to a preliminary hearing where, as you know, and as we've heard repeatedly today, all kinds of evidence is presented at the preliminary hearing that may not be admissible at trial. And so the universe of the public's right of access to proceedings is not limited just to what eventually gets admitted at trial, which, you know, if there even is a trial. And we've cited the court to, you know, numerous cases on this, and I don't have the brief in front of me, and the docket is huge, and I can find it for you if you'd like. But I just wanted to correct the misimpression that the public is not entitled to hear argument and to see evidence just because it may not be admissible. Otherwise, we would never have admissibility arguments in public. And I do want to I'll just make one other point. Kearns Tribune also speaks to this. And that is that if you do decide that there's and so let me just make two quick points. To the 403 point, just because evidence isn't admissible is not a basis to close the hearing. There may be a 403 argument. I haven't seen this document. I don't know what's in it. Maybe there is something incredibly prejudicial. You would have to make that decision. I'm at a loss. I haven't seen it. I'm happy to take a look at it and give you substantive argument, but it's the same high constitutional standard that you have to satisfy in order to close it. And then the last thing is just on the scope of any closure. Kearns Tribune speaks, and I know the court is aware of this. If you are going to close it, it needs to be as minimal as possible. And it's my experience, at least, that most of the argument about things in this context can occur in open court. And if you want to have, you know, a closed session or a sidebar or however, you have also done it in chambers. I just ask that it be as limited as possible. Thank you.
Thank you. All right, Mr. Novak, and it appears like, would you like to respond to that before? And then I'll return to Mr. McBride for any final thoughts, and the court will make its ruling.
Well, I just wanted to mention the Utah Supreme Court decision in State versus Archuleta, 857 P. 2nd 234. where this state's Supreme Court reminds us that the First Amendment right of access is qualified, and that what needs to be carefully judged in light of the qualified right of access with respect to preliminary hearing exhibits, that was the issue in State versus Archuleta, is the defendant's right to a fair trial. So we're in this slightly twilight zone situation where counsel for the media is saying, even if the court has decided that the exhibits are not going to be made available for copying and inspection, and the court may decide that this exhibit is either not admissible or admissible for the court's eyes only, counsel for the media is counseling that the court permit Mr. McBride to read the exhibit verbatim in open court. And that basically defeats all of those principles. So I don't think that's the correct path. Counsel for the media is correct that the court's sealing or closure should be narrowly tailored. And the 403 issue, which we are prepared only to discuss because of the sequencing of things in this case, in this proceeding, we're only prepared to discuss at sidebar, has to do with potential future evidence that the court may receive in this hearing, or it may not. So I'm not going to address other 403 issues in open court. If the court wants to defer this entire exhibit and discussion of it until later in the proceeding, then it may be that part of the 403 argument doesn't need to be at sidebar. And I think we're all assuming that sidebar proceedings in this preliminary hearing are going to be part of the sealed transcript until some later point in time. In other words, it's not sidebar just for the moment, it's because the transcript's going to be sealed. So it very well may be that taking this issue up at a later point in time in this proceeding eliminates the need, from our perspective, for that 403 issue to be discussed at sidebar, or at what counsel for the media says in a closed proceeding. However, I agree with the court that Mr. McBride can't have his cake and eat it too. If he wants to make his argument and he thinks that his argument requires that he read an exhibit in court, which we in good faith are saying is not admissible, then we need to have a closed proceeding. I'm not asking for a closed proceeding. I was asking the court to caution Mr. McBride not to read into evidence exhibits that are not received into evidence, because that's the same as Mr. McBride testifying.
All right. Thank you. Anything further, Mr. McBride?
Just to note, I have not made my full argument on admissibility, that's all.
All right.
So how can you
All right,
rule on
I appreciate the
admissibility?
arguments by the parties. This is clearly something that's very important to you all and is important for this case, as is every piece of potential evidence. I note that Mr. Novak indicated that receiving this could create confusion for future potential jurors. And that he mentioned that it could suggest to a potential jury pool that this case is about religion. However, what is happening at a preliminary hearing is far different than what happens at a jury trial. The magistrate, myself, is the fact finder. And whether something becomes admissible at trial is far different than what is admissible at a preliminary hearing. The purposes are different, the standards are different, and different steps need to be followed. Something could become admissible at a jury trial, but given the nature of a jury trial, more steps are necessary. Under Rule 1102, one of the major differences is that reliable hearsay is allowed in a preliminary hearing under the Utah Constitution and under the Rules of Evidence 1102. That is far different than what would happen at a jury trial. Taking this into consideration, I look to the information going to the very beginning, whether this is relevant. And as noted by counsel, looking to count 1, which is squarely before the court, to determine probable cause at the end of this proceeding. And the court is not weighing in whether it will reach that or not. It's not predetermining anything. But what is before this court under count 1, aggravated murder, which is a capital offense, victim targeting enhancement in violation of Utah Code Annotated 76-3-203.14 sub 2, Tyler James Robinson intentionally selected Charlie Kirk because of Tyler James Robinson belief or perception regarding Charlie Kirk's political expression. And so if that was not here, this enhancement, and it also goes to count 2, felony discharge of a firearm causing serious bodily injury. And I'm just reviewing. And then finally, count 7, violent offense committed in the presence of a child, where the victim targeting enhancement also is in play. Because that is part of the information that's squarely before the court, this becomes relevant. Now, trying to determine what is political expression versus religious expression, that goes into different grounds, but at this point, the court finds it is relevant for consideration, and for the very least for argument. What the court is going to rule is that the need for a closed hearing is not been met at this point, because what needs to be shown is prejudice, or that the exhibit contains inflammatory information that would prejudice the jury pool. That begins the path where we can consider closing the hearing from the public. However, that's not what's before the court, nor has the court heard that. And so the ruling of the court is, previously I sustained Mr. Novak's objection, and the court will expound upon that Mr. McBride in his argument cannot read the entirety of State's Exhibit 5.1. Can he reference points of it and specifically quote certain points? The court rules that he can, just as Mr. Novak pulled from this, and it was broad, but he quoted Matthew chapter 19. He stated that this came from the Bible. He talked about
that was chapter 9.
Going from paragraph 1 where he quoted, or at least drew from, about the Internal Revenue Service and the type of business. And so there is grounds for that to occur in order for the court to consider the argument fully and making the determination whether it is relevant and should be admissible. Therefore, the court rules that Mr. McBride can continue in his arguments in order that the court can make its determination whether State's Exhibit 5.1 is admissible or not.
Yeah, 5 days isn't enough, Judge. Long sigh from the judge.
Thank you. 5.1 is a general explanation of what Turning Point USA, Charlie Kirk's organization, is and was on September 10th. The exhibit describes the events that Turning Point USA holds, talking about at least 200 plus of these events featuring Charlie Kirk as a headline speaker had taken place by that time. That's in paragraph 3. That these events discussed political issues as well as religious issues. Those political issues in the portion I previously quoted talked about gender issues in particular, gender, sexuality issues, the difference, or the Christian and political view regarding marriage and families and gender identity. And that information is relevant to the motive that we are alleging in this case. And it's also relevant to the victim targeting enhancement, which is in part a motive type enhancement. And the evidence will be introduced through, or we will offer evidence through other witnesses that talks about some of the defendant's statements that indicate his gender persuasion, and that he falls into some of these political and gender views that Charlie Kirk argued against. That's the relevance of this statement, is it shows Charlie Kirk publicly, in front of large gatherings of people, debated and presented his views, his political views, which were tied to his religious views about gender identity, LGBTQ rights type issues. And the relevance to that is the defendant's motive is that he was on the other side of those views. And you'll see evidence that talks about that through other witnesses. It talks about that being the inference and the motive that he had, or the inference from that evidence supports that motive, which supports the victim targeting enhancement, and frankly, motive in general, which goes to identity.
This is
For that
still
reason,
over the
Your Honor,
admissibility of the document.
This exhibit is relevant. I don't see the prejudicial effect, unfair prejudicial effect this would have on the fact finder, whether or not it has, some capability of prejudicing the potential jury pool. I think that's a completely different question. I don't think it does. I think this case has already highlighted the political issues that we're talking about here, but my job here is to present this case to the court, to you, Your Honor, for you to make a decision. This evidence is admissible for that purpose. Whether or not it's public or published for the public to see is a different question, which I'll submit. The media is very capably represented, and I'll let them make the argument on that point. But I would ask the court to admit this exhibit.
Mr. Novak.
Thank you, Your Honor. For the state to argue that this exhibit says anything about Mr. Robinson's state of mind should be rejected out of hand. This exhibit does not say anything about Mr. Robinson's state of mind, and that's what motive is, and that's what the victim targeting enhancement adopted by the legislature focuses on, is the defendant's perception. If Mr. McBride wants to propose significant redactions to this exhibit so that Your Honor, acting as a magistrate, can consider things that are narrowly tailored to what the information alleges, which is the allegation is that Mr. Robinson perceived that Mr. Kirk had certain political views, that's one thing. But this document talks, and now Mr. McBride, not to be colloquial, has sort of thrown down the gauntlet. This document talks about foreign affairs, political doctrines, America's founding principles, cultural trends, and what Mr. Engelhardt refers to as Orthodox Christian views on sexuality, marriage, and gender/sex. So this document goes way beyond what the state just flagged for the entire world is their view of Mr. Robinson's motive, which has something to do with gender identity, gender ideology, and sexuality. That's what Mr. McBride has just said this case is all about. This document goes way beyond that, and that's why it's not admissible. There may, as I said, be other evidence which Mr. McBride and the state want to rely upon, which they haven't presented yet, and Mr. McBride hinted at that. So I think that it's not admissible at this point in time. I don't think it's relevant in the sense of has a tendency to make a fact of consequence more or less true. That's the definition of relevance. So how does this court go from what the state has to establish, which is motive, or well, actually, the state doesn't have to establish motive. Motive is not an element of the offense. But at least with respect to the victim enhancement, according to the legislature, the question is, what is in Mr. Robinson's state of mind? The other thing I want to say is that Mr. McBride did not address the admissibility of these opinions. Now, the court talked about 1102, but 1102 doesn't resolve all of the other rules of evidence. It's just a gateway for an affidavit. So what we have in this document are what I think are purport to be untested expert opinions, or at least lay opinions. And the question is, under the rules of evidence, is whether this document is helpful to the court when it makes a determination about whether Mr. Robinson perceived that Mr. Kirk had certain political views. So where is the evidence that Mr. Robinson, in this document, that Mr. Robinson was aware of Mr. Kirk's political views? Where is the evidence in this document that Mr. Robinson had...
It doesn't need to be in this document, just for the record.
Disagreement with Mr. Kirk's political expression. None of that appears in this document. There may be other evidence of that we'll have to see. But there's nothing in this document which connects up with Mr. Robinson's state of mind, which is the question in the enhancement. And Mr. Engelhardt cannot, of course, express any opinion about Mr. Robinson's state of mind because he doesn't know him, and because that would be improper opinion evidence under any rule of law. So for a document to be received into evidence that quotes one very narrow piece of religious doctrine, and that involves Mr. Engelhardt's interpretation of what that means. I mean, Mr. Engelhardt at the top of page 2 is basically telling this court what he thinks Chapter 19 means. How could that possibly be admissible in this proceeding? And how could it possibly be admissible for the purpose of this court concluding what Mr. Kirk thought Chapter 19 of Matthew means? So it's not relevant. It's improper opinion evidence. It's definitely overbroad in terms of the evidence that the state is proffering to prove a very narrow point. And it actually doesn't get to that point, which is what was Mr. Robinson's state of mind. It also doesn't say anything that Mr. Kirk specifically said on September 10th that Mr. Robinson may or may not have heard, or anything that Mr. Kirk said before September 10th, specifically, that Mr. Robinson may or may not have heard. Nor has the state presented any evidence, and as an officer of the court, I would say I don't think the state can present any evidence that Mr. Robinson specifically heard Mr. Kirk say a specific thing at a specific time. There are some statements which I think that the state will say are admissions by Mr. Robinson, which reference Mr. Kirk, which we will get to later. But none of those reference specific statements by Mr. Robinson about specific statements by Mr. Kirk on any specific issue.
He's fully launched
that
into
would
his judgment
even
of
make
acquittal
a piece
argument.
of this relevant. So I'm pretty sure that I've reached that point where anything more I say, I'm going to be repeating myself, and so I'm just going to stop unless the court has questions.
Please stop.
I don't. Thank you. Well, I do have a question as it relates to political expressions. Does religion or gender intersect with political expressions?
I think that's a great question, but probably not a question to be answered by me in this proceeding. That's actually a really, really complicated question that the state wants the court to say is a simple yes.
All right.
Because I don't want to be the expert. I mean, the court's basically asking me to testify. I'm not trying to be flippant. The court is asking me to testify about where religion and politics intersect. And that's a fascinating question. The question here is whether this document, the way it's presented, the way it was written, is admissible under relevance and expert 701, 702 rules of evidence to prove what Mr. McBride says the state, what he acknowledges the state has to prove, which is that Mr. Robinson had a state of mind which was, let's just say, hostile to Mr. Kirk's political expression. And I don't think that this court should be deciding, based on the record before it, where, if at all, politics and religion intersect. That's. I mean, if the court needs to resolve that issue, then the court also needs to resolve the question of which religious philosophy are we talking about?
Well, Mr. Novak, I bring that up because you mentioned it, and you said you cited directly to the enhancement. You said political expression, and then you went to the Bible itself. And so it appeared to the court that you put it into play. So I just wanted to get a little bit of guidance from your position. And so that's the reason for the question.
No, I totally appreciate the question. I'm not suggesting, Your Honor, that there's a problem with the question. Any question that the court asks is a question that counsel should take seriously. The legislature separates in the statute religion and political expression.
This is a better answer.
The state selected the victim targeting enhancement based on political expression only. Now the state wants to I didn't bring Matthew in. The state is bringing Matthew in through Mr. Engelhardt. I didn't bring the Bible to this courtroom, the state brought it. And that concerns me greatly because the state is turning this into a question of whether Mr. Robinson's views, identity, life are anti-Christian. And that's a huge problem. And the state has created that problem. And this hearing is being broadcast to the entire jury pool. And that's what Mr. McBride just did, is he turned this case into whether Mr. Robinson's life is inconsistent with what Mr. Engelhardt calls Orthodox Christian views. I'm going to just stop right here because
you're getting
I think the court knows what the problem is.
Thank you. All right, anything further before the court makes its ruling? I appreciate the in-depth argument and the passion behind the argument. You are advocating for your clients, and I respect that.
Yeah, Your Honor, I'd just say it provides context for the defendant's state of mind.
All right.
That's all.
All right, in making this determination whether it's admissible or not, I'm going to start at the beginning, which is this. This is a preliminary hearing. The purpose is to determine whether the state has established probable cause to believe a crime was committed and that Mr. Robinson committed it. As it relates to this case, as I turn to relevance, I turn to the information as previously stated, and is this relevant, what is before me? And without indicating my decision on probable cause, because I am not at that point, I'm withholding all decision-making until all evidence is properly before me. And so in this ruling, it is not indicating either direction that the court is heading. However, the court finds that it is relevant as it relates to the victim targeting enhancement, as it relates to Charlie Kirk's political expression, and the court recognizes the argument made by defense in regards to state of mind. And it is because of both arguments that the court finds that the court is ruling that it is provisionally admitted into evidence. And at such point, when it becomes relevant, based off what Mr. Novak has talked about Mr. Robinson's state of mind about Mr. Kirk's political beliefs, then at that point, whether it is admitted or not into evidence will be decided upon. So as of right now, it is provisionally admitted. Because of that stance, it will not be published to the courtroom or media, but both parties can weigh in on that when this is brought up again, and the request for it to be fully admitted is made by either party. Then the court will re-examine whether it should be published at that time to those in the courtroom and to whether that is displayed or filmed by the camera.
So now he gets to read parts of it.
Let us proceed. Well, let us proceed to lunch because it is now 12:40. It seems like a natural place to stop. I believe everyone looks like they need a lunch break. So let's go ahead and break for lunch. Let's come back at 1:15. Well, I need to give you a full lunch here. I need to do my lawyer math and see what that would bring us to. So it's 12:40. Let's come back at 1:45 for lunch. All right. Any party need the benefit of the record before we break for lunch?
Not from the state, Judge.
I'd like to tear a few pieces off.
Court is in
if it's all right,
recess
Judge.
until 1:45.
The record. All right. We'll see if the camera keeps the seal. We hope it keeps the seal up during the break. We're going to stay here with it. We're not going to leave. Let me go back and talk about this a little bit. This is an 1102 argument. It's an argument about an 1102 document, which is, according to the state, a self-authenticating legal document and public record. That's how they introduced this. This self-authenticating public record legal document, 1102 statement, and it's by, I don't know the guy's name, Englert, I don't know. Somebody with Turning Point filed a statement about this is my statement. And so they just want to admit it, and defense has fought that on a couple grounds. They fought on relevance and lost, and they're fighting this argument where the defense is I'll say the defense is winning, even though they're sort of losing the rulings. They're winning in that they're able to frame the discussion around the points that they would like. So they get to create the narrative and the parameters of the argument. They're saying, Judge, you have to you can't let this in because it doesn't have anything in here about Tyler Robinson's state of mind. It doesn't have anything in here about proof that he was targeting Charlie for this reason. It doesn't need to. That is not the argument at all. What the state is trying to bring in is a document, excuse me, that could go to support this enhanced penalty option under the law. The enhanced penalty we're talking about is the death penalty. In case no one's read between the lines here, we're talking about the death penalty. Is the enhancement. And the state of Utah, back in 2019, came out with 76-3-203.14, which is a law, victim targeting penalty enhancement. And these are the penalties. It says, as used in the section, personal attribute, this is a personal attribute of the victim, personal attribute, it could be, and these are all things that could be an enhancement. Okay, so if this crime was committed against this person because of one of these reasons, then it could qualify for an enhanced penalty. And this is the list, and it's a big one: age, ancestry, disability, ethnicity, familial status, gender identity, homelessness, marital status, matriculation, national origin, political expression, race, religion, sex, sexual orientation, service in the U.S. Armed Forces, and status as of emergency responder as defined in Section 53, as well as status as a law enforcement officer, corrections officer, or special function officer. So they did kill the camera for us. Sorry about that. So all these things are potential categories that could qualify a defendant to face enhanced penalties in their charges. And if it's a murder charge, the enhanced penalty could bring the death penalty. If he chose the victim because of one of these reasons and target him for that reason. I think the defense is right in part that the state does have to prove that Tyler chose his victim. If they're able to prove that he did all this, whatever, they're going to have to prove for this enhanced penalty that he chose his victim because of one of these reasons. The defense is saying, the state said he chose him for political reasons, and now they're introducing this 1102 document from the Turning Point USA guy that has all this religious stuff. Well, that's a different category on the list. Okay, political expression is K, religion is M. So we shouldn't let the religious stuff in because they are worried, as they rightfully should be, that this might be viewed as an attack on religion in general. And Utah being a very religious state, it might be more difficult for Tyler to get a fair trial in a state that, strongly religious and thinks that this attack, this murder was committed because of a bias against religion of some sort. So that's the argument back and forth that we had. The judge, he sat on the fence and didn't really decide, provisionally let it in. I don't know how that's going to look because the state has said, Your Honor, you have to rule. I have to be able to talk about this. And so he let it in so he could talk about it, but then ruled that the media and the public can't hear about it. It's a document. So if he reads it or quotes it or somebody on the stand quotes it, we're hearing about it. Wrapped in all of that, the defense suggested that because of the inflammatory nature of this 1102 statement from the Turning Point USA guy, with talking about religion and some of the things that Charlie stood for that were not political, it's so sensitive that it could jeopardize any future jury. Thus, we need to close this hearing right now, kick everyone out of the courtroom, get rid of the cameras, because we need to. It's so sensitive we can't even talk about it in front of the public. He lost that battle quite handedly. So that was good. Loves true crimes. He stated in his text why he did it. The texts haven't come in yet. We're waiting on that. And trust me, there'll be a fight over those too. But thank you, Loves True Crimes. Appreciate your support. I think the easier motive or the easier explanation that the state could have offered and sort of did get to at the very end was that, Your Honor, we accept that burden of having to prove that Tyler did this because he was targeting one of these classifications under the enhanced penalty. We accept that. That burden's ours and we carry that. To establish that, we have to show that the victim qualified under one of those statuses. This document is a sworn statement that establishes that because the victim, I'm not sure if you checked, isn't with us anymore. Okay, that would mean that anyone who is, if we had to have Charlie Kirk himself give a sworn statement saying, yes, it was a political or a religious statement that I was targeted for, that any murder victim would never qualify for an enhanced penalty against the defendant. It has to be able to come in somehow, and that would have been the easy explanation. But it's pretty much in now, for the most part-ish, provisionally. We're finally still between witness number 2 and witness number 3. We never got to the third. We didn't get him on the stand yet. This was all just the fight after witness number 2. So this is going, I think by everyone's measure, slower than expected. They have 5 days to get this done. Tomorrow was a half day. So, we're basically, we have 3 full days left, counting today and tomorrow. And there's a lot to get through. Let's see. Any other questions about that? Why is RA clearer than the state? I have the benefit of not being on national TV on 700 different outlets in front of a judge with victims behind me and I don't know, Secret Service, are they there today? There's a lot of pressure on those attorneys, and honestly, this the ideas that they're putting out there by the defense are sort of harebrained. They're popping up out of the blue. Defense doesn't have to say, by the way, tomorrow, when you go to introduce that one 1102 from the Turning Point guy, we're going to say this. So there's no warning. They're shooting from the cuff, and they also don't know where the judge is going when he hears the argument, where his mind is, right? We saw that a little bit with defense when the judge says, hey, I'm just curious, where's the line between religion and politics? Do the two merge a little bit? And defense did not want to step into that pot of boiling water. So they're backtracking. I can't be the arbiter. Judge, that's not my place to decide. And then he's like, wait, but it's also not your place to decide either, Judge. You can't decide that either. So it was a little bit funny, a little bit of double time quick step to sort of dodge that question. How do we feel about the judge? Is he good? I do like the judge. I think he's I think his inexperience shows in a couple situations. I disagree with some of his decisions, but as demeanor, as a judge, I think I'd love to follow his career and see other cases he follows. This is just his first death penalty case, and he's taken it slow and very deliberate. And I think there are some things he's encountering here, possibly for the first time as a judge, which is causing it. I mean, it shows. He's every single time he makes a ruling, he's giving you case citations and on the laws and the rule and what his reasoning, and that might just be his style, but you can't clear a docket that way. You can't get through a day's docket by citing every single objection that you overrule or sustain and why. So I think that in time he'll start ruling a little bit faster as he starts experiencing the same questions in different cases more and more often, and he gets a little more familiar with case law. Let's see. I think this is a huge case. Judge is just being overly cautious, and I agree. There's a lot of pressure on him as well. I think. Okay, let me go back to one other thing. This is about the judge, and this has been raised a couple different ways that I think needs to be talked about. So, State, if you're listening to me, think this one through and see if there's a way you can suggest this to the judge. The defense has raised the issue of the 403, the prejudicial evidence, something like, Your Honor, we can't let this in. It would taint the jury. They would, this is so prejudicial, this video of allegedly my client committing the crime, that we can't let them know it's out there. Well, guess what? How many of you guys have watched court when some witness blurts out something like in the Zachariah Anderson trial? His daughter blurted out, because that's the gun I was threatened with. Immediately there was an objection, move to strike, sustained. And the judge, in that case it was Judge Schroeder, turns to the jury and says, jury, you'll disregard. Okay, I think it went something like that. I might have sort of merged that together really quickly because that was a hectic point in the trial. But the judge says, disregard what you just heard. Strike that from your memory. It should play no part in your decision making. If we trust the jury to be able to put the poop back in the horse and make a rational decision without considering the manure, the judge should be able to do the same thing. And so the defense insinuating that the judge should not even view this because it's so prejudicial to this case, excuse me, is that an insult to the judge's ability to be able to differentiate and say, I can make a ruling on this document and then determine whether or not I'm going to decide if it's going to be one of the factors I consider on the ruling on the case in whole. I really get frustrated with the fact that judges are professional. They are able to understand, and they must be able to because they think the jury should be able to when they strike something. Okay, that's my my vent is over. This isn't a huge case. This is a massive, enormous, soul-crushing case for a new judge. It's way too political. I think he can navigate it. I really think he can. And it could be that we're seeing from him something that we like, but it is also causing a problem. For instance, what was it? Brian Koberger's judge? Was that Judge up in Idaho? Was he the one who would never rule from the bench? He'd always take it under advisement, and then he'd go and he'd think it over and then come back with his ruling. Judge Graff is making decisions on the fly. We like that. But he might just be like a lot of other judges that struggle to make a decision on the fly and might not be able to have rationally thought through every aspect of the argument and case law and where it stands and how it applies in this situation. And so his gut reaction ruling might come off a little bit different. So maybe he needs to take a brief break between hearing the arguments from both sides and ruling, just to make sure he gets it right. We do like on-the-fly decisions, though. It helps us a ton. Let's see. So we did post over on Twitter, by the way, for those that are curious, we put a link up there of the security footage compilation. That was the stuff that couldn't come in yesterday, and they admitted it today without any of the zooms and markups and circles and everything else. I took a copy of that. And because you watch it, here, let me do a demonstration for you. We're just going to grab this children's book, Little House in the Big Woods, Laura Ingalls Wilder, from my shelf. If you were to look right at the TV, okay, it's going to have this rectangular shape, right? But if you were to look at it from an angle, this side looks shorter, and the side closest to the TV looks bigger, right? This is how we're viewing the monitor in court. This would be the monitor in court. So the camera's looking right at it, and it looks a little funky. What I did is I took this, and I distorted it by zooming in and twisting it so that it fills up the whole page, and it's not distorted. So I took the video from the compilation of the security camera footage from U of L University. We put that up on Twitter there that way. So if you want to see that, if you want to use that, to some of it is a little bit new. I think it's out there if you need to find that. We also, I didn't tell you this, we also started running a live stream on Top Mark Media. A couple people had asked me if I could fix the audio because people are only getting left channel or right channel only on their feed. So I've put on Top Mark Media, I've corrected the audio so that it is mono, so you get the sound in both ears, and done a little bit of adjustment and put a limiter on so it doesn't get too loud, and it's loud enough that you can hear everything. Over on the Top Mark Media side, if you need to pull any clips, and that's just clean, that's just court view, nothing, no commentary, not my face, no chats on screen. So that's going as well. Anybody else? Any questions? Had father-daughter time today, so I missed anything of note happen. A lot of fights, well, not fights, but arguments over evidence. I think we're making ground, like we're gaining ground in this. The state was able to sort of put a stop to a lot of the renew our standing objections issues that we've had yesterday, and the judge adopted that, and the defense adopted that. So that was wonderful. So it's gone a little bit quicker, but we also haven't had as much evidence come in today because the evidence that's come in has been either very big, like 10-minute long video, or possibly very complex, like this 1102 turning point statement. I already had lunch, Grace. I admit, when I did this, I was eating lunch. Had a couple brats. They were delicious, very hot. I burned my tongue and my fingers. Is there a hard stop at 5 days? Cat pool, that is the amount of time that the judge has allotted in his schedule for this. That means that Monday next week, someone else is supposed to be in court with their attorney and the state prosecuting them. If that's the case, and the judge has to continue this on Monday, then that person gets either pushed off to another judge, or their court case gets pushed out a little bit, and that can cause problems with speedy trial time frames. It can cause problems with a lot of things. So they don't like pushing if they don't have to, and planning on 5 days, being 5 days is enough, and then not hitting that mark, the judge will be pretty unhappy towards the end of the week. Cheryl, thanks for your kind words. RA was, or are you an attorney? Brian Heath, I am not. I love the law. I've studied the law. Professionally, my career is diverse, but it would be for what we're doing here. I've done a lot of. There were years that I read every bill that was submitted in my state for consideration for passage of the legislature. I love reading the law. I've always loved that. I've worked with the police departments. I like law enforcement. I like interaction with law enforcement. I've worked with the media. I've worked for some of these channels. I've got footage that's played on this KSL channel that is doing the pool media here. I worked for Fox 13 in Salt Lake City, Utah. I have a degree in communications, electronic media. And then as soon as I got that degree and realized it doesn't pay anything, I went to work for the federal government in IT. And after working for them for a lot of years, I transitioned to YouTube full time. So that's my background. It's a love for the law. So I'm not providing legal counsel. I'm not a lawyer. I don't pretend to be one. I just love to learn about it. I will tell you this, there are some great attorneys out there, and especially great attorneys here on YouTube that are following all the cases. I mean, I'm wearing Josh Courtroom Confidential shirt. We were on with him just a couple days ago. But there are a lot of great attorneys out here that give great analysis of the legal battles and issues that come up in court. We're fortunate enough to have friends of them, and some of them here in our chat right now. There's Nicole from Goodman Law Firm. That when an issue comes up that is out of my depth and understanding, they're here and they help us out. They help us understand what the law is, how it works, what the process is. So we benefit greatly from some really smart and generous legal minds here, both friends of the channel, other channels as well. So there you go. I am credentialed media, I can tell you that. So, all right, off topic, but the ad screens on the sidelines of the World Cup games, heard that they show different ads to different regions, something about the way they film in different frames. How does that work? I would say yes, Mac. I'm not huge into how exactly the ads work as far as the frame rates. I can tell you that like in England, they do 50 frames per second, and whereas the U.S. we do 60. So there's different standard frame rates for television. Just television standards are different. But yeah. Let's see. How did I pick the wrong state to do this in? I think any state would be the wrong thing to do this in. I'm not a big fan of murder as a resorting to killing to get your way or to prove a point. I'm not trying to get political on this. I don't think any murder is seldom justified, and what it is, it's called self-defense. That's usually how it boils down. What's going on in New York City? A building is collapsing. The old Pfizer building, they had a floor sort of buckle, which means the building's coming down. So that's happening. If you're up in New York, please stay away from that one. It's going to come down. It has to come down now that it's buckled. Imagine building a 20-layer wedding cake and having the second layer up lose all the filling. It's coming down. It's coming down. So, let's see. Yeah, I have so much respect for people who make political statements without violence. When we're talking to Rosa Parks and Martin Luther King, I think those are powerful, powerful ways to affect change and to reach people. I think violence is the least effective way of convincing somebody that you're right politically. So not a fan of it, but here we are anyway. So, all right. I think that's all the notes I had to take. That's all the notes I had for what I wanted to talk to you today during lunch. The court live stream is just the KSL live view feed. So what we might do is switch it up just a tiny bit so you can see. We'll give you a view to look at. Just one second. I'm going to do mix effect. Not sure if this will work, but we're going to try it. It did. All right, hold please. We're going to get all these set up. Okay, 4 is the background, and 1 and 2. So 4 is going to be media player 2, which is over here. And then 1 is box 4, and 2 is box 7. Okay, there we go. That didn't work very well. Let me put this up here. This was supposed to be picture-in-picture, and the background didn't come in. Camera 4. Oh, that's HyperDeck. We'll put it as media player 2. There we go. There we go. So there's my desk, and the live view is the transponder from the pool media KSL TV. That's their bonded cellular encoder. So as we go to lunch, we're going to be back here in about 42 minutes. 42 minutes, lurking live from the woods. Nice. 42 minutes, we'll be back with this afternoon with what we hope to be witness number 3 in this trial. We're still only 2 witnesses deep in this thing. It's taking a little bit too long. Elated says, so this all prosecution case and not a case in chief by the defense. Right. This is, if you're familiar with a grand jury indictment, that is something where the prosecution gets to speak. The defense isn't even present. They don't get a say in that at all. That is one way to bind somebody over for court, is to have a grand jury indict them. And that's where a jury hears evidence presented by just the prosecution and only the prosecution. And they say, is there enough evidence to charge? And they say, yes, they usually do. Grand juries will indict a ham sandwich. And then it goes to court. Utah has chosen, in other cases as well as this one, not to do the grand jury route, even though they legally can. Instead, they're doing a preliminary hearing. That is where a court with a judge listens to a preliminary view of the evidence to see if there is enough, enough probable cause, not beyond reasonable doubt, but enough probable cause for this to go to a jury and proceed to trial. So at the end of this, if the worst thing that can happen for Tyler Robinson is that he would be proceeding on to trial. There's no jail. Well, it continues in jail because I don't think he's out on bond. But there's no additional penalty or fine or anything that's going to happen. It's just going to proceed with the criminal case if it goes against him. Will he be the trial judge? Unless something changes, yes. There are some times we've seen, and I imagine this argument's going to be raised again before we reach trial. But there are some times where we have seen that when defense usually asks for a change of venue, meaning we want to have this trial somewhere else because it will be impossible to find a jury that's fair here, they'll move to another county. Sometimes, because of the inconvenience to the judge, it will move to another judge. But oftentimes, that judge will just travel to the other county and sort of telework from the other county and be there to oversee the case that he's been over the whole time. So most likely it would keep him as the judge, even if they did get a change of venue. $5 says Nestor will ask him to be disqualified. Might happen if it hasn't already. Very much wondering about if a change of venue will come up. It will, Sarah. I'm telling you, it will. But defense has to look at a couple things. First of all, we're in Orem right now, Okay, we're in Provo, Utah, which is Utah County, just south of Salt Lake City. Salt Lake is 20 minutes away. It's just up and over the hill, over the point of the mountain. Traverse Mountain is between Utah County and Salt Lake County. That would be a better county, politically speaking, for this trial if the defense wanted a more diverse political citizenry to draw from. That because Salt Lake County is more liberal than sort of the rest of the state. So that would be their goal to get that one, but it might also move to Davis County, which is just north of Salt Lake County. Davis County is the most conservative county in the most conservative state in the nation. So when you ask for a change of venue, you might get more than you wanted and actually end up in hotter water than what the pot you left. So don't you always want a diverse jury? I'm just saying the jury pool, and I'm basing this entirely on elections, right? Which counties elect different parties, and Utah as a whole is conservative and tends to lean strongly Republican. Salt Lake County has a Democratic. I think they have a Democratic mayor right now, and often elect Democratic officials locally to offices. It's more politically, it's more balanced than the rest of the state. Is there any middle ground country? Maybe Weber County, just north of Davis. Box Elder County is a bit too far. They could go to Summit County, where they had the Corey Richmond trial. That's up in Park City area. So there are a couple choices around there. You really can't go much further south unless you go clear down to like St. George or Cedar City area. They're just Utah's a lot of desert. And there aren't a lot of they're massive areas with just no people in them. So there's some options. You could go to Tooele, maybe, out by the Great Salt Lake. All right. Let's see. You don't get a choice necessarily for where the venue gets changed, so it can certainly be a toss-up and a gamble. Yeah. So they are not in the worst place for this trial. Based on just that political factor. There are worse places than Utah County for that, but not many. Utah and Davis County are probably two of the most conservative counties in the state. Have they talked about why the screwdriver wasn't in the report? That came up yesterday. I don't remember if it was. I don't remember the reason it wasn't in the report. Box Elder County. I think Box Elder County is where the railroad met, where they had the Golden Spike, the driving of the Golden Spike, where the east and the west joined together. I think that's in Box Elder County. I think that's it. Okay. We're going to take we're not taking a break. We're going to still remain live here. And probably just give you guys a couple moments of silence to get some food in without.
In the beginning, when we started 110 years ago.
Laura, I said silence. Just kidding, Laura. She did that because it's quiet and the judge moves at a snail's pace. Can they bring in more than one reason? Elated, I want to answer this question. More than one reason? Are you talking about the document with the victim targeting penalty enhancement? Because yes, they can. You don't have to limit yourself to just one. It says that a defendant is subject to enhanced penalties if the defendant intentionally selects a victim because of the defendant's belief or perception regarding the victim's personal attribute, one of those things, or a personal attribute of another individual group. So if there is a personal attribute, it works. So you could have multiple qualifications there. Yes, it couldn't have been timed better. All right, I think that answers all the questions for today, gets us all caught up. We are in our lunch break for another half hour and, 35 minutes. And And I know somewhere I have a Milky Way candy bar that has my name on it. So I'm hoping it didn't find its way into my son's lunchbox today. But predictions when the trial will actually begin. Christine, this is a tough one because I believe the state is under the pressure of the defense requiring this to be under speedy trial. So this has been quick. You look at other murders where, murder trials we've been to, you often have about a 2 to 3 year period between when the event happens and when you're to court. Look at how long it's been here. I mean, we've got the video camera with the timestamp. This is very quick. It's been hurried up for that reason, and that's a strategic move by the defense. So I don't know how soon it's going to go if the defense chooses to keep that speedy trial requirement in place and exercise that constitutional right. So it could be. I could be this year. That's fast. That's super fast. But, I mean, look at Murdaugh, for instance. He's got a new trial, and his won't start till next year. Finally saw Tyler's text messages. We're possibly going to see them. I'm not sure if they're going to come in today or if it would be at the end of the 5 days, 6 day preliminary hearing. It is sort of the smoking gun because it's about the closest thing we have to a confession by the defendant that we know of. I mean, it's possible that he could have talked to police and we just don't know what happened there after he was taken into custody. It's my understanding that he basically surrendered, said, "I'm the guy you're looking for," and clammed up and lawyered up. If that's not the case and he instead did speak to police, A, his lawyers have their hands full, and B, we'll have a lot of time to watch that and argue about that too. How many years do you think it will be to go to trial? If it's a speedy trial requirement, I think they're going to start the process this year. There will probably be delays that the defense asks for, or the defense creates by reason of their objections, say like change of venue type things. But I think we'll start this year at the latest next year. Okay. Adam Montgomery's getting a new trial. Yep. Letitia Stout's getting a new trial. Alec Murdaugh's getting a new trial. It seems to be the trend. Do you think Corey is getting a new trial? I don't think so. I read her motion for a new trial. It was not convincing to me, saying the judge doesn't like me best, so we go on a new trial. It was just not there. Judge Mrazek was so balanced and fair in that trial that it's almost offensive for them to even insinuate that he was anything other than that. It's just everyone gets 2 trials. Best out of 3. How about that? New judicial system. Best out of 3. You get 3 shots, and you have to lose twice before you get convicted. Who's down for that? I don't think Corey will get one. Yes, they will retry Adam Montgomery. And the evidence will still be overwhelming as it was before. Are you planning to cover any of the new trials? Possibly Murdaugh. Murdaugh's just south of me. I'm in North Carolina. He's in South Carolina. That might be one where we head down to the low country for. Obviously, we're following Tyler Robinson. So as that progresses, we'll follow that if that goes to trial. I have my suspicions that it won't, just because the defense is putting on so much of a show right now. I think this is sort of their trial in public opinion right now. But the alternative is pleading guilty, and I'm not sure if you can get the death penalty by just pleading guilty. I don't know about Utah law. Some states require the maximum penalty to be decided by a jury. So you might have one of those situations where, we've seen this once before, where the defendant pled guilty, and then we proceed with a sentencing phase trial where all the evidence is admitted again. Where did we just see that? That was, I forget which trial that was. All right, do you have other live streaming members you recommend we also follow? I've heard about a few. I love watching you, but look for others to follow. Oh my goodness. The pillars of LawTube, everyone from Emily D. Baker, Ian Runkle, the lawyer Josh from Courtroom Confidential. We've got the therapist was on Twitter just a minute ago saying some kind words about us. We got to give a shout out back there. Trial TV Live is a lot like me. We work together to bring you court, access to courts and transparency. They're great. Brandy Churchwell has done some live streaming of courts, as well as now it's in true crime podcasts. That's 13th Juror. That's a fantastic channel. Rob, Law and Lumber, amazing. We can't wait for him to come back on YouTube and enlighten us with his insight. He's amazing. He's just been busy with his legal profession. We talked about Ian Runkle from Runkle of the Bailey. I like Dr. G as far as, if you're looking at behavior analysis, he's a fantastic one. Dr. G Explains is his channel. Kurt from Uncivil Law was here this morning. He's great. Brandy's live for this trial. That is awesome. Awesome. We missed Brandy. She's going to be live for Murdaugh as well, I know. Let's see. Daisy Link gets a new trial. Yes, we released our song that wasn't about Daisy Link. It just happened to be about someone who got pregnant in prison by a fellow inmate who they never met in person. We released a song about that. And then she got a new trial. So, Kathy from Gossip Room and Innuendo, if you want a hot take on any of the trials that are going on, Kathy can get you jump-started in the morning with a really hot take on that. There are just some great. Andrew Burkhart is great. Dr. Patrice Berry. There are a ton. And I love it, honestly. Yes, you can say that we all compete, but in this world, in true crime, I'm talking about the true crime YouTube content creator world, there are so many different ways to slice an opinion from a judge or to view evidence in a courtroom. And what it means, and analyze and guess at what's going to happen next. If you're only watching one side, if you're only watching one vantage point, I think you're missing at least half the story. So I love it. A lot of us are on at different times. Some of us stream at the same time. I know Courtroom Confidential. Josh is streaming this channel as well. He's actually in person there in Provo because he does the Fox News Nation live bit because he's like a TV star. And so, Melanie Little. Yep, Melanie Little's there. Danny on Direct. She took a job in D.C. She took a big, high-paying job in D.C. Bob, yes. Bob Mata, yep. Bob and Allie. They were in chat here just yesterday. It was wonderful seeing them there. So there's a ton, honestly. Broken Baker. There's so many. We're leaving out some good ones. And they're different, right? And what I love about them is they're not me, and I'm not trying to be them. Okay, I do things differently than any other channel, and they do things differently. So if Melanie Little or Megan Fox or Ian Runkle or Rob or Peter Tragos, if you don't like the way they're doing it, if you want a little more spicy than I give you, Emily D. Baker is a great one. She has all the cursy words, so she's got a wealth of experience from her personal time in California in the legal profession as well. There's just Grizzly True Crime. You don't get a better background, in-depth, deep dive in a case than Grizzly True Crime gives you. There's just, I like them all. And I think that what they bring to the world of true crime makes the whole community better. So I do recommend, jumping around and checking out some of the other channels and looking at a different vantage point. I like what we do here. I like what we do. It's my style. I'm a tech guy, so I bring the best sound I can, the best video I can, and we're tweaking with the videos and showing replays and things like that. That's my way. That's my direction of how I do this. Brother Counsel, yep, here. Yes, Kurt is Supreme Court certified to argue in front of the Supreme Court. We said Peter Tragos from The Lawyer You Know. It was awesome. Peter Tragos invited me down to be on the show. Not down, but to be on the show. And he's an amazing guy. Just I love it when you meet somebody and they're the same off camera as they are on, and that's him. He's just genuine. Love it. So love being a grizzly. Yep. I think Brandy changed her channel. She's partnered with people before. Brandy Churchwell. She started with Murdaugh. I think it's when she started on Twitter. Really, that's when her Twitter blew up, and that's when we had her on the show. And then she started YouTube live streaming and just blew up there. Did great. And then her true love is podcasts. I think she loves to tell a story, and does a great job. She's live on 13th Juror. Yeah, she has a couple channels. JD, a Lawyer Explains, is good. There's more than I can watch all of them, so it's fun to hop around and see a different take here and there. She's just on Brandy Churchwell this morning, her old name. Cough hiccup. When I win the lottery, can I hire you to build me a YouTube studio? I'd love to, but I'd probably build it better than what I built this one. We do a little bit of consulting that way. I do my company, Topmark Media, which is the parent company that Recovery Addict operates under, does event production. So we do go out to convention centers and set up and do live streams and things that way. So we could help. I could also point you in the direction of some really good people, not cheap, but some people who could do fantastic setups as far as lighting and getting the depth right and different sets and images, and we could do some cool stuff. All right, so many wonderful channels. All right, great question, by the way. Love Danny on Direct. I like that she grants wishes. Love the Lucy cam. Yeah, I had the Kiki cam a little bit, but my cat's not very photogenic because it's an outdoor cat and I think it belongs to somebody else. So we have to share it. It's always here. Runclo the Bailey is a sweetheart Canadian. His channel is fun to listen and review cases in the evening. Yeah, I finally got to catch one of his leatherworking streams the other day, and that was just cool. Out there in the garage with like a mountain of ammunition, like ammo cans, military ammo cans. They're all empty. He swears they're all empty. And yeah, we believe you. No, it was just cool watching him work on the leather. He's talented, just like Rob is with wood. Just amazing. What time will they return? We'll be back in about 16 minutes. Indy Cindy. And by the way, Indy Cindy, I see that red courthouse by your name. You've been here for 37 months. Makes you an OG. I missed a couple of membership milestones during the court as well. Let me back up just for a minute. I think we had, let's see, Meanie Banana, member for 35 months, also on the jury, OG, says, good luck by getting a jury who hasn't seen the video of the shooting. I don't get this judge throwing out all the video. Right. Sloth Life came in with a huge super chat. Not a big fan of a brand new judge having a big case like this, and I hear you on that one. I think he can get through this one all right, but he might need some help from the state or the defense, as the case may be. Shelly Small gifted 5 memberships. Thank you. Manjuflay, appreciate you overcoming your bias by pretending the victim someone you adored. That's awesome. I love that you're able to do a little mind shift there just to enjoy the watch here. Let's see. Callie Carmen, brand new member. Welcome to the gallery, Callie. Now that you're here, you can never leave. You're one of us. Loves true crimes. He stated in his text why he did it. That's coming in. It's coming in. DSN, thank you very much for the big thumbs up super sticker. Appreciate it. Ivan's lurking from the woods. Hello, Ivan. Indy Cindy, also what time will they return? That's caught up. I've got them all. We're good. Missed all morning. What happened? Recap. Michelle, I wish I could tell you. I don't have time to recap. There's just so much that's happened. You need to rewatch. I wish I could honestly say that, but really, it has been slow. Like the progress in the trial has been slow. We have had lengthy arguments about evidence, admissibility, relevance, and whether or not it should be shown to the media and the public. Once again today, even though the actual time spent and the number of times that the defense has objected has only been 10 today. I think it's all defense objections today. We only had 10. So that's fewer than we've had previous days at this point. But really the arguments took a long time. If you watched yesterday, there was that video Mr. Hull was trying to admit that had the compilation of all the UVU security camera footage. The judge didn't allow that in. Yesterday, defense won that objection. He allowed the source video in today, but then allowed the compilation in, but only he could watch it, and the people in the courtroom could watch it, but we couldn't on media. Which, don't get me started. I have a hard time with that decision. So that happened, and then we also had some 1102. Which is one of those sworn statements, a long argument about that. We're still only 2 witnesses deep into this hearing. Hope you do this for a long time. I want that purple courthouse, says Joe Sherlock Joe. Thank you very much. I appreciate your support. Makes it all possible. Steel and Stitches Designs on the jury. 21 months makes you an OG. As such a new judge, I hope he takes his breaks to phone a friend who has more knowledge and experience in this law. I know that a judge should not make a decision, should not use an outside judge to make a decision, but I don't think there's anything wrong in consulting someone to get more information, especially a fellow judge, a coworker in this case, to make a good decision. Laura, you did go to orange. Congratulations on the new color of courthouse. Looks good. Why is he new? Denise, he's just new to the job. He's been a prosecutor, and this might give you a little insight into why he's very sensitive to the rights of victims, particularly. But he did a lot of prosecution of special crimes, child crime type situations. That's where he came from. That's his background. So he's very mindful of victim rights and the sensitivity and the rights the victims have. And you'll see that through everything he does. But he just got nominated to the bench, or just got placed on the bench by by Governor Cox, the Utah State Governor. That's how the judges get appointed in Utah, and that was last year, like in August or September of last year. So he's just reaching his year mark right about now, and this is his first death penalty case. But even if it's a brand new judge, at some point they're going to get their first death penalty case, and so why do you say, well, you have to have six murder trials before you can do the death penalty case? I don't know. Maybe they should qualify judges for death penalty like they do lawyers. He was an appeals prosecutor. He has a wealth of experience in the legal profession. He's just new to being a judge. So it's not that he doesn't understand the law or anything like that. The robe is still quite starched. It's new on him. It still smells like Tide. It's brand new. Let's see. All right, I told everyone who wants me to watch court watch to send me a Zoom link. Not willing to go in person when it's 112 degrees. So far, I'm just court watching with y'all. Well, if you can stay in the air-conditioned room, that's awesome. That's a great way to do it. Let's see, we got Horson Round 2. Welcome. Thanks for clicking the subscribe button. In just a couple minutes, you're going to be able to talk. There's a 5-minute wait period. I apologize for that, but it does stop a lot of the trolls, because the trolls don't have patience. They can't wait for 5 minutes. The robe's still itchy. Yes, he hasn't worked out the rough spots yet. Maybe his appeals background is what makes him so painfully thorough. Could be. I share a birthday with his state. I don't know how I feel about this. Is that July 24th? Gadget Girl? Is that? I mean, I'm not trying to out your birthday. I'm not trying to dox you or anything, but I don't know what the birthday of Utah is. I know that's the day they celebrate. That's their little holiday. Some trolls just subscribe and start getting along with us, and we'll allow it. We do. January 4th. Okay. I learned something today. I didn't know that. Well, happy birthday in January. Gadget Girl, thanks for being here. It's on the seal. Ooh. I probably should have paid attention to that. All right. About 13 minutes left. Just checking to see. I posted a clip yesterday of the judge watching the footage of the Charlie Kirk shooting from the vantage point of the camera right next to him. And the video was shown on the judge's screen and possibly was shown to court. I don't remember, but we were not allowed to see it on the media. So we zoomed in on the judge. That video has that I posted, that clip has 120,000 views just on Twitter, on X. And most of the comments, or most of the common sentiment that's shared in the comments on that video had to do with people sharing their reaction or saying, yep, I had the same reaction when I watched it the first time. And I don't like, I'm not telling people to watch that video, but it gives me hope that most of us still look at murder and be like, oh, I don't want to see that. That's bad. I like that there's a visceral reaction there. Wolf says, my main RA, unless there's a different trial I want to watch elsewhere, I watched Lawyer You Know, Peter Tragos, a bouncer all around to all mentioned After Hours. After Hours, it's lots of goes off the rails. After Hours, it's a lot of fun. Are you going to have lunch? I ate already, briefly. Let's see. I get trolls on my Wimpy channel. How can you troll horses? That's just not right. Don't let the Cloverman Courthouse fool you. I am, in fact, an OG. Real government name. Thank you very much. OG. Been here longer. Runkle's fun. I love Runkleisms. It's awesome. Okay, we're watching in the right-hand side window. That is the live view from court, or it will be the live view from court as soon as the camera gets turned on. And then the other window is just my camera, which looks a little dark. What's happening there? Let's see if we can lighten it up. Let's go down a bit. Yeah, that's about it. Ian, Emily, and Rob together is fun. They are the pillars of Law Tube. There are a couple others, but they're good. Busy the Gamer Mom says, I forgot to share that I bought a metal detector for last month. It was a cheap one, but it got here fast. We were trying to locate a lost cell phone on the side of a country road. Should be a pretty easy find. What I'd suggest, if this is as someone who loves metal detecting, this is what I would do. If you have or know anybody who has the same cell phone, like the same brand, if it's an iPhone 12 Pro, another iPhone 12 Pro, get that out and find an area of the ground where there's no signal and set that one on the ground, and then adjust the settings on your metal detector so that it alerts when it goes over the iPhone, but doesn't alert when it goes over, say, nails and other items. And you can do that on some metal detectors. Depends how cheap yours is. But you're basically setting the discrimination, telling the metal detector, this is what I want you to beep when you see, and then it allows you to cover ground a lot faster. That's how I find, say, like a lost earring. I'll say, well, give me the earring that you didn't lose. That will help me find the one that you did. And it actually works. You can tune detectors to find a specific item or look for a specific signal that way. Cell phones are a little harder, but because there's so many materials in them. It should be easy. Rob is okay. He's just working. We have confirmations that life's just busy right now. Have you ever tried magnet fishing? Briefly. I've filmed a lot of magnet fishing. I was a cameraman for a metal detecting, magnet fishing, and relic digging convention event. So I filmed a fair amount of that. It's just messy. It's dirty. The mud and the muck and the stinky goo at the bottom of the river is just... That's why I don't... Natalie Lawyer Chick has been doing YouTube law for quite some time. Yes, another one. Been around for a long time. Good stuff. Good people. Stinky goo. You don't know unless you know. And once you know, you know. Yeah, the mud at the bottom of rivers and canals. It does not smell good. Think how it got there. Ducks swimming by, fish eating and then swimming by. It's not good. It's not good, I tell you. Yeah, fish poop. Well, that just ruined me a chance of ever magnet fishing. It shouldn't. Just wear gloves and a mask. A canal's going to be a lot worse than a river. River mud's not bad at all. That's more like silt. But if the river is extremely slow moving, we're talking Mississippi. I guess I've never seen how fast the Mississippi moves, but I assume that it's slow. We are going to be back in about 6 minutes, according to the judge. Are they on break or done for the day? They're on break, lunch break, and we're working through it. It's anaerobic activity decomposing the junk. As I said, it stinks. Mississippi mud is special. Feels good between your toes, right? Biohazardous hobbies sounds cool. Sign me up, says Potato Smiley Face. Last week, the Shenandoah River was so low and warm, you could walk across it. Isn't there a song about that river? Someone magnet fished my iPhone and keys I lost in the river and searched my medical ID on Facebook and mailed them to me. Shelbster, that's awesome. It's always fun to be able to return an item when it's lost. I've had some experience. I was able to return some cell phones that I found at the beach. I found an iPhone underwater at the ocean that was lost 2 days before, and the battery was still on. I pulled it out. It was still turned on. It was still good. We were able to get it back to them. I found a wedding ring. I was able to return that to the owner. I also found a gold coin, a $5 New Orleans Mint gold coin that was able to return that to the guy who had stolen it from his mom's jewelry box and lost it 75 years earlier. Incredible story. It was so much fun. Highlight of my metal detecting career. How's the house fixing going on for this Sloth Life? I don't want to talk about it right now. It's not going well. I did a project in one of the rooms, and now I have to redo that project. And it involves a week worth of work. And we're changing how the AC is upstairs, the attic AC, which is 120 degrees up there. We're changing how it drains the overflow pan because it overflowed again after I fixed the ceiling one time. So yeah, it's we have to install a little moisture sensing sump pump type thing. It's not fun. Couple getting married, dropped the wedding rings in the grass. My brother found them with his detector in 3 minutes. Oh, it's so much fun to do, especially when there's no way we can find them. And you're like, give me 2 minutes or 3 minutes. How do you trace a coin back 75 years? In this case, the property was still owned by the family, and the story about the coin being lost was like a family legend that had been passed down. And so the relatives of the great uncle or whatever it was that had lost the coin got permission for me to search for it, told me about what the story was and where it happened. We went to the property, got permission from the aunt that owns it, and metal detected it. And as soon as I heard the coin, even though it was about, I'd say 7-8 inches deep in the ground, I knew exactly what it was. It rang like a bell. And if you've used a metal detector for, I don't know, probably 500 hours like I have, you get to understand what the detector is telling you by the types of beeps it makes. And it just sounded like gold. And it was. We dug it up on camera, had the imprint of the eagle on the or the imprint of the face on the dirt, and had the young grandnephew, I think it was, I don't forget the relation, actually find it with the pinpointer in the clod that I had dug up, and then obviously because it's theirs, it's not mine just because I found it. They kept it and took it back and were able to give it back to him. So now just in addition to just being like a family legend, it's now a family story. It means a lot more to them than it would to me, but that's really cool. Gailey May gifted a membership. Thank you. Can I get a TLDR? Too long didn't read on why you're moving. We just think it's time. That's sort of the same thing that brought us out here to North Carolina. We just think it's time to move, and we're looking. What does a $5 coin look like? It's funny you should ask. This is from July 31st, 2021 was when I found it. Hang on, I need to turn off a couple things so it doesn't. I'll do it this way. Go full screen here. Can you see it? 1943. I think I said 34 before I transposed the dates. That's the coin right there. And that's in my hand. So they're small. They're smaller than you'd expect. It's not like a big coin, but they're nice and heavy. And they come out just as shiny as the day you dropped them, because gold does not tarnish. Yeah, hand for scale. Yeah, I'll get a post office box in a different state, and then I'll never go get in the mail. We do like this house. It has a lot of personality. Unfortunately, a lot of the personality requires a lot of upkeep and care, and it's like owning an old boat. about done. No, not going back to Utah. I can't afford Utah. Like even if I wanted to, I don't think I could go. It's just too expensive. Brooke, it helps that I'm able to work from anywhere. It looks like we have court coming back. There we go. We're a minute late. Let's see if the judge bangs the gavel. I can tell you we're going to be going west. We want to be closer to our grandbaby for sure. But how far west, I don't know. But I'm on the East Coast, so everything's west. I like Idaho. Their fishing laws are a little confusing. I don't like that. Weird seasons and limits, and if you're on this stretch of the river, you can keep 2, and on that stretch you can keep 4, but you can't catch 4 from there and then walk onto this stretch, or else you're in violation. They've got some weird rules. I can't go to Georgia because I'm banished from there. I'd love to be down in the Texas-Oklahoma range. I like that area of the country. My wife does not like tornadoes, so that might not happen.
You are banished from the state of Georgia.
I am. Texas, we've thought about Texas. I'd like to have land and water. And Texas has land. I'm not sure if it has water. Why are you banished? It's a joke around here. Hope always I'm not actually banished. Georgia scares me a little bit of all the states because of how they run their judicial system and how long it takes to work your way through the judicial system. Hearing people get, pulled into court and they've been serving 200 days without, any progress on their case. So they just got arrested and they've been sitting there for 200 days. That's wild. That's crazy to me. I don't have a house to move to, so no, I'm not moving yet. Have to sell this one first. Yeah, it's Amber's mom's here. I understand moving when you have to, military family, etc., but I absolutely hate to pack things up and move. Just saying, last time we sold everything. Like my family, 6 kids, my wife and I, sold almost everything we owned. The only things we kept, and we're talking like the kitchen table, the grandfather clock I inherited from my grandpa, some book collection, a little bit of clothes. It fit in 14 feet of a moving truck. So if you measure from the front to the back, think the smallest U-Haul you can rent. That's still a self-driving vehicle, not a trailer. Everything we owned fit in that. And we shipped it across the country, and then we had to start over from scratch. We showed up here, no beds, nothing. I'm not allowed to pick the house. This is correct. I chose this house, and I lost all house buying privileges. I bought this one without my wife ever seeing it. How long have you been in North Carolina? About 7 years. Yeah, we could have shipped a pod. It would have fit in a pod, or maybe even half of one. Any second now, we'll be back. Grew up in Missouri and will never live there again. Judy, my wife, helped me part with things that I had a hard time parting with. She's like, it doesn't give you joy. It was the KonMari thing. If it doesn't bring you joy, it goes. So, high school yearbook. Gone. Come to Houston. Houston might be a little too hot for us. Arkansas is beautiful. Marie Kondo, that's the one. That's the lady. But it was fun. We got to give away some stuff that I'd never use again, or at least wouldn't for a long time. My ice fishing gear, have no need for that in North Carolina. So gave away a bunch of that. My kayak. Got rid of my motorcycle. I'm still sad about. North Idaho. I could be up there by the Ambition Strikes folks on YouTube. Love that channel. Not true crime related. They fix up houses and boats and cabins, and they're a project family. They're a lot of fun. Montana. East Texas, Piney Woods. Come to Canada. I don't know. I've heard rumors about Canadians, and
because we here in Canada hate you and hope for bad things for you because we hate you.
Yeah, see? I'm not sure if Ian would let me move up there. Screw it, Alaska. That's not going to happen. Too cold. Although I was watching the bears with the salmon jumping this morning. Man, some of the salmon just can't figure out how to go upstream. Here we go. We're back, you guys.
Seated.
Sound effects off. We're serious.
Court is now in session, noting the presence of all counsel and all parties. All right, Mr. McBride, turning to the state.
Yes, Your Honor. Just by way of preview, we are going to call Jen Falmuina, Sergeant with the SBI, but how we're going to proceed is we're going to call her for a very limited purpose. We're going to pause her testimony. Defense is not going to cross at that time, and we're going to call an FBI DNA analyst out of order. It's a defense witness, but that's to accommodate that witness's schedule. State calls Sergeant Jen Falmuina.
So defense does get to put some witnesses on during this.
I'd like to come forward and be sworn in. All right. After you're situated, there should be a bottle of water to your left, maybe behind the monitor. And if you wouldn't mind just bringing that microphone just a little bit closer to you so it picks up your voice for the recording. Mr. McBride, your witness.
Will you please state your name?
Yes, Jennifer Famuina.
Where do you work?
I work for the Utah Department of Public Safety.
What position do you hold there?
I am currently a sergeant within the State Bureau of Investigation.
What was your assignment September 10th, 2025?
I was assigned to oversee the crime scenes as well as the physical evidence.
And were you sergeant with the State Bureau of Investigation at that time as well?
Yes.
And do you have any kind of specialty in your assignment there?
Yes, I do. I am currently overseeing, or I am the lead over our evidence response team within our division. That includes not only conducting training, but also attending training and whatnot.
Okay. So if we hear ERT, it means Evidence Response Team?
Yes.
Were you called to the crime scene at Utah Valley University on September 10th of 2025?
Yes, I was.
And were there multiple scenes that you oversaw or helped to process?
Yes.
We've had some testimony about the rooftop of the Low C Center. Did you oversee or are you aware of evidence that was collected in that area?
Yes, I am.
Was there a screwdriver that was collected from that rooftop?
Yes.
And do you know how that was collected and what happened to that screwdriver?
Yes, that was collected by the Utah Bureau of Forensic Services Crime Scene Response Team, or also known as our State Crime Lab.
And do you know what happened to that?
Yes, it was packaged, and then that evening there was discussion on who would take custody of the evidence, and I was there along with FBI. Then it was decided that FBI would take custody.
And did that evidence actually go to the FBI?
Yes, it did.
And was it sent for testing?
Yes, it was.
Where was it sent, do you know?
It was sent back to their equivalent of our crime lab.
Okay. Are there other areas there at Utah Valley University that were also processed for the presence of evidence?
Yes, there was.
Is there a wooded area that's northeast of campus?
Yes.
What was found in that wooded area?
What was found there was a long gun that was wrapped in a dark colored towel.
And you say a long gun. What does that mean, a long gun?
Sorry, that would be a rifle. So to be more specific, it was a Mauser 98 rifle.
Do you know what caliber that was?
It was retrofitted to a 30-06 barrel.
And do you know what kind of action that had? Was that a semi-automatic, automatic, bolt action?
It was a bolt action.
What is a bolt action rifle?
I'm not too familiar with guns, but I just know there's a bolt and you have to pull it back.
Okay. And what was done with that weapon and that towel?
That was documented in place, and then eventually pictures were taken. It was documented in place, and then afterwards we rendered that gun safe, and then packaged the gun as well as the towel.
What was done with the towel after it was packaged?
The towel was also provided to the FBI.
And those two items, well, let me tie up that thread. The gun, what was done with the gun?
The gun was packaged. It was taken to FBI custody, then eventually it was provided to the ATF lab.
Okay, so the gun went to the ATF lab. Is that correct?
Yes.
The towel went to the FBI lab.
Yes.
And the screwdriver went to the FBI lab.
Yes.
Did you receive reports back from testing that had been done on those items?
Yes, I did.
I'd like to show you State's Exhibit 31. That's connected to the defense computer right now. Is there any way to switch it? Thank you.
What was that sound effect?
Okay, I'm showing you here on the screen.
I think it was the judge drinking.
State's Exhibit 31. Do you recognize that?
Yes, I do.
What is that?
This is the FBI report that was provided to me by the FBI that documents DNA testing.
And does that include testing that was done on the screwdriver that we've spoken about and the towel that we have spoken about?
Yes, it does.
Okay, what I'd like you to do, Kimberly, if you'd please just scroll down so that Sergeant Falmuina can observe this exhibit. If I can have just a moment.
The Mauser 98 normally wasn't 30-06. That's a retrofit barrel, she said. I think it's a 7.62, isn't it? 7.92.
And can you see who that report is signed by?
Yes.
Who's that?
Amanda Baker, I'm assuming is how you pronounce your last name.
Is that, in fact, the report that you received documenting the testing results on these items and some other items from the FBI?
Sorry, yes.
And does it appear to be in an accurate condition as to how you received it?
Yes.
I'd move the admission of State's Exhibit 31.
Defense?
No additional objections.
No objections. So I'll note the standing objection, and as it relates to admission, what is your request as to publication?
I'd move this admission and its publication both to the court and to the public.
All right. Anything further, Mr. Burt? No. All right. The court will admit State's Exhibit 31 into evidence and allow publication of this exhibit to the gallery and to the monitor on screen in the courtroom and for the camera to broadcast.
Okay, if you'll go to, Kimberly, if you'll scroll down to, still on page 1, where the screen will show items 7 and 8. Sergeant Falmuina, do you see the lines there that say item 7, that line?
Yes.
And will you read that portion of the report that describes what item 7 is?
Item 7, TOW from around Mauser rifle, serial number 8863.
And there's also some other identification numbers. Is that the towel that you found with the rifle that day?
Yes, it is.
On September 10th?
Yes.
Item 8, will you read what that says is a description of item 8?
Item 8, screwdriver from perch.
And is that the screwdriver that you described that was collected from the rooftop?
Yes.
Okay. If we can go to page 3 of 6, please. Will you, item 7, sub 1, will you please read the result there from the title item 7 until the word contributors?
Objection cumulative.
And would you mind repeating that, but with the microphone? I want to make sure that the record picks up your objection. All right. Either way, if you want to come up, that's fine, Mr. Burke.
Judge, the objection is that her reading to the court what's in the report is cumulative, since we have the analysts here who will be testifying to what the report says and what it means. So you've got the report in evidence. We don't need this witness's reading the report to the court. So it's a 403 cumulative objection.
Mr. McBride, do you wish to respond?
My point is only to draw your attention, Your Honor, to the relevant results that will be discussed by the other expert, as well as the results of the items we've discussed, the towel and the screwdriver. That's all.
All right. The court will overrule the objection and allow a brief overview of it, not going line by line, page by page. So if it is brief, I'll allow that.
Thank you. So if you'll read item 7.1 to the word contributors at the top of that page, if you will.
Yes. Male DNA was obtained from item 7 sub 1. Item 7 sub 1 was interpreted as originating from two individuals, one of whom is Twigs. The DNA results from item 7 sub 1 are 1.7 octillion times more likely if Twigs and T. Robinson are contributors than if Twigs and an unknown, unrelated person are contributors.
The way she says Twigs.
Let's skip down to item 8.1. Do you see that bolded and underlined line there?
Yes.
And this is relating to swabs of the handle area of the screwdriver. Is that right?
Yes.
Will you read those same two paragraphs there? Male DNA ending with contributors.
Male DNA was obtained from item 8 sub 1. Item 8 sub 1 was interpreted as originating from two individuals, one of whom is Twigs. The DNA results from item 8 sub 1 are 30 quintillion times more likely if Twigs and T. Robinson are contributors than if Twigs and an unknown, unrelated person are contributors.
So Twigs' DNA was the primary one.
A couple of foundational questions before we finish for now. First off, do you know who Twigs is?
Yes.
Who is Twigs?
Twigs is Lance Twigs. He was a roommate of Mr. Tyler Robinson.
And do you know if Lance Twigs' DNA was obtained for comparison in this test?
Yes, it was.
And how was that DNA obtained?
It was obtained by law enforcement officers.
And was that by a buccal swab?
Yes.
What is a buccal swab?
A buccal swab is basically like a Q-tip or a swab that we'll just place in someone's mouth and just scrub the inside of their mouth to obtain the cells.
And then that Q-tip is then packaged and sent to the lab for testing and comparison?
Yes.
And was the defendant, Tyler Robinson's DNA, also collected in the same manner?
Yes, it was.
Okay. Thank you. Nothing else.
Right. Mr. Burke, cross-examination?
No. No cross right now. He's not using the mic.
Oh, would you mind grabbing the microphone? I just want to make sure what you say is on the record.
With the court's permission, I'd like to reserve the right to cross-examine on the area she testified about until she's completed her testimony.
Okay, okay, I see what you're saying. Any input, Mr. McBride?
That's exactly what they agreed to. They stipulated. Use the mic. Come on, people.
Your Honor, that's what we expected to happen. We discussed this beforehand. We stipulate.
All right, that's fine. And so should I have the sergeant step down or?
Yes.
Okay. Sergeant, if you'd like to step down, you're still under oath, and so please don't discuss your testimony with anyone. And is she being asked to exit the courtroom, or what's the request of the parties?
Yes, to exit the courtroom at this time.
All right, Agent, if you wouldn't mind exiting the courtroom, and then we'll come get you when we're ready for you. All right? Thank you.
And now we're taking a defense witness out of order.
All right, Mr. Burt, turning to you.
Your Honor, out of order, the defense would be calling Amanda Baker.
All right, Ms. Baker.
This is usually done because the availability of the witness is quite
All right, Ms.
limited.
Baker, if you wouldn't mind coming forward right up here by the bailiff and being sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, Ms. Baker, if you wouldn't mind being seated at the
Attorney
witness
the lectern.
stand. Once you're situated, there should be a water bottle for you if you'd like behind the monitor. And after you're seated, if you wouldn't mind just pulling that microphone close to you so it picks up your voice, okay?
Okay.
Mr. Burt, your witness.
Your Honor, we're going to need the monitor switched over to our side if we could. While we're doing that, good afternoon.
Good afternoon.
Tell us your name, please.
Hi, good afternoon. My name is Amanda Baker. My last name is spelled Bakker.
Ms. Baker, what do you do for a living?
I am a forensic examiner in the DNA casework unit of the FBI laboratory located in Quantico, Virginia.
And how long have you been a DNA analyst at that location?
A little more than 10 years.
And just in general, what are your duties?
My duties are to manage a case. When a case comes into the DNA casework unit, I will review any information associated with that case. I will review any evidence that is submitted for that case, determine which items of evidence need to be tested and which tests need to be performed. I will then create something called an exam plan. You can think of this like a to-do list to let the biologist know which items I need tested. Once that testing is complete, I will review all the data, draw conclusions in the form of a report, and then testify if needed.
Ms. Baker, in this case, were you requested by the state of Utah to do certain testing?
Yes, I was.
And when were you called upon to do that testing?
That was September of 2025.
And do you recall when the case first came into your lab?
I believe we received evidence the first time was September 11th of 2025.
And just in general, when the FBI, your unit receives evidence for analysis, is it true that the turnaround time is about 200 days?
It depends. We've wavered between 90 days and over 200 days. I would say on average, it's somewhere between 180 and 200 days.
However, did this case come in on what's called a priority 1 level?
Yes, it did. And what that means is we worked 24 hours a day, 7 days a week until examinations were complete.
And is it true that you were conducting the analysis as the evidence was being inventoried?
That is true. Because of the high-profile nature of this case, an item of evidence would be submitted to the lab. It would be inventoried by our evidence management group and then sent to the various units for testing, for example, the DNA casework unit. We would begin testing as additional evidence was being delivered to the FBI lab.
Now, as a result of your analysis, do you produce case files?
Yes, I do.
And document your examination in other ways?
Yes.
Do you have your case file with you?
Yes, I do.
Okay. And in your case file, are there notes of conversations that you have with people that are relevant to your testing?
Yes, that's called our communication log.
Now, do you have your case file there in front of you?
Yes, I do.
I think the pages are numbered. So I'll ask you to go to page 22 of your case file notes.
Okay.
And if I could direct your attention to the bottom of that page, there is a communication log entry dated September 13th. Do you see what I'm referring to?
Yes, I do.
And would you read to the court what your entry is for that date?
Yes. This is my communication communication entry on September 13th, 2025. All. Spoke with FBI Special Agent Folger and Utah SBI SA Dave Hull. Gave technically reviewed results that Robinson was included as a possible contributor to the DNA from the towel and the screwdriver. We discussed the additional examinations conducted by DCU, and they both agreed that no additional immediate comparisons are needed at this time. All remaining comparisons will be in the laboratory report.
Is that an accurate reflection of what you told the agents at that time?
Yes, it is.
And you told them that, quote, Robinson was included as a possible contributor to the DNA from the towel and the screwdriver, correct?
Yes.
Was the language that you used in conformity with requirements that you have for reporting out test results?
Yes.
All right. I'd now like to direct your attention, if I could, to exhibit number, State's Exhibit 31, which is in evidence, and I think it's our tab 2. And that's in evidence, so if you could display that on the screen.
And Mr. Bird, are you requesting it to be displayed to just your screens or to all screens?
No, since it's in evidence, Your Honor, I'd like it displayed to the public.
Okay, let's go ahead and put it on the main monitor as well.
Okay, could you go to page 6, please? And highlight the third paragraph. This is your report dated September 15th, 2025, correct?
Yes, that is correct.
So this is 2 days after you had the conversation with the agents as to what your results were.
That is correct, yes.
They use
And in your report that
probabilistic
you
genotyping.
wrote 2 days later, you included this language that's highlighted there, correct?
That is correct.
This report conforms to the Department of Justice uniform language for testimony and reports for forensic DNA examinations. Correct?
Yes.
Okay. Now, I'd like you, if you could, to take a look at that standard that you referenced. And then I believe is that, and this will be just to the witness, not to the public.
Okay.
Calling up tab 7. Do you see that on your screen?
Yes, I do.
Do you recognize this document?
Yes, I do.
And tell the court what this is.
This document is the approved standards for scientific testimony and reports for autosomal DNA testing.
And is this the document that you were referencing in your report?
One of them, yes.
And is it a true and accurate statement of what the policy of the FBI is in regard to reporting DNA in a case of this type?
Yes.
I move that document into evidence, Your Honor.
So is it just this page or all the pages? Because it says 1 of 6.
Yes, so this would be the entire document.
Mr. McBride?
I don't see the relevance of this document. I object on relevance grounds.
There's an objection.
Mr. Burt?
Your Honor, the document is referenced in a report, and it defines the parameters of what her opinion means. So I think it's very important for the court to understand the limitations of the opinions being expressed.
And just for my understanding, when you say in her report, are you referring to State's Exhibit 31?
That's correct.
All right, Mr. McBride, any further thoughts?
No, I'll submit it.
All right, so State's Exhibit, well, I'm sorry, how am I labeling this exhibit for the defense?
Your Honor, we have our exhibits organized by witness, and we would be submitting to the court electronic copies of these under named witnesses. So this would be Baker 7.
All right, Defense Exhibit Baker 7 is admitted into evidence, and as it relates to publication, what is your request, Mr. Burt?
Your Honor, I would ask that this be published since the report is published, and this is important to understanding the limitations of the report.
And so published in the courtroom and on the monitor for the media?
Yes,
Okay.
correct.
Any thoughts, Mr. McBride?
No objection.
All right, it will be admitted and published both in the courtroom and on the monitor for the video camera.
Okay, so this document has various subjects, correct?
That is correct, yes.
And it, in the beginning, tells you how to frame your testimony in terms of inclusions or exclusions, mixtures, sex determination, et cetera.
Correct, yes.
And then there's a section called Statements Not Approved for FBI Autosomal DNA Testimony in Our Laboratory Reports.
That is correct, yes.
Okay, so if we could go to page 5 for that statement. Okay. Under the topic absolute identification, is it the policy of the FBI when you're reporting out results that an examiner may not state or imply that a match provides an absolute identification of the individual from whom the biological material originated?
That is correct.
And you were following that policy in this case when you told the investigators that this was a possible match, correct?
That is correct, yes.
You never said it was an absolute identification of Mr. Robinson, did you?
Correct, no, I did not.
Now, the second guidance under that policy is an examiner shall not use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony unless required to do so by a judge or applicable law. You're not, in your report, did not use any language that suggested you were giving an opinion to a reasonable degree of scientific certainty.
That is correct, it was not.
Okay. And then the next one, not that one more down. Not going to talk about race, ethnicity. That doesn't apply to this case, right? But 5.4 says, an examiner may not state or imply that forensic autosomal DNA examinations have a 0 error rate or are infallible.
That is correct.
And you followed that policy in this case, correct?
Yes, I did.
You're not in your report stating to the court that your testing has a 0 error rate, correct?
Correct.
You're not saying that the test is infallible.
I am not, no.
What is the source of error rates in DNA testing?
I'm
You can
sorry.
take that down.
Can you clarify your question?
Yeah. When it refers to don't state that there is a 0 error rate, what in general are the sources of error in DNA, in the kind of DNA testing that you do?
Human error could be an error.
Mm-hmm. Anything else?
Nope.
Not that I can think of off the top of my head. One of the big things is potential human error. I guess you could also associate the DNA testing itself and how items are collected or how those items are tested.
Now, to your knowledge, that policy statement that we just read in Exhibit 7, Baker 7, was based on a more general Department of Justice policy, correct?
Correct, yes.
And that policy is called the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examinations using probabilistic genotyping systems, correct?
That is correct, yes.
And could you display 8 for us, please, to the witness? Let me know when it's on. No, not on the big screen.
Okay, so not to go onto this main big
Correct,
screen.
this is
Thank
just
you.
for the witness. And you're familiar with that policy, correct?
Yes, I am.
Okay. And does it contain a statement that support for inclusion is an examiner's conclusion that there is evidentiary support for the inclusion of a known individual as a possible contributor to the DNA typing results obtained from an evidentiary sample?
I believe it does, yes.
And did you follow that procedure in this case?
Yes, I did.
All right. Does this same policy state at page 4, fourth down, one more. No, next one. An examiner, does a policy state, an examiner shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample?
That is correct, yes. It does state that.
And you followed that procedure in this case, did you not?
Yes, I did.
You're not implying that those numbers that a previous witness quoted in our State of the Union report provides an absolute identification of Mr. Robinson or Mr. Twiggs?
No, I'm not.
Okay. Thank you. You can take that down. Are you also familiar with a concept called formal activity level?
Yes, I am.
Tell the court what that is.
Formal activity level is determining an activity that causes DNA to be left behind on an object.
And does your laboratory have a policy about whether you can express opinions about formal activity level?
We do have a policy, and I cannot give an opinion as far as activity level goes.
And why is that?
That is because DNA can be left behind on an object for numerous different reasons. So just because DNA is on an item doesn't necessarily mean that an individual touched it or utilized that item. So because of that, we do not opine on what activity may have occurred.
And consistent with that policy, you cannot tell, if you interpret a piece of DNA as being present on an item, you can't tell when that DNA was deposited, correct?
I can't give an exact time, but there are some situations, if a piece of evidence has been buried for a long time or is in a river for a long time, it would be my expectation, based on my experience, that I probably won't get DNA off of an item that's been buried for 10 years, for example. However, I cannot give exact timing as to when DNA was deposited on an item.
And I was talking more about a situation where you actually find DNA on an object, be it a gun or anything else. You can't say when that DNA was deposited, correct?
Sure, that's correct.
And how long, in general, does DNA persist on an item? Once you've made contact, how does DNA get deposited on an item in general?
In general, DNA can be deposited a few different ways, via body fluids such as saliva or blood, or skin cells. So touching an item or wearing an item, DNA could be deposited. Once DNA is on an item, if it's subjected to ideal conditions, it's out of heat and high UV, it's not subjected to any kind of cleaning or chemicals, it can persist on an item rather indefinitely. It can degrade slowly over time, but we've certainly worked items of evidence that are 40 and 50 years old, and we've been able to recover DNA.
Now, could you explain to the court the concept of degradation of DNA samples, what that means and what it suggests with your testing?
Sure. So degradation of DNA is breaking up the DNA. So if you think of DNA like a long rope, it's essentially taking that rope and cutting it up into pieces. Seeing degradation in a sample could lend me to believe that there may be, that sample may have been subjected to cleaning or high heat an extended period of time. So I can't tell why an item is degraded, but looking at my data, I can tell if that sample is potentially degraded or broken down.
And two of the items that you examined were referred to as items 7 and 8, correct?
That is correct, yes.
One was a towel and one was a screwdriver.
That is correct, yes.
Were both those samples degraded to a certain extent?
May I refer to my
Certainly.
data? So item 8 was the screwdriver from the perch. I would say that there was some degradation. As I look at the DNA peaks or the DNA data, in an ideal world, if there's no degradation, I would expect all the peaks to be at the same height. Here I see a ski slope type effect, meaning that the data on the left is a little bit taller than the data on the right. As far as item 7, item 7 was the towel. There was a slight amount of degradation, but not as much as item 8.
Okay. And what is the effect of degradation on production of the allele? First of all, what's an allele?
An allele is an individual's DNA type. So we inherit half of our DNA from our mom and half of our DNA from our dad. We're looking at something called short tandem repeats, or STRs. These are small segments of DNA that repeat themselves over and over again. We all have those same sections of DNA, but what might differ amongst us is how many times it repeats, and that's actually what we inherit from our parents. So for example, at one particular location, my mom may give me 14 repeats and my dad may give me 15. So when I'm looking at the DNA types, I would say that I have 2 alleles at that location, a 14 and a 15. As far as degradation goes, it could cause some of those alleles to do something called drop out, meaning when I'm looking at the DNA chart or the DNA data, I do not see information. I do not obtain numbers at that particular section of DNA.
And is it true that in the testing that you were doing in this case, STR testing, what you were looking at is the length of the, what I'll call, have you ever heard the boxcar analogy?
I have, yes.
Tell the court what that is.
So the boxcar analogy is how many times that section of DNA repeats. So that section is essentially letters. So for example, A, C, T, G. So you may have A, C, T, G repeated 10 times or 12 times. Each of those sections of A, C, T, G would be considered one boxcar.
And so when you're looking for alleles, you're essentially counting the boxcars. Could be 7 boxcars, and that person would be a 7.
That is correct, yes.
And from the mom and from the dad, he may have inherited 10 boxcars.
That is correct, yes.
And so that person at that particular location would be a 710.
Yes.
And what you're doing in your testing is comparing those numbers to what you get from a known sample to see if they match.
That is correct, yes.
Is that true?
Yes.
Now, is it true that what you mentioned the A, C, T, and G, correct?
Correct, yes.
Is it true that you are not measuring the sequence within the boxcars? You're just measuring the length of the boxcars?
That is correct. So the sequence would be equivalent to letters in a word. What I'm looking at is the number of words versus the letters that make up that word.
And we'll talk about this a little later, but people can vary not only in the length of the boxcars, but in the sequence within the boxcars, right?
And that is correct, yes.
And what your testing looks at is just the length?
Correct, yes.
Okay. Now, and is it also true that you're looking across many different locations?
Yes. So at the FBI laboratory, we use a kit called Global Filer, and this is looking at 21 different locations on a human's DNA, in addition to 3 sex-determining locations. That lets me know if an individual is biologically a male or a female.
As between two individuals, 99% of their DNA is exactly the same, right?
That is correct, and that makes sense. We're all humans. We all have arms, legs, and a head. Less than 1% of our DNA is what differs amongst us, with the exception of identical twins.
But with within that 1%, you're looking at these length differences, correct?
Correct, yes.
And you're looking at what you called short tandem repeats.
Yes.
How many, you said you looked at 25 locations?
We're looking at 21 and 3 sex type determining, so 24 total.
What are the sex determining? They're called the locus, correct?
Correct. So locus is that individual section of DNA.
All right. And they typically have names or numbers associated with them, correct?
Yes, they do.
So what are the sex determining loci?
So there is amylogenin, and that lets me know if an individual is male or female. And then there's 2 specific male sex-determining locations. One is Y-indel, and one is DYS 385. Those just let me know that those are specific to male individuals.
Okay. And then for the other locations you're looking at, those you're just looking for 2 types at each location, correct?
Correct, yes.
Okay. Now, for the samples that you looked at, the 7A and the 8A, did you get a full, what's called a full profile would be a profile where you have all 23 locations present?
That is correct. So a full profile means I have DNA at every single location. It is above our threshold, and I'm seeing 1 or 2 pieces of information at each location. For item 7, I did develop a full profile.
For item 8, you developed a full profile?
Item 8 was a partial profile, so I did not develop DNA at every single location.
Okay, so what that means in your comparisons is you have certain information in the question sample that for whatever reason doesn't appear, correct?
Correct, yes.
So you can't make a comparison at those locations?
That is correct.
All right. What makes it not appear at certain locations?
So it could be that there's degradation. So those larger locations could be broken up so that it wasn't detected during the DNA process. It could be a low-level amount of cellular material to begin with. So if I only have a few cells, I may not have enough to detect at every single location.
Okay. And for the 8-1 sample, did you measure Mr. Robinson and Mr. Twiggs's DNA at the 23 locations?
For item 8, I did not have a full profile, so I did not have data at all 23 locations to compare to either Mr. Robinson or Mr. Twiggs.
Right, but you had full profiles for Mr. Twiggs and for Mr. Robinson, right?
For their known sample?
Yes.
Yes. So for their known sample, that was a sample that was taken directly from those individuals, and I did develop a full DNA profile.
Okay. And just to illustrate how this works, is one of the loci that you looked at called the DYS 391 loci?
Yes, it is.
And what type was Mr. Robinson at that loci?
At that location, Mr. Robinson was an 11.
And I think you said you inherit one from your mother, one from your father. but when you say he's an 11, technically, he's what's called an 11-11, correct?
So for this, so DYS 391 is actually that male location, so he would not have, or anybody would not have inherited anything from their mother. So at this location, I would only expect to see one piece of information, and I did see an 11 here.
Okay. And for the D3S loci, what was his type?
His type was a 17.
Now, for that loci, you'd expect two types, correct?
That is correct.
And when you say he's a 17, do you mean he's actually a 17-17?
That is correct. He inherited 17 repeats of that location from mom and 17 from dad.
Other locations, for instance, the VWA, he's type 18-19, correct?
That is correct, yes.
So you're looking at those, and what the machine produces are peaks, correct?
Correct, yes. They're just spikes on a graph, similar to like spikes on a heart monitor.
And you said for 8A, you had certain locations where the test sample didn't have any results.
That is correct.
So at the TPOX location, Mr. Robinson is a type 8-9, correct?
That is correct.
Mr. Twiggs is a type 8-11.
That is correct.
But when you looked at the sample, 8A, it didn't have any of those types.
That is correct. So I could not compare at that location.
Now, are there certain rules for when you exclude someone? In other words, when you're comparing two samples, are there rules which say, here's where I would conclude that he could not possibly have contributed this sample?
Yes.
Your field has a lot of literature written about it, correct?
That is correct, yes.
And do you generally like to keep up with that literature?
I do, yes.
And across time, there have been several books, publications that attempt to educate you and courts and lawyers on the technical aspects of DNA testing, right?
Correct, yes.
One of the books, the early one, DNA Technology and Forensic Science by the National Research Council.
I'm familiar with that, yes.
That's an authoritative book that was really one of the first books on DNA testing.
Yes.
All right? And then by the same organization, National Research Council, the Evaluation of Forensic DNA Evidence.
Correct, yes.
Published in 1996. So you're familiar with that as well.
Yes, I am.
And then there's an author, I believe, who did his research work at the FBI named Dr. John Butler.
Yes, I'm familiar with him.
And you have studied his work both in your training and your continuing education.
That is correct, yes.
And he's got 3 current textbooks on the topic that we're talking about, right?
I'm not familiar with how many textbooks he has. I know at least the one.
Fundamentals of Forensic DNA Typing.
Yes.
Familiar with that. Forensic DNA Typing Methodology.
Yes, I'm familiar with that one as well.
And Forensic DNA Typing Interpretation.
Yes.
Everybody in your field relies on these publications and use them as teaching tools.
Yes, I would agree with that.
And then in addition to those books, there have been studies that have been done on particular topics, correct?
Yes.
This case, we're dealing with mixtures, correct?
Yes.
And mixtures present certain challenges that are not present when the samples are not mixed, correct?
Not necessarily. So first, to define a mixture, that simply means DNA from more than one individual in a sample. So if I were to take a sip from a coffee cup and my husband were to also take a sip, if I were to swab that coffee cup, I would get a mixture, his DNA and my DNA together. As far as it being difficult, you can have some mixtures where there's one contributor that donates a lot of DNA and the second contributor donates a little bit. For DNA interpretation, that is not challenging for me. Where it can become challenging is if you have 4 or 5 individuals within that sample all donating roughly around the same amount, it may be challenging for me to determine if a person is included or not.
And would you also agree that that challenge exists in situations where you have what are called low quantities of DNA?
Again, that could be possible. So I could have low quantities of multiple individuals, which is simply just saying that I can't determine which piece of DNA goes with which individual. So that's possible.
What is drop-in?
Drop-in is where you have environmental DNA that's not inherent to that sample that's detected during our DNA process. DNA testing is very sensitive, so it could be that we have a peak that's detected, like I said, from the environment.
And what is dropout?
Dropout is when you have an allele that is not detected or a piece of DNA information that is not detected. So in the DNA chart, there is no number associated with that particular location.
And degradation can cause dropout?
Yes.
So if you have a person at a particular location that is a type 1415, and because of degradation, that 15 drops out, what you're seeing on your chart is just the 14, right?
That is possible, yes.
And that presents a certain challenge, does it not? Because if the 15 is not there, you could misinterpret that as a type 1414, correct?
Not necessarily. So we have thresholds. We have something called the stochastic threshold. If that 14 is above that stochastic threshold, I'm confident, based on our validation, our testing, and my training, that the DNA type there is only a 14. If that 14 falls below that stochastic threshold, that could be indication that there is another peak. So when I'm interpreting, when I'm comparing, if that 14 is below threshold and someone is a 14-15, I will not automatically exclude them.
What is stochastic effects?
Stochastic effects.
I'm going to object at this point. I think we've gone beyond the scope of preliminary hearing. I think this is getting into 702 material that's not necessary for the probable cause determination.
All right.
Mr. Burt?
I think it goes directly to the reliability of the testing results that the state introduced.
Well, maybe if you brought a book that would say that.
The court has to understand the limitations and the potential sources of error in order to assess whether these results are reliable.
That's probable
And
cause.
In regards to this line of questioning, how far are you going to go on this line of questioning?
I have this one question, and then I'm moving on.
All right, Mr. McBride.
All the next questions.
I'll hold them to that.
All right, well, Mr. Burt, so the objection is overruled. You may proceed with that question.
You can
Said
answer.
I'll hold him to that.
Could you repeat your question, please?
Tell the court about stochastic effects.
Stochastic effects, when you have low-level samples during the DNA copying process, based on how the DNA is copied, you could have alleles that are copied better than other alleles.
Okay. Now, on another topic, I mentioned studies before. One of the studies that you're familiar with is called the PCAST report. Are you familiar with that report?
Yes, I am.
And tell the court what that is.
PCAST report is, PCAST stands for the President's Council of Advisors on Science and Technology. And this was a committee that was found, I believe, under the Obama administration that gave guidance on different areas of forensics.
Including how to deal with mixed samples and how to deal with samples that have low quantity of DNA.
I don't know that I would agree that it's how to deal with them. They gave some of their concerns on low-level samples and mixtures.
Right. And they also did a follow-up report to assess whether using the kind of software that you used in this case had been established as reliable, correct?
That is correct.
Objection
And
leading.
what was the software that you used in this case to reach your statistical results?
The software is called StarMix, STRMIX.
And the PCAST report specifically addresses whether reliability has been established with respect to StarMix, correct?
I don't believe reliability came into question. I think PCAST thought that there needed to be additional testing as far as mixtures and low-level samples go.
Mixtures and low-level samples that had certain characteristics, right?
That is correct, yes.
Including mixtures where what's called the minor contributor was in the sample below 20%.
That is correct. So the minor contributor would be an individual that donated less DNA to that sample. So PCAS called into question mixtures of 3 or more individuals with that minor or that low-level contributor making up 20% or less.
7 and 8 samples in this case were both mixtures, correct?
Yes, that is correct.
And did you determine what the proportion of mixture was between what I'll call the major contributor and the minor contributor?
So I did not calculate that personally. Part of the StarMix software, it does a couple different things. One, it takes a mixture and it uses math and biological modeling to try to break that mixture into its individual contributors. And then it also calculates the likelihood ratio, which is the statistic that I report. During that process, it does give an estimate of the breakdown of those potential contributors.
And what was, first of all, for the 7 sample, was the minor in there at less than 20%, according to StarMix?
Yes, it was. For one of the runs, when I compared to Mr. Robinson conditioning on Mr. Twiggs, it was a 5% to 95%.
Okay. And how about for the other sample?
For item 8,
Got a little glitch in the matrix there. Backed up a couple seconds.
for item 8, one of the contributors was 11% and the other was approximately 89%.
So below 20%, right?
Correct, yes.
And the concern expressed in this report, which was written by experts in your field, correct?
No, that is not correct. The PCAS report was written by individuals that were not practitioners or any type of laboratory personnel.
Right, but they list the experts who provided input into that report, do they not?
Yes, they did.
One of them was Bruce Bedoli, correct?
Correct, yes.
Who's Bruce Bedoli?
He is a DNA expert within the field.
Well, he was the head of your unit for a number of years before you came on board, wasn't he?
He was, yes.
And he's written extensively on forensic DNA testing, has he not?
He has, yes.
The report also lists Eric Gilkerson, correct?
That name does not, I do not recall that name.
Forensic examiner for the Federal Bureau of Investigation Laboratory.
I don't recognize that name.
How about Bruce McVicker, forensic examiner, Federal Bureau of Investigation?
Objection, Your Honor. I'm going to renew my objection. I think this is beyond the scope of determining probable cause. The standards that apply here are that the court weighs the evidence in the light most favorable to the state and avoids credibility and balancing the evidence at the stage. I think we're far into 702 territory at this point.
Mr. Burton.
I'm not sure I understand the objection into 702 territory. 702 deals with reliability of evidence. That's what the court is here to determine. So again, it's directly relevant to reliability. This report criticizes, for the specific samples she's using here, the reliability of this testing. And her response was, oh, but they weren't experts. But the report indicates that there were experts who were consulted on this report. So I think it is relevant, and I think it goes to the issue of reliability, and it's the only question I have on this area as well.
Anything further, Mr. McBride, or do you wish to respond to that?
Just that 702 deals with admissibility. It does discuss reliability, but it's directly related to admissibility of the testimony at trial under the Utah Constitution and under the robust case law in this area. The court does not weigh the evidence, draws the inferences in the favor most in the light most favorable to the state. And I think we're beyond that point now. We're getting into the admissibility questions.
All right. Anything further, Mr. Burt?
No, Your Honor.
All right, well, as this is the last question, I'm going to overrule the objection, but as a reminder to all parties that this is a probable cause standard, and as it relates to, well, I will just leave it at that.
Are you familiar with that analyst?
No, I'm not.
Okay. Just to close the loop on the PCAST report, what they said in the report was that published evidence
So it wasn't the last question.
supports the foundational validity of probabilistic genotyping with some programs of DNA mixtures of 3 individuals in which the minor contributor constitutes at least 20% of the intact DNA in the mixture, and in which the DNA amount exceeds the minimum required level for the meth.
The
Isn't
meth
that what
what?
they concluded?
That sounds accurate, yes.
And do you know why the level 20% raises reliability issues?
I do not know.
Okay.
Guys, sad news. I'm going to be sick the day that this happens in court in the actual
But
trial.
you do know that in this case,
Sorry.
both your samples had minor contributors below 20%.
That is true, but in this case, it was also only a mixture of 2 individuals.
All right. Now, that's the next thing I was going to ask you about, which is what is NOC?
NOC stands for number of contributors.
And when you use this program, this genotyping program, StarMix, who decides what the number of contributors is?
That's my determination based on my experience and training, looking at the data. That's something I input into StarMix.
Right. And that's a complex determination, is it not?
Not necessarily.
But it can be in some cases, correct?
It could be, if there's mixtures of a lot of individuals and a lot of the peak heights, the size of the spikes are relatively the same, it could cause some trouble for me as an examiner.
All right. One of the groups that studies your field is the National Institute of Standards and Technology, correct?
That is correct, yes.
They're in the Department of Commerce,
I believe so, yes.
federal agency.
Yes.
And they published a report in 2024 called Forensic DNA Interpretation and Human Factors, Improving Practice Through a Systems Approach. You're familiar with that publication, right?
I am, yes.
And was that a publication written by scientists?
I don't recall exactly who the authors of that publication were.
Okay. Just to make sure.
Last question has a lot of different answers.
That the it's a long report, right?
Yes, it is.
And you've read it.
I've read highlights of it.
Is it true that one of the things that they say in that report is they have a section on the complexity of number of contributor estimations?
Objection.
Are you,
Same objection, Your Honor. This is beyond the scope of a preliminary hearing. Again, we're talking about expert reports. We're talking about scientific studies. These materials are all fine to consider at a 702 admissibility hearing. At this stage, where, again, the evidence is viewed in the light most favorable to the state, this is unhelpful to the court's determination, and therefore irrelevant to this proceeding.
Thank you, Mr. McBride. Mr. Burt.
Your Honor, I think the report that the state put into evidence, as clarified by this witness, indicates that she reached the conclusion that Mr. Robinson and Mr. Twiggs were, quote, possible contributors to these 2 samples. And so the one thing the court has to weigh is what is the weight of that opinion given the science or lack thereof? And one of the important issues here is how she derived these statistical numbers. And as an offer of proof, I'll indicate to the court that the numbers derived from this software program, and that software program is dependent in large part on how many contributors the analyst puts into the input of the software. And the numbers can change if the number of contributors is changed. And in this case, as I'll show through the examination, this examiner originally thought there were 3 contributors. And I will show to the court why she changed her analysis, and will indicate through this publication that there has been criticism of the way in which she determined the number of contributors. So I think it's important for the court to assess whether you've got accurate numbers in front of you. The state put in these astronomical numbers and are asking the court to give weight to them. And I'm asking the court to consider how those numbers were arrived at and whether there are reliability issues with regard to those numbers.
So the concern that I have is, I turn to State v. Ramirez in 2012, UT 59, in paragraph 10. It states, furthermore, the magistrate's role does not encompass an assessment of whether such inference is more plausible than an alternative that cuts in favor of the defense. That is a matter of fact-finding, which is left for the jury at trial. And so when I'm staying in my role as a magistrate, I hear what you're saying, but my concern is based off case law that dictates what I as a magistrate should be doing. If I want to stay in that lane, my fear is as we go down further down this path, which again is not precluding if this were to proceed, if there were a bind over, if there was a trial, that certainly that could be determined. But at this point, at this stage, how do you weigh this issue as I'm weighing State v. Ramirez in deciding whether we're going past the probable cause stage?
Sure, and I think the answer to that is we have to take into account the ruling that you made in this case, which is the law of this case, which is when we objected to the hearsay aspect of these DNA reports and other reports, you ruled that you are the ultimate determiner of the reliability of the hearsay evidence being admitted. And you will recall that our argument was the statute was unconstitutional because it was dictating that you find certain evidence to be reliable without considering whether it was reliable. And your ruling, as I understood it, was no, you retain the ultimate determination of whether the evidence is reliable. And that's not a credibility issue. It's, is this reliable hearsay that the state is offering? And so issues that go to whether these numbers that the state is putting in front of you are reliable, I think go directly to the substance of your ruling, which is that your role here is to determine reliability of evidence. And I'm familiar with a case that the court cites, but I think that has more to do with weighing evidence and making credibility assessments, whereas I'm focused on what the court ruled, which is we have to look at reliability here, and that's my job as a magistrate.
Mr. McBride, any final thoughts?
Yes, under Rule 1102B4, this the Exhibit 31 is considered reliable hearsay. In addition, credibility determinations are not proper for the court to make here for the whole reason that, you know, studies supporting this science, studies opposing this science, testimony from this expert or that expert about what is reliable, what is not, what's more reliable, what's less reliable, factors that affect all those determinations. Those are all very, very complex decisions. There will be probably multiple day hearings dealing with that. And a probable cause determination is just not the place to conduct that kind of thorough, in-depth, and searching analysis. Rather, the case law, the Constitution of Utah that says the only purpose of a preliminary hearing is determining probable cause, the case law, the rules that all say the court does not weigh the evidence at this stage, but leaves that for a finder of fact, the jury, in the end. That all supports cutting this line of questioning off at this point rather than going on for into greater depth, Your Honor.
All right. Well, based off what's been presented before me, I'm going to sustain in part and deny in part the objection made. I'm going to allow this question to be asked, and so that is denying, but sustain in the sense that this would be the last question, and if Mr. Burt would chooses to, may go on to a different subject or a different line of questioning.
Sure. Did that NIST report conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
Can you repeat that?
Yeah. Did the report, the NIST report that you referenced, conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
I think that goes to the DNA evidence. Again, we never truly know the number of contributors in a forensic sample. So, like I mentioned before, you could have DNA mixtures that are made up of 2, 3, 4 individuals. I have training, I have experience, I followed standard operating procedures. So I'm making the best determination based on the evidence, the DNA evidence that I have, as far as number of contributors goes.
Now, if I could, I'd like to return to your case notes, and could you display for the witness page 365 of tab number 4? And while he's doing that, by the way, it's true that if you change the number of contributors, you're going to get different numbers from the software program.
It depends. So actually, each time you run the software, you will get a different number based on the math that the software system does. But there are studies and validations that show we don't expect that math to be greatly different, usually by a factor of 10. Changing the number of contributors, it depends. If you have a major contributor, someone who's made up most of that DNA profile, if I originally interpret something as 3, calculate a statistic, if that major contributor is the individual that I'm comparing to, if I change the number of contributors to 2, based on the studies and based on my own experience, it doesn't change the likelihood ratio of that major contributor by much.
But it does change it, correct?
Yes.
And you just said, I think, that even when you put in the same parameters, you don't get the same answer if you run it through STR mix more than once, right?
That is correct. Based on how StarMix utilizes math and distributions, you will never get the same answer twice, but it will be no more than a magnitude of 10.
So that test is not reproducible in the sense that you can run it a sample or your assumptions in there 10 times, you could get 10 different answers.
That is true. Again, all within the first time I run StarMix, I'm not going to get a likelihood ratio of 10, and the second time get 10 quadrillion. I might get 10 quadrillion the first time, 2 quadrillion the second time, but even if I run it 10 times, I'm still going to get around the same likelihood ratio value.
Now, could you look at tab number 4, your case notes at page 365, if you could bring that up for the witness? Let me know when you have that in front of you. I think you need to scroll up one page. There we go. Can you identify this page from your notes?
Yes, I can. These were notes that my technical reviewer made, and my technical reviewer, they will review all of my DNA evidence. They will draw their own conclusions as far as number of contributors and comparisons, then compare it back to my conclusions.
All right, so this is regarding the 7 sample, correct?
That is correct. That is one of the samples.
And your original assessment was that there were 3 contributors to this sample, right?
That is correct, yes.
And that conclusion was reviewed by a reviewer, correct?
Correct, yes.
She read the same electropherograms or the name for the output of this technology you use, correct?
She utilized the same electropharogram, which is the chart that the DNA is on.
And does this page in front of you, is that an accurate representation of your case file?
Yes, it is.
So I move into evidence page 365, and that would be Baker 4.
Mr. McBride?
I'll object on relevance grounds.
All right, did you want to respond, Mr. Burt?
Your Honor, it's relevant because the witness originally determined that there were 3 contributors, and I'd like her to explain to the court how she reached that conclusion, because I think it does go to the reliability of her testing here.
All right, so as it relates to Baker 4, and this is her personal notes from Ms. Baker as it relates to what I'm assuming is State's Exhibit 31, that these notes were prepared as part of the report in State's Exhibit 31. I will find that it is
Your Honor,
relevant
Your
and
Honor.
that it is admitted into evidence. As regards to publication, what is the request?
Your
Mr.
Honor,
Byrd?
if I may clarify, I think the testimony was that this was not her notes. That these were the notes of her technical reviewer, is what I heard.
Please correct me if I misheard that, from both sides. I want to
I
make
did.
sure, are these Ms. Baker's notes?
Could I clarify that?
Absolutely.
Ms. Baker, these are notes in your case file, correct?
These are notes in my case file, but they're not my notes.
And the way your lab works, you're not the one that does all the different steps in the testing process, correct?
That is correct.
Other analysts have input that then all goes into the case file, which you have access to and rely upon in rendering your opinions.
That is correct, yes.
All right.
And this particular page is a note written by your peer reviewer that you relied upon.
Correct. After I made my interpretations and drew conclusions, my technical reviewer then reviews the data and draws their own conclusions. So this was created after I had already drew my own conclusions.
All right, I'm just trying to put it
wake up.
together here. So the question I'm trying to get to, counsel, is, was this particular, I recognize it as it being prepared by someone else, but as it relates to State's Exhibit 31, was this relied upon in order for State's Exhibit 31 to be put together as the report? Because I'm trying to determine relevancy as it relates to that, and that's a crucial point I don't have the answer to just yet.
Okay. Let me lay a more adequate foundation. The case file notes are assessed by you at every step of the analysis, correct?
Not necessarily at every step. Before I issue a report, before I write a report, I review all of the case notes. So that will be any communication log entries, any documentation from the laboratory, the biologists that perform the DNA testing. I will review all of that, write a report, and then give that to a technical reviewer. They will draw their own conclusions to determine if they agree with me. If they do, they will sign off, and then my report and my case file will go for an administrative review to make sure that the laboratory number is correct on all the pages, that if there's any crossouts, there's dates and initials and so forth. Those 2 reviews have to be done before I can actually make it a final report and case file that gets submitted and sent to the field.
And in this case, correct me if I'm wrong, but the sequence was you originally determined in sample 7, that there were 3 contributors. That conclusion got reviewed. Then you ran some further testing, and then you change your conclusion, correct?
That is correct, yes.
Right. And before you change your conclusion, you of course go back and look at what the reviewer said about her review.
We would have a discussion. If I say a number of contributors was 3, he or she notated that it was 2. We had that discussion. She agreed with 3. So for that step of that process, because again, we're piecemealing this. Typically in a normal case, we will work all of the evidence. I will write a report. For this situation, I had DNA evidence coming to me throughout the day, throughout the night. So I had reviewers at different steps, which is not usual for a case. Usually I have one reviewer. So in this case, at that particular time, I had a reviewer. Then when I was submitted additional known samples and used those for comparisons, then I did have additional conclusions and additional reviewers.
But you certainly took into account this notation on this page before you changed your conclusion, correct?
I don't know that I would agree that I took into account. We had already had that conversation, and again, once I received additional known samples and additional information from the field, I then did amend my conclusion.
And these notes are kept in the ordinary course of your business?
Yes.
And they're part of the case file that you rely upon in reaching your conclusions?
They are kept with the case file after I draw my conclusions.
So, Your Honor, I think there's a foundation for this. The state has offered all kinds of hearsay here, and certainly this is, there's no question about the reliability of the entries.
All right. Anything further from the parties before I weigh in on, make my ruling on Baker 4?
No.
The court finds that it is relevant, and as it relates to State's Exhibit 31 and Baker 4 is admitted into evidence. In regards to publication, Mr. Burt, what is your request?
That it be published.
All right, in the courtroom.
In both the courtroom and
They want their stuff published.
To the cameras.
They just don't want the state stuff published.
Any objection, Mr. McBride? All right, go ahead and publish that to all screens and may be captured by the media.
So
we're on it, Judge.
These notations at the top there, 7-1 male, discuss 3 NOC and okay with 3. Could you translate that for us, what that means?
Sure. So when my technical reviewer took a look at the DNA evidence, she determined that male DNA was present, and she concluded that she would have called it a number of contributor of 2. She compared it to my conclusions. I said number of contributor 3, so we had a discussion as to why she thought it was 2, why I thought it was 3, and she said she agreed with me calling it 3 based on her discussion.
Okay, so was that an extended discussion you had with her, or just?
No, this was a quick discussion, and this is not unusual. We have discussions like this during the technical process quite often.
And the stamp on the bottom, approved by Tara Benson, is that the reviewer?
Yes, it is.
Talking about? All right, thank you. Now, I want to ask you to look at page 128 of that same exhibit. No. Is this an electropharogram that is a part of your case file?
Yes, it is.
And is this an accurate representation of what's depicted on this page?
I'm sorry, there's nothing on the screen. Am I?
Yeah, 128.
Yes, it is.
I move that into evidence, Your Honor. This would be Baker 4, page 128.
Oh, I thought I already admitted Baker 4. Is this a different? The previous one was Baker 4, as I understood it.
Yeah, Baker 4, page 365.
Oh, okay. So Baker.
And so this is Baker 4, page 128.
Right, so the previous admitted exhibit is Baker 4, 365. The current proposed one is Baker 4, 128.
That's correct.
All right, Mr. McBride.
If I can have just a minute to update my notes on those page numbers.
All right. 365 was the previous one, unless I heard it wrong.
Yes, that's right.
All right, and the current one is 128.
First, I'll note, this is the first I'm seeing these as exhibits. Of course, I have this file, but I was unaware that we were going to be, these are going to be offered as exhibits, so I'm looking to find them in my file as we go. Second, again, I'm going to object on relevance grounds to the probable cause determination. We're going through the finite details of the analysis here. And once again, I think these are appropriate questions to raise in a 702 hearing, but with the standards that apply at the preliminary hearing that I've already discussed, I think we're beyond the scope of probable cause determination as we dive into this evidence.
All right, Mr. Burt.
Your Honor, I think this exhibit is particularly important because the court does not yet have in front of it what an electropharogram is and how it's interpreted. And this particular page will illustrate to the court how the analysts interpreted the peaks on this electropharogram to reach the conclusions that she reached, that there were 3 and not 2 contributors. And I think it will assist the court in determining exactly how this comparison process works and what the output looks like, so the court can see exactly how the interpretations are being made.
So now the shoe's on the other foot. He's arguing
And
the
is
same
this,
thing the state was arguing
were relied
before.
upon I'm viewing today's Exhibit 31 as a summary, and this more of showing the work of how the summary was reached. Am I misunderstanding how this fits in?
This fits into how the analyst originally was of the opinion that there are 3 people here and not 2. And she will go on to explain how she changed the interpretation from 3 to 2. And the point of this is to illustrate to the court that this is a subjective process to a certain extent, and that people can read these things in different ways. And so I think it will help the court understand exactly what's being compared here. You've got peaks on a line, she will say, and just to let the court know in responsive to Mr. McBride's statement that he was unaware that this is going to be an issue, he and I met with this analyst before the preliminary hearing. The analyst pointed this page out to us as being illustrative of why she originally concluded that there were 3 contributors. So this is not something that's being sprung on the state. He was a part of that conversation, and this particular page was identified by the analyst, not by me. So it is important to understand why we went from 3 to 2 and what impact that has on the numbers that the state is offering.
All right. Anything further?
No.
All right. Under Utah Rule of Evidence 1102, B4, it says scientific, laboratory, or forensic reports and records. I find that this is admissible and is admitted into evidence as Baker 4, page 128, and is a request to publish this document.
Okay, you can.
Was that a yes? Oh, okay.
Yes.
All right. So published, I'm assuming to that
Yes.
screen as well. All right.
Correct.
It may be published. Counsel, just as a reminder, as this is a probable cause, I understand and I appreciate you give me a pointer of where it's going, but just as a reminder, as probable cause, it is admitted, and you may discuss it, but I definitely want to keep this within the track of probable cause.
Understood.
All right.
Thank you.
Mr. Burt.
Okay. Is it true what I just told the court, that you pointed this particular page out as illustrating why you originally thought we had 3 contributors?
Yes, that is true.
So explain to the court, is this an electropharogram?
Yes, this is an electropherogram. Each of those rectangles at the top, for example, D2S441, that is that small segment of DNA that I referred to earlier. And each of those peaks has a corresponding number that is the allele, so that corresponds to the number of repeats that an individual inherited.
And this is what you ultimately, after you get this electropherogram not through running it through STR-Mix. There's a different device that you use to produce these electropherograms, right?
Correct, yes. During the DNA process, this is the last step of that process. So what it's doing is DNA is found in cells of our body. We're taking those cells, we're breaking them open with chemicals to release the DNA from those cells. We're making photocopies of those pieces of DNA so that we can essentially see them. And then the last step is to separate those pieces by size, and the ultimate output is this electropherogram.
Okay. And is it true that you set the parameters for what the machine will pop up in terms of numbering the alleles?
Personally, I do not set that up. That was done during our validation of the chemicals and the software and the instrument that we utilize. But there are parameters so that the output of the DNA lets me know, for example, the different types of alleles, but that's not a parameter I set.
I want to make sure you answered that. You set, or your lab sets, what the machine does in terms of labeling particular alleles, correct?
Yes, that's part of the whole process and the validation, yes.
So you could tell the machine, give me all the peaks at whatever level and label them as whatever the alleles are.
I see. So yes, so during our validation, we determine our thresholds, our analytical threshold, and that stochastic threshold that I mentioned before. The analytical threshold is a threshold that was determined during validation that we input into the software that I utilize that says, for example, our analytical threshold is 150. Any peak that is 150 or greater, the software system will give me that allele call or that number for that peak. Any peak that's below the 150, the software system will not give me an allele call for it.
Even though it might be a true allele.
Correct, yes.
So you could say, and you referred to a measurement, you refer to that as RFUs, right?
Yes, that is the unit.
What does that mean?
It stands for relative fluorescent unit.
So in your lab, you tell the machine, only label peaks that come above 150 RFU.
The software that utilizes the information from the machine, yes.
However, it's true, is it not, that in determining the number of contributors, you look below that 150 RFU level.
And that is true, yes.
All right, now on this is only showing 1, 2, 3, 4 different locations, right?
Correct, yes.
And you see a number of peaks at each one of these locations. Some of them are labeled, some of them are not.
Correct, yes.
So tell us how you originally looked at this and said there's not 2 contributors, there's 3.
Sure. So first what I do is I count how many labels that I see, so how many of those little squares under each of those locations. So for example, at D2S441, there are 3 squares. Knowing that one piece of information comes from mom and one comes from dad, if it's a single source profile from one individual, I expect to see no more than 2 squares. Because I see 3, that gives me an indication that there's at least 2 individuals. Same thing for the next D19S433 and as well as FGA. There were 3 peaks that were called. So I knew this had to be at least 2 individuals. Then what I do is I take a look at the peaks that are not called and determine could there potentially be a third person included. So for example, at D2, the location farthest to the left, I'm asking myself that 12 in that bottom box, is it the same contributor as, for example, the 22 under FGA all the way to the right? Because I see peaks that are not labeled, it could be that the the 12 belongs to one individual, and those 2 peaks that are not called belong to a second or third individual. And that at FGA, I could be seeing the 22 from that third person, but that second person has dropped out. Because I'm able to use information below the threshold and I see peaks, that gives me an indication that I can increase my number of contributors to 3, which I did in this case.
Okay, and when did you reach that conclusion, time-wise?
If I recall, it was somewhere around September 12th.
And when did you change your conclusion?
That I would have to refer.
Sure.
I changed my conclusion on September 13th of 2025.
And explain to the court why you changed your conclusion?
I was submitted an elimination sample from Mr. Twiggs, and an elimination sample is a sample in which it's from a known individual, and then there's an expectation that the individual's DNA might be present. In receiving that sample and talking to the investigators, it was decided that Mr. Twiggs should be used as an elimination. When I compared him to this sample, all of the DNA, unlike that major contributor, matched to Mr. Twiggs. So because of that, I determined that there's actually only 2 individuals because those small peaks, there was nothing left for a third individual to be compared to.
You use the phrase elimination sample. That's typically used, is it not, in a situation where you're testing a sample that has more than one contributor?
Not necessarily. An elimination is just simply an individual that we're expecting their DNA to be there. So for example, if we have a stolen vehicle, I will request an elimination sample from the known driver of the vehicle so I can subtract out their DNA to see what I have left over. It doesn't necessarily have to be more than one individual. There certainly has been times where I only detect that known expected individual.
And you said you had a conversation with the investigators as to whether Twig should be included as, or you talked to them about whether you should get elimination samples?
I talked to them with regards to if I should utilize Mr. Twiggs as an elimination versus comparing him and offering a statistic.
Okay, but in your report, you concluded, did you not, that one of the contributors to both samples was Twiggs?
That is correct, yes.
Right. You didn't just assume that, you reached the determination that he was the source of both those samples, one of the sources, right?
I don't want to use the word source, but knowing that there was an expectation that his DNA could be present, when I compared him to that DNA sample, I did see his DNA types present. So using the word assumed, that's verbiage that we use when we calculate our statistical calculation. I'm letting the software know, I know this individual is there. I'm assuming that they're there. Based on my comparisons, I did see evidence that that person was there.
But I guess what I'm confused about is we talked before about how your language should never imply an absolute identification. But in the body of your report, you say that one of the contributors is Twiggs. You don't say he's a possible contributor like you do for Mr. Robinson. You say he is a contributor, do you not?
I do, and with elimination samples, that's slightly different. So for example, let's say I have a sexual assault case and I have a vaginal swab from a female. She has a consensual partner. I can request an elimination sample from that consensual partner. If I see that they're present, I can say they're present and say the DNA foreign to that victim and that consensual partner is one person, for example. So it's It's different than comparing a known individual if they're an elimination sample. I can say that I expect their DNA to be there, and based on my interpretation and reviewing that data, they are present.
And based either on your conversations with the agents or other people, why did you think that Twiggs was someone whose DNA you would expect in those two samples?
So from what I recall, in speaking with the investigators, Mr. Twiggs was a roommate of Mr. Robinson, and it was thought that those items came from potentially Mr. Robinson's home. And I don't recall exactly if it was a situation where a particular towel was known to have been in that house. I don't remember that exactly. But in talking to the investigators, based on their investigation, it was important to assume potentially Mr. Twiggs was present.
Right, did any investigator ever tell you that the towel did not come from Mr. Robinson's home, but was found in a bush out at the university?
I was aware of that, yes.
So you knew that that towel was not found in a place where you would expect Mr. Twiggs's DNA to be present?
That is correct. It was found outside of a home, but again, based on speaking with the investigators, they had information to suspect that that towel came from Mr. Robinson's home, and I should utilize Mr. Twiggs as an elimination.
Right. And again, you didn't assume that, you actually concluded it based on the match, right?
Based on reviewing Mr. Twiggs' DNA profile to what I developed from these items, I used him as an elimination sample.
Now, you did various STR mix, what I'll call runs, correct?
That is correct, yes.
And the way this works is you input the number of contributors. You determine that. And then they also have something called HD and HP, right?
Correct, yes.
Tell the court what that is.
So those are different propositions. So in calculating the likelihood ratio compares the probabilities of seeing a DNA profile given one of two different scenarios or explanations or hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. So depending on the question being asked is how I set up star mix, number of contributors. For example, if I'm utilizing someone as a known elimination sample, I will apply their DNA profile both to the HP and HD.
And the theory of this HP is the prosecution hypothesis, right?
Correct, yes.
And HD is the defense hypothesis.
Correct, yes.
So, and these are things you plug in based on your understanding of what the prosecution and the defense are contending.
Correct, yes.
So how do you plug in the HD in a case where you don't yet have a defense postulating what their theory is?
So HD, or the defense hypothesis, is simply the DNA profile, the probability of the DNA profile, given that it's another unknown, unrelated person to the prosecution's potential person of interest.
Mr. Burt, I don't want to interrupt your line of questions, but we've been going for just shy of 2 hours. Would right now be a good time
It'd
to
be a
take
great
15
time, Your Honor.
All right,
Thank
let's
you.
take a 15-minute break. Let's see. We'll come back at 3:50. Court is in a brief recess.
All right. As I go to break, I'm trying to sort out an issue with YouTube where their content identification system on its own decided that Topmark Media live streaming this trial as an approved media outlet was a violation of copyright. So they took our live stream on Topmark Media. That is incorrect. We are court approved. Literally, they sent us the unlisted media pool link specifically so we are allowed, with instructions that we're allowed to access and live stream this. And now I have to fight YouTube to get that fixed. So, quick little break. The judge says I either need a nap or an energy drink, possibly energy drink. During one portion of the testimony by this witness, the judge, as she turned to address him with some extremely complex DNA testimony. The judge had to pretend he was writing notes and like crouch down over his desk and put his hand up over his mouth to stifle a massive yawn because he was where all of us are. And this is deep in the weeds. Deep in the weeds. Indication of where this trial may go if this goes to trial, if he's bound over for court. But it's all good. He's issued rulings a little bit faster here. I think the process is quicker. We have had a couple objections. We're getting some objections, but he's making the rulings quicker. The arguments are going faster as both parties now sort of understand what the judge is looking for. It's all good. So anyway, I've checked out so many times during this testimony. Let's see. Does anyone know if someone turned Tyler Robinson to the police? I've heard that his father turned him in. I believe he talked to his family, and that I think we heard that it was a former scoutmaster, like a family friend, his scoutmaster, a mentor position, that ended up actually going with him as he turned himself in. But as far as turning himself in, it's one thing to say, hey, you're looking for me. I hear you're looking for me, and, here are my wrists, cuff me. It's another thing to say, let me tell you what happened. And I don't think he did the second one. I think he just turned himself in and then did not cooperate, basically just said, I'm lawyering up, which I guess is cooperating with his rights, but not with the police. This is the weeds of the weeds, the roots of the weeds. I'm going to stand ready to throw tomatoes. Let's see. Let's see. I thought it was a preacher. I think they said in court today it was a scoutmaster. I thought it was a religious advisor of some sort, but not sure. Let's see. People have made false confessions before. Yeah. It's when they corroborate the confession with other facts that it's harder to get away from and say that it's false. Lacey Lou, I'm so thankful for you. Remember, tomorrow sunrise needs you. I say that from a hospital bed today. Lacey Lou, get better. Get better. Please. I hope you're doing okay. Thanks for joining us today. Hopefully we can bring you a little bit of light and fun to your hospital bed. It was former law enforcement officer who I believe was his Boy Scout leader. Yeah. I'd send my lawyer in and wait for my lawyer to call me. Me no talkie. Of course, me no shooty. It helps. No talkie and no shooty helps your case, both of them. So I recommend strongly the no shooty one. Was Tyler Robinson even a student there? I don't know. I don't think he was. I thought he drove quite a ways. I thought he was down at another university, wasn't he? Like in Cedar City or something? That just from my memory of the news when it broke. I don't think he was a student at UVU. Let's see. Confess does not really matter to whom, does it? It can matter. Sorry, got like insulation in my eye or something that's bothering me. It can matter. It's one thing to do a sworn statement to police signed after Mirandized and everything else, and it's another thing to have made some comments that might be taken as a confession. Tyler Robinson was a third-year student in the electrical apprenticeship program at Dixie Technical College. So Dixie, I think that's down St. George way, isn't it? I feel like nothing was accomplished today. Laura, we got the video in. That was a tough fight. Tyler Robinson went to Utah State for a brief time. That is not even close to UVU. Utah State is in Logan, at the very north edge of the state, right by Idaho and Wyoming, up in that area. The skinny part on the very top of the state. Beautiful, beautiful town. I lived there once, briefly, when I was very, very small. You need Benadryl? I'm itchy. No, I need to stop doing repair jobs on my house. That would lessen the amount of insulation we have to play with up in the attic and everything else. The sheriff's press statement that he turned himself in to State of the Caller said he knew the family through religious association. So I guess that would mean that the information we got today, that he was former law enforcement and a Boy Scout leader in his troop, was in addition to that. So there might have been 3 ties, or three facts we learned total. Is that close to where they made Napoleon Dynamite? Yes, I think that was made up in Idaho, just across the border. Will we get a chance to hear Tyler speak, or will it be his lawyer for him? I don't think he's going to speak in this hearing, definitely. That would be a terrible idea. But I think there will be at least some times when the judge has to question him about his decisions in this case, where we'll hear, if nothing else, yes, no, no thank you, yes, Your Honor, that type of response. He could elect to speak as well, so we'll see. I was thinking a former youth pastor. It could have been that. I think they did go with him when he turned himself in. He didn't drive his Challenger to the police station, park it in the VIP parking, and just waltz into the jail. Kind of it feels like defense is crossing their own witness. They're definitely leading their own witness. The state should object to that. I think it would help a little bit in speeding things up. Yeah, he's not going to speak at a preliminary. That's a terrible idea. You're not on trial yet, right? And anything you say still can be used against you in trial. It's a no-win for him. Did Charlie put up a post where he would be so people would come, or just show up places? I'm sure they announced it. I didn't follow it, but I'm sure it was announced ahead of time, so they knew the schedule. Aaron Blackman says, all right, sorry, very unrelated. I just read a report that there may be a rework of the plea deal for Catherine McBanawa. I butchered that. Adelson witness. Possibly to get her to flip on Wendy. Oh, wow. That possibly, I mean, that's speculation, but why else would you rework a deal after she's done her part, unless you need something else from her? That is incredibly interesting. I wonder if that's going to happen. A lot of us expected additional charges in that case. We thought, from what we had heard, we thought that it would be reasonable for the state to file additional charges on one more family member. And it just didn't happen. It just didn't come to fruition. So maybe it will. We don't know. Gossip did a great video on it. That's awesome. I'll have to check out what Kathy said. Charlie lost his appeal just recently. She could have pled but got life instead. Maybe reworking the life. Yeah. I think Shirley Knott says that rumor has been debunked. Let's see here. We're only taking a short break here, maybe 15 minutes, so we don't have much time. Lacey Lou says, touch the like button, leave your DNA kindly as we wait. Yes. We'd like you all to touch the like button, because if more than 3 people contribute, then they can't find any of us. And it helps with anonymity. The complexity of I was doing this. Let's see.
Remember in the beginning when we started 110 years ago?
Apparently, in that Magbanawa case, there's no filings, no official filings, so it could all be speculation so far. Thank you, Lacey Lou. Let's see. Nestor should be petty and say, I object to the leading in the interest of time. Nestor's not going to, because this is her side that's presenting. This is a defense witness. This is called out of order. The state has interrupted their regular scheduled broadcast to allow the defense to call this witness from the FBI out of order to testify as if we were in their case already. And so it should be direct questioning by the defense attorney instead of cross questioning, meaning that he should not be able to lead and the state should be able to lead on cross. Have they talked about the conversations? No, those text messages have not come in yet. This was an accommodation. This is the state saying, yes, we'll help you out. Sorry, you're in a bad spot. We'll do something nice for you. Maybe in turn, defense could, I don't know, stipulate to the foundation of some exhibits or something. That would be nice. We get a little tit for tat. Isn't 5 days extra long for probable cause? Seems like they could fit the eventual trial into that time. It's a foregone conclusion. Yeah, we're cutting out a lot of the schooling, the education, the work experience that you'd normally get on some of these witnesses. We're truncating that greatly. In the actual trial, we're going to add 10 or 15 minutes to get to know the witness and their background before we designate them as an expert in the field. So it is a shorter version of the trial, and it's not all the evidence. It's just some of it that speaks to all the elements. This is supposed to end on Friday. That's the current plan. Tomorrow's only a half day, though. We start late, so it'll be afternoon on the East Coast before we start. I think it's about 11:30 or 12:30 Mountain Time that will kick off. Maybe the defense won't object to everything. Maybe. I always wonder the mindset of the obviously guilty person who pleads not guilty. Do they really think they'll get off, or do they like the attention? I don't know. Generally, the obviously guilty person ends up going to jail, and I just haven't talked to any of them after they've fought it in court. I can tell you they generally don't speak when they're at their sentencing and say sorry, because even then there's the chance of an appeal that could go their way. And if they admit to something at the end of the trial in the impact statements and speaking to the judge, that could be used against them as well. Can't wait for Josh's update this evening. Josh will have an update over on Portland Confidential. I think he said last night that he wasn't sure if he was going to do it tonight. I think he will. Because it's hot outside and it's cool in his hotel room. Let's see. Is Nestor still in the courtroom? Yes, she is, but she's just not the attorney that's questioning this witness. They're dividing up the witnesses and take turns. So one person isn't doing all the work. Tony, thanks for being here. Appreciate it. Josh was on Fox doing recaps today on Fox News Nation. That's his job. He's scheduled for 6:30 Mountain. So that's about 2 hours, 45 minutes from now. Don Jr. is there again today? The only thing I don't like about it is it's taking up so many seats in a high-interest case where so many people want to get in. Other than that, he has every right to be there just like anyone else. "1 p.m. tomorrow, the judge said they wouldn't have to worry about lunch. Does that mean 3 p.m. for us?" Yes, Linda Lou. We'll start a little bit early. We'll probably do some court hopping in the morning or cover some updates on some other cases, and then stop that live stream and pick up the Charlie Kirk, Tyler Robinson case. My friend that was in court said Don Jr. was not there today. He wasn't going to be there the rest of the week. So now we have competing accounts. What does the Secret Service just stand like a bailiff? I applied for the Secret Service. You know that? It's a fun story. I applied to work as a Secret Service agent, and they offered me a job, and I turned it down. So it's a tough job on families. It's really tough. Then I applied for another a private security company that I really wanted to work for, and went through all the fitness tests and everything, did everything for them. And then they're like, okay, we'll get back to you. And they just didn't get back to me. I'm like, well, I need work now. So I started another job, and it was paying me better than the private security place was wanting to pay me. And like 2 months into my other job, they called me up and they're like, all right, we'd like to hire you. When can you start? I'm like, no. That ship has sailed. I'm done. I'm earning several dollars an hour more than you were going to offer me. And I can't go back down now. It's funny. So I have done some security work, some on the volunteer front during the Olympics in Salt Lake City. That was fun. Trying to keep guns out of events, and mace and pepper spray and Kubotans and other fun knives and all that. My brain is too tired to provide me with who Don Jr. is. The name is ringing like a distant bell again. The son of the current president of the United States, Don Jr. Let's see. Robinson surrendered to police after his parents saw images of the gunman and said, hey, I know that guy, according to court filings. Interesting. So today is Don's last day, apparently. He's going to be there just for those 2 days. I wonder if he fell asleep during the DNA portion as well. I have to answer 7 questions on YouTube about copyright. So far, I'm getting it right. Three out of 3. 4 out of 4. Five out of 5. Six out of 6. That was a tricky one. Last one. Hang on, almost done. Seven out of 7. Done. I completed the training.
We're still with Mr. Burt and Ms. Baker, direct examination.
Thank you.
Mr. Burt, your witness.
Ms. Baker, would you take a look at, in your notes, page 24 of 379? Very bottom of the page. Did you write there on the 15th of September 2025, spoke with Special Agent Folger, gave update on report timeline, discussed that upon review, it was decided that additional statistics needed to be run. Report will still be issued with Twigs as an assumed contributor per previous discussions with Folger and Carmack. You see that?
Yes, I do.
And what additional statistics needed to be run at that time?
So at that time, I believe I ran statistics with just Twigs comparing that individual to the sample. If I may refer, I think that was the only additional. Yes, after discussion with my reviewer, it was determined that I was also going to calculate a statistic or compare Twigs by himself, comparing him to the evidence, and having that run in my case file.
Okay. And could you go to tab 38, page 39?
Oh.
Yeah, it should not be on the screen.
Let's pull it down from the screen. Thank you.
Thank
So
you.
just to the monitors of the attorneys and the witness, Mr. Burt?
Just for the witness, Your Honor.
Okay, just for the witness.
39. And this is page 39. Is this the DNA report, I'm sorry, the star mix report that was produced as a result of your inquiry that involved a comparison of the sample to Mr. Twigs alone?
Yes, it is.
And is that a 6-page report?
Yes, it is.
And is it a true and accurate copy of the STR mix report for that particular sample?
Yes, it is.
And move that into evidence, Your Honor. This would be Baker 38, page 39 through 44.
Baker 38, page 39 through.
I'm seeking admission as well as publication to the audience and the camera.
I just want to make sure I have the label correct. Baker 38, pages 39 through 44. Did I hear that correctly?
That's correct, Your Honor.
All right. To the state?
Yes, Your Honor, I object on grounds of relevance to the probable cause determination.
All right. And Mr. Burt, would you like to respond?
Submitted, Your Honor.
Submitted.
So I'm not exactly sure what this is in order to
Sure.
determine
Let
how
me-
it fits into the probable cause analysis.
Sure.
So a little bit more information, because as of right now, I don't have enough to admit it.
Understood, and I apologize to the court. So the report that was admitted into evidence has the conclusion in it that both samples were contributed, that Mr. Twiggs was a contributor to both samples. And this is the report that the analyst ran in order to make that determination, I believe.
All right. Did these reports, were these made prior to State's Exhibit 31 being prepared?
Yes, that's correct.
All right. I will admit, Baker 38, pages 39 through 44 is admitted and may be published. Again, as a reminder for all attorneys, this is a probable cause standard, so if all parties can just keep that in mind as we're moving forward on this.
Sure.
Thank you.
Thank you.
And so it may be published to all screens.
Yeah, it's
Bailiff, you need to sit down.
No, but the actual Bates number, I'm having a hard time finding the file. I didn't provide this to the
Um,
Document stamp 39.
So is this the report that you referenced in your notes that you needed to run the sample through StarMix?
Yes.
Now, at the top, this is the StarMix unit dated September 15th, and it relates to item 7-1, correct?
That is correct, yes.
All right. And then down below that, the kit used, if you could go to the summary of the input. You tell the software program, assume there are two contributors, right?
Correct, yes.
You input sample 7A,
Correct, yes.
and when you input it, it's just the raw data, right?
Correct, just the numbers from the graph.
The numbers, and then known contributors under HP, the prosecution hypothesis,
Correct, yes.
right? And you put in sample 61,
Yes.
right? That's Twiggs's known sample.
Correct, yes.
And then the known contributors under the defense hypothesis, you left that blank.
Correct.
Is that because you didn't know what the defense hypothesis was?
No, again, the defense hypothesis for this situation, if I'm comparing someone, is an unknown, unrelated individual, and that is taken into account during the calculation.
Okay, and then you input that data, and what you get out from that is a likelihood ratio, right?
Correct, yes.
So let's go to page 2 of that report. And is this a summary of the results from that test on the 15th in terms of a likelihood ratio?
Yes, it is.
What is a likelihood ratio? What does that mean?
A likelihood ratio is a statistic that calculates the probability of seeing a DNA profile given one of two different hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. The probability with the higher number gets the support, and the magnitude of the support is determined by the ratio of those two numbers.
That's pretty technical stuff, but the bottom line is that the software computes the numbers, and then you look at those numbers and determine whether it has any significance, right?
I don't know that I would say if it has significance. I report the value that's calculated.
Right, and why is one column, these columns relate to different what are called population databases, right?
That is correct, yes.
The one on the far left, BAH, is an FBI population database on Bahamians,
And African Americans, yes.
African Americans. Another one for Caucasians.
Correct, yes.
SEH is Southeast Hispanics.
Correct.
And then Southwest Hispanics.
Objection.
That's all I have on that. I'm just trying to explain the chart.
All right, well, there's an objection. Let's pause and turning to Mr. McBride.
Sure.
Your Honor, at this point, I'm going to object on, again, grounds of relevance to probable cause hearing. State v. Drosbeck, State v. Merrill, State v. Ramirez that the court has cited, all hold that the court should bind the defendant over for trial unless the evidence is wholly lacking and incapable of reasonable inference to prove some issue which supports the prosecution's claim. I don't know that any of this analysis goes to whether or not the expert's testimony and her report is wholly lacking and incapable of reasonable inference to prove her result in this case. We're far beyond this. We're hours into this examination. This feels like a 702 hearing to me. I think we're far beyond a probable cause hearing, Your Honor. I would ask the court to sustain the objection, not allow questioning on this or any other matter that does not deal with the issue of probable cause.
Thank you, Mr. McBride. Mr. Burke.
That's a bold
The state offered this report on a very technical, complex, scientific area of inquiry. And they offered to the court a conclusion in that report that Mr. Robinson and Mr. Twiggs were contributors to 2 samples that were found at the crime scene. They obviously think that's relevant to the probable cause inquiry, or they wouldn't have offered the report in the first place. So having done that, I think the defense is entitled to inquire whether those conclusions are reliable, because that, again, is the court's ultimate determination here, reliability of this evidence. And the court can decide it's not relevant, it's not reliable, therefore I'm not going to rely on that in determining probable cause. And that, or the court could say it is reliable and it bolsters up other evidence that the court is going to hear from. So the particular report in front of us goes directly to the issue of whether the expert correctly concluded that Twiggs not was a possible contributor, but was a contributor. And the state's theory here apparently is that both Mr. Robinson and Mr. Twiggs are somehow connected to this crime scene. So I think when the court sees what the numbers were generated and how that compares to her own standards for assessment, the court will see that the conclusion is not justified that she reached.
Well, I understand what both parties are saying, and at a probable cause hearing, the issue is whether we walk 1 mile or 100 miles down the path, and so I want to keep it limited to 1 mile, and as opposed to 100 miles, because that would exceed the probable cause standard for a preliminary hearing for what is before me.
Your Honor, I'm on my third pair of shoes here.
Mr. Burt, as it relates to the objection, I'm going to sustain it in part. If you want to briefly address this and move on, you certainly may choose to do so, but as it relates to where we're at, my hope is we can keep this very brief as opposed to going through all this, so we can move on to whatever else you would like to present.
Thank you. We'll do that, Your Honor. And in the interest of doing that, could you bring up on the same screen part of her report, People's Exhibit 31?
And let's take that off.
I'm going to need that up there because I need to do it.
So is it part of the same? Because it was on that screen. I want to make sure that what you're calling up on the screen right now, is it part of this that was already admitted or something else?
It's part of this, which has already been admitted, compared to Plaintiff's Exhibit 31, which has also been admitted.
Okay,
So
thank
they're
you.
both
I just
in.
wanted to clarify.
Sure.
All right, so do you want that published on this all
Yes.
screens? All right, let's go ahead and do so.
And the chart I would like you to bring up from that report is on page 5.
I think we need to ask for a different angle on this monitor,
Yeah, and just highlight that.
or just a feed, direct feed.
Thank you. So what we've blown up there is from your report, plaintiff's 31, and you provided this chart in the report, correct?
That is correct, yes.
Explain to the court how this works, what this chart is supposed to represent.
Sure. So this is our verbal scale. In addition to the numerical likelihood ratio value that I provide, I also give a qualitative or a verbal equivalent to that numerical value. That gives some kind of context to what that likelihood ratio means.
Okay. And on the left, explain what the greater than 1 million, less than 1 in 100 means. What does that scale relate to?
Sure. So that scale is the numerical value of the likelihood ratio. So if I have a likelihood ratio that's greater than or equal to 1 million, I designate that as very strong support for inclusion. The next example, 10,000 to less than 1 million, I would say that's very strong support for inclusion, and so forth.
So you need to reach a likelihood ratio of 2 in order to get even limited support for an inclusion, correct?
Correct, yes.
Okay. If you could not reduce that. And go to page 2 of the report on the left.
Make the big part be little again. Or that. That's
So,
okay as well.
From this chart, when you ran Mr. Twiggs against the sample, what was the likelihood ratio that you determined?
I believe this chart is not the comparison to Mr. Twiggs.
That's not in the report?
That's the wrong.
The chart at the bottom of the screen is not my comparison to Mr. Twiggs.
Let's verify that if we could. Take that down, the highlight. And repost 38, page 45. I'm sorry. Page 39, that is in evidence. There we go. Second page. Is this the likelihood ratio from your Twiggs comparison?
Yes, it is.
Okay. Now, what was the likelihood ratio that you calculated based on this chart?
The likelihood ratio was 1.
1.
Yes.
So that doesn't rise to the level of even limited inclusion, correct?
Correct. It would fall under an uninformative.
Uninformative, and yet you concluded that despite this STR mix reading with a likelihood ratio of 1, that Mr. Twiggs was a contributor to both item 7 and item 8, correct?
I did. So actually, I didn't utilize this calculation to determine that Mr. Twiggs was a possible contributor, or that I could use him as an assumed contributor. I visually looked at the DNA sample, and the DNA, unlike that major contributor, he also had those peaks. So that was one proposition or one hypothesis that I determined that he was an assumed contributor. There are multiple different ways. We don't have a threshold. I don't have to see 2, 4, 8 peaks to determine I think an individual is present. Given that the field submitted him as an elimination, I assumed he was a contributor. When I compared him to that data, I did see his DNA present. So when I calculated the statistic for Mr. Robinson, I used Mr. Twiggs as an elimination.
Let me see if I understand that. The STR mix that you relied upon to include Mr. you relied on the STR mix to include Mr. Robinson as a possible contributor, correct?
Correct, yes.
But when you ran Mr. Twiggs's sample through STR mix, the result you got was that he was not a contributor, correct? Or that it didn't it was of no, not even of limited value in including him?
Based on the Star Mix run, it was uninformative, but I did use my own knowledge and training to determine that I was going to utilize him as an assumed contributor.
Okay. Your own knowledge and training. Is there some standard that you use for deciding when not to rely on the Star Mix results and when to sort of disregard it and rely on your training and experience?
I can't say that I disregarded it. When I'm comparing someone, that's my first determination. Do I think this person is potentially included or excluded? If I determine that I think they're included, I will run Star Mix to give weight to that inclusion. Elimination samples are different. If I'm told that an individual is submitted as an elimination sample, I can assume they're there. Visually, I'm able to look at the DNA evidence and determine, yes, I think there's enough evidence there to assume that individual, which is what I did here.
Okay. At D16, Mr. Twiggs was a 912, right? According to your electropherograms.
That is correct, yes. Mr. Twiggs was a 912 at D16.
912. And did you find 912 at that location in the 8-1 sample?
I'm sorry, the sample 8 or sample 7?
Sample 8.
The only piece of information I had for sample 8 at item D16 was a 12.
And you said Twiggs at that was a 912, right?
Correct, yes.
But at that location, the evidence sample was not a 912, but a 12.
That was the only piece of information that was recovered at that location.
Let me ask you about your interpretation rules for excluding someone. Is this an accurate statement? This is from Butler's textbook. In forensic DNA analysis, if any STR locus fails to match when comparing the genotypes between 2 or more samples, then the comparison of profiles between the question and the reference sample is usually declared a non-match, regardless of how many other loci match.
I would agree with that if it's a single source sample. So single source, again, meaning from one individual. If I have a DNA profile from evidence and I compare it to a known individual, if there's a difference at even one location, I can say it's an exclusion. If I have a mixture, it's not that cut and dry. I have to take into account how many people are in that mixture, how many pieces of information I have, is there potential dropout. So it's just because someone may not be present in a mixture doesn't necessarily mean that I'm going to automatically exclude them.
I see. At D19S, what was Mr. Twiggs's type?
It was a 1416.
Did you find a 16 allele in the 8A sample?
No, I did not.
Okay. At Tho, what was Mr. Twiggs's type?
He was a 7.9.3.
Did you find a 7 allele in the 8-1 sample?
No, I did not. But again, this is a mixture and there is some dropout. So just because I didn't see a 7, for example, does not mean I would automatically exclude someone.
It's a mixture, so there was some dropout. So did you assume that at that location that the allele that dropped out matched his allele?
At that location, no. There's only one individual represented there. So when comparing an elimination, I would essentially ignore that location. I'm looking at the other locations where there was 2 individuals present.
Okay. Now, a couple more topics and then we're done. When you received this, the evidence, you got more than 7 and 8, correct? You got a number of other samples.
Correct, I did.
You got a backpack, which you labeled as Exhibit 9, and a bunch of items from that backpack. Correct?
Correct, yes.
You were initially told that those items related to things that may have been discarded by the suspect.
So initially, we didn't have any information. So we processed that. Those are items that are good for DNA. Not having any information from the investigators, we process them for DNA. As the investigation continues, it was determined that that backpack was potentially left behind by a bystander, and there was no comparisons needed at that time.
Well, left behind by a bystander, or according to your notes at page 20, the backpack belongs to Kirk's detailees.
Yes, based on the individual that was not my communication log, that was someone else within the laboratory. That was the information that they received.
Before you received any samples, did you request to perform what's called destructive testing on the samples?
Yes, I did. And destructive testing is essentially consuming the sample, cutting the cotton off of the Q-tip or the swab, subjecting it to testing. There's nothing remaining. I have to request permission to consume prior to doing so, and I did in this case.
And why did you do that?
That is part of our protocols, that we have to request permission to consume, and we consume, so DNA, we can't see it, so when an item is swabbed, we don't know how much DNA is on that swab, if anything, or how that swab was used. Did someone just swab using one side of it? Did they roll it and use all sides? Because I don't know that, it's our practice to consume that swab. It's our best chance of getting any DNA evidence.
And that's a determination that you made in this case before you even saw any of the evidence, correct?
Determination to consume?
Yeah.
Yes.
Okay. Now, remember I referred to that NRC report?
Yes.
1996. Did they say there a wrongfully accused person's best insurance against a possibility of being falsely incriminated is the opportunity to have the testing repeated? Such an opportunity should be provided whenever possible.
Yes, that does say that.
And does your laboratory have a policy, standard 7.4, which says, where possible, the laboratory shall retain or return a portion of the evidence, sample, or extract?
That is correct. And we do actually return the remaining extract, the liquid from our DNA testing. So we did consume the swab. However, there was a small amount of liquid that was left and returned.
On some of the items, right?
I believe on all of the items.
Well, we'll get to that in a minute. And that policy that I read is from your lab policy, right? The
Yes.
FBI's lab policy.
Yes, it is.
And then is there also a similar policy from the quality assurance standards, the FBI quality assurance standards, which says the laboratory must have a policy on sample consumption. The policy is expected to provide instruction for if and when the laboratory may or may not consume a sample, and any documentation that the laboratory requires.
That is correct, yes.
Okay. Now, your report indicates that certain samples were destroyed, consumed, correct?
That is correct, yes.
And which samples were consumed?
Items 1 through 6, which were swabs from possible smudge, swabs of hand swipe, swabs from possible sweat drop, swabs from possible smudge, swabs of possible smudge, and swabs from possible sweat drop. In addition to items 54 and 55, which were swabs of swiped finger areas and swabs of stairwell railing.
Okay, so when you wrote in your report that those items were consumed, which of those items, and by that you mean the actual swab was consumed?
Correct. So a swab is just like a Q-tip. So the cotton portion of that swab was cut off the wooden stick, placed into a tube, subjected to DNA testing. So we consider that consuming. But again, there is liquid at the end of the process that is returned to the field.
And the normal procedure in terms of sample preservation would be something called sample splitting, right? You split the swab and you use half, you save half so that your testing results can be replicated and retested.
So yes, however, again, I don't know how an item is swabbed. So even if I were to cut that swab in half, it could be that I'm testing the half that doesn't have any DNA and the other half may have some DNA. Or the swab may have a little bit of DNA on one side and a lot on the other side. So for the best possible chance of getting a DNA profile, it is our practice to consume the entire swab.
So for the first 6 items, those were swabs that were taken from the northeast corner of the Losi building, correct?
Correct, yes.
And you
That's where he's jumped
used
down
all,
the northeast
all of
corner.
the swabs, and you concluded that there was no DNA present on any of those items, correct?
That is correct.
So you couldn't do any comparative testing.
Correct. There was nothing for me to compare to.
Okay, and what did you have left after you did that in terms of the volume of extract? What was left?
So it was approximately 3 microliters, so a very small portion.
Very small portion, and you actually used 10 microliters to do your testing of those samples, right?
That is correct, yes.
So if you didn't get any results with 10, what you left over would not be sufficient to get any sort of independent testing done, correct?
It could be tested. However, my expectation, if I took 10 microliters and did not get any DNA, the remaining 3 would also still not give me any DNA.
Okay. And for item 55, that was 2 swabs of a stairwell, from a stairwell railing where the suspect touched the railing, right?
As far as I know, they were swabs from a stairwell.
And correct me if I'm wrong, but I understand from your lab notes that you took those 2 swabs and combined them into one sample and then used the whole sample, right?
That is correct, yes.
Okay. Before you did that, did you inquire whether the 2 swabs came from 2 different areas? For instance, maybe the suspect touched it here, but the other sample was taken somewhere else?
I did not. They were both labeled as coming from the same stairwell, and they were packaged together. So our policies and procedures is that we can combine those 2 together.
And when you do that, you create a mixture, right?
I don't know that I would agree that combining the 2 would create a mixture. Given the item of evidence, a stairwell railing, I don't necessarily expect that one swab would have one person, the second swab would have a different second person, and combining the 2 of them creates a mixture. However, I don't know that for certain, but again, I don't know is DNA present, so our procedure is to combine and consume those swabs.
And in this case, when you did that, what you got was a complex mixture, right?
I did. I got DNA from more than 5 individuals, so I could not provide a conclusion.
All right. Now,
Mr. Burt, and we are at the 4:30 point. I just want to inquire, without applying pressure, just trying to understand.
I just have one area left. He holds up 2 fingers. Just have one area left.
We talked earlier about your testing of the length of the DNA sequence, the length of the DNA boxcars, not the sequence of A, C, T, and G within those sequences, within those boxcars, right?
Correct, yes.
And is it true that there are different alleles that have the same length when you measure by SDRs but have different sequences?
Yes, that is possible.
And like to show you a chart that you have reviewed, I believe. This is, could you bring up 34? This is not in front of the, on the public screen, just for the witness. And is this a chart that you reviewed, that I prepared and you looked at to see if I had correctly stated what alleles were found?
Yes, it is.
And does it, as it's presently existing, accurately state what the alleles are at each location?
Yes.
Okay. I would move that into evidence. It's 5 pages and it's Baker 34.
Mr. McBride?
Objection?
Yes, I object. Unless this exhibit is reasonably likely to defeat the prima facie showing of probable cause, this is irrelevant to the preliminary hearing.
Mr. Burt?
Your Honor, this exhibit and the next one go directly to whether the comparisons being made between Mr. Robinson's sample and the evidence samples are usable and reliable to make a determination that he is a probable contributor.
I'm not sure I'm following with what you're saying on there, right? And maybe it's just because it's late in the day. Could
Yeah,
you
it could
repeat
be.
that?
Judge is like, I'm sorry, I
So
wasn't
this
listening.
chart illustrates what allele she found at each location for Mr. Twiggs and Mr. Robinson, and for the evidence samples, the 71A and 81A. The other alleles are on here as well, but we're going to focus on 71 and 81. And for instance, Your Honor, at the, you'll see that under the first reading there is for Tyler Robinson at the D3 location. He is a 17. Okay. And take that down. And then if you go down to the 7-1 towel sample, which is what the topic is of this report introduced by the state, you'll see that she found a 17 there as well, measured only by the length of the DNA strand. And what she's going to testify to is at this location
The boxcar.
and 5 or 6 others, there are alleles, all of which measure here 17, but actually contain different sequences. And that her testing that she used does not measure for those differences.
And so as it relates to probable cause, that's what I want to keep coming back
Sure.
to. Again, if this was a trial, this may be a little bit different analysis that the trial judge applies. But as a magistrate, taking a look at this and looking at the probable cause standard, how does this comport?
So it comports because it goes to the ultimate opinion expressed in the report that the state is offering, that the report offers reliable support that Mr. Robinson is a possible contributor. And we're asking the court to consider that the comparisons are only based on a limited number of length-based comparisons, and that there are sequence differences so that she cannot distinguish, and I believe she'll testify, she cannot distinguish based on the testing that she did in at least 5 separate locations, whether the evidence sample and Mr. Robinson's sample, or for that matter, Mr. Twiggs' sample, matches the sequence differences here. And this is my final area, and I think I can do it very efficiently, and I think it is important.
We don't
for the
have
court to
that
consider,
amount of faith in you, sir.
especially as it relates to the comparison to Mr. Robinson.
Mr. McBride.
And she is also going to testify that the analysis she does is based on looking at the totality and all of the different markers that match and are consistent, and that's how she comes to the opinion that she does. The point is, there are explanations that are susceptible to different interpretations and arguments, ultimately, we're going to have an expert hearing where all of the literature is going to be before the court, and the court's going to determine if it meets a threshold of reliability for admission at trial. But at this stage, even granting that there may be some argument that may come from defense counsel's position, the court can't weigh it. This does not go to the probable cause determination, and I don't think it's relevant. And this exhibit in particular is not relevant without the testimony of the witness, and so the exhibit should not be admitted on its face either.
That's why I was trying to lay a foundation that she would, and offered a proof to the court that she would testify that in fact there are these sequence differences at the 5 or 6 locations, 6 different locations, relevant to the comparison to Mr. Robinson. And when the state says the court cannot weigh it, the court can weigh reliability. The court has ruled that. So we're simply asking the court to take into account the limited nature of these comparisons and the fact that she cannot, based on the testing that she performed, tell the court whether there are differences between, at these 5 locations. She can't match Mr. Robinson to the question samples because she didn't do sequence testing. And she'll also testify that the FBI is in the process of implementing this kind of testing.
All right. Thank you to both sides. I'm going to allow the admission of this evidence, but I'm also going to set a limit of
30 seconds.
A limited number of questions. We are now at 4:40. This is on the cusp of whether it is applicable to the probable cause standard. I want to afford defense its full opportunity, but I still have to rein it in to keeping it to probable cause and not going into a full exploration, because that's not the purpose of a preliminary hearing. So I will admit Baker 34, but Mr. Burt, I'm going to limit you to how much time do you need to address
I just
this?
need about 4 or 5 minutes. I'm going to, the next
45?
chart will be the chart with the, what are called isoalleles displayed for the court, so the court can see what we're talking about, and that's it.
All right.
I'm just going to have her document that, in fact, I've accurately stated what the
Mr. Burke is one of those
alleles are that
drivers
have
that
sequence differences.
never
So it is
pulls out of the
Mr.
fast lane no
McBride.
matter how slow he's going.
Just on a second matter, which is, I need to cross-examine this witness. She's got to leave town today. I would like 20 minutes to cross-examine the witness.
All right. Well, I will go with the I accept Mr. Burt's representations in the amount of time, and I'm going to talk less because that's consuming more time, and also allow the state the appropriate time for cross-examination given the nature of this witness having to travel. So, Mr. Burt, I'll turn to you. This has been moved into evidence. Do you want it on the screens?
Actually, I don't need it on the screen, just in the interest of efficiency. Pull up the next one, please.
Okay.
I want 35. Take that one down. And is this exhibit the same chart with what are called the isoalleles indicated?
Yes, it is.
And isoalleles is a term used to refer to these alleles that have different sequence but the same length.
Correct, yes.
So across the top there for allele 17 and D3, there is a allele 17A, allele 17B, allele 17C, all with the same length, but different sequences for each of those 3.
Correct, yes.
And similarly at VWA, where you say that Mr. Robinson is an 1819 and 1819 in the evidence sample, there's an 18A, a 18B, a 19A, and a 19B.
Correct, yes.
And similarly for the other areas I've indicated there, I've accurately stated what the different sequence alleles are, correct?
Yes.
So I move this exhibit into evidence, Your Honor, and for publication.
Is this Baker 34?
Yes. 35. Baker 35.
Same objection, Your Honor.
All right, I'll admit into evidence under the previous statement as it relates to Baker 34. It may be published.
He didn't expect to win. Now he doesn't know what to do. What? It's allowed in? What? What? I can...
And as you look at these 5 areas, you can't distinguish the evidence samples from Mr. Robinson based on the sequence differences.
To be fair, none of us can.
Correct. I only utilize length differences, STRs in this case. The FBI laboratory does not use sequencing for nuclear DNA testing, nor am I qualified in it.
Right. What is NGS?
NGS stands for Next Generation Sequencing.
And your laboratory is involved in validating next generation sequencing, correct?
We utilize next generation sequencing for mitochondrial DNA, which is a different subset of DNA testing, but not for nuclear DNA testing, which is what we're talking about today.
Right. But the people who market STR mix also market a sequence platform, do they not?
I'm not aware if they do or do not.
Last question, take a look at. Well, I'll save that for redirect. Thank you.
Thank you.
All right, turning to the state. Mr. McBride.
Take your books with you, sir. The whole library you brought.
Whoops. Good afternoon.
Good afternoon.
You almost should wish her a good tomorrow. It's been that long.
I want to start by asking you what your training and experience is. First of all, do you have any education?
Yes, I do. I have a Bachelor's of Science in Biology from Salisbury University.
And do you, after your Bachelor's in Biology degree, what did you do for your career and in further education?
Upon graduating from college, I began working at the FBI laboratory as a contractor. I was assigned to the Federal Convicted Offender Program, which was a program under the DNA unit. During that time, I did that for approximately 1.5 years. It was my responsibility to open and inventory and barcode DNA collection kits sent in from federal agencies across the United States. I then became a biologist in the DNA casework unit. I did that for approximately 6 years. During that time, I did the actual testing of items of evidence, so swabbing, cutting those swabs, producing the DNA profile. And then in 2015, I accepted a position as a forensic examiner, which I am still today.
I'm sorry, what year was that?
2015.
So 11 years you've been doing more or less the same duties you have now, is that right?
Correct, yes.
I want to ask you about your lab's accreditation. What is accreditation for a laboratory?
Accreditation is a formal recognition that our laboratory is following a very strict set of standards. We're accredited by ANAB, the American National Standards Institute National Accreditation Board. And our accreditation shows that we have to follow standards such as I have to have a certain education background, how we process evidence, how we store evidence. Every 4 years, we're audited to those standards, meaning an outside body will come into our laboratory, look at my training records, look at our standard operating procedures to ensure that we're following those standards.
And you mentioned your training. So what do you have to do as an examiner there, as a scientist there, for your lab to maintain its accreditation?
So for my training program, I had to complete a 2-year training program. During that time, I learned the science behind DNA testing, and I showed that I understood that science by completing oral board examinations and written examinations. I also then had to show that I could relay results, those scientific results, to a jury by completing moot court exercises. And before becoming qualified, I then took something called a competency exam, or it's like a final examination to show that I'm qualified to perform my duties. During that accreditation or that audit process, my training records were reviewed to make sure that I had the proper coursework, the proper college degree, as well as completing successfully that training program.
And do you have to keep up with ongoing education to maintain your, do you have a certification?
I'm not certified. I'm qualified as an examiner.
To maintain your qualification, do you have to have ongoing education?
Yes, on a yearly basis, I have to complete at least 8 hours of continuing education, and this can be done by attending conferences or lectures or reading scientific literature.
Do you also have to undergo proficiency testing?
Yes, and a proficiency test is a test that we receive from an outside vendor. I process that test like I would any other case and submit that those answers to determine if I'm satisfactory or unsatisfactory. This tests not only me to see if I'm still proficient in my qualifications, but it also tests the laboratory process to ensure that we're getting accurate and reliable results.
Now, as you discussed your work in this case, you talked about your work needing to be reviewed by another analyst.
Correct, yes.
And is that true in every single case?
Yes, in every one of our cases, they have to undergo a technical review in addition to an administrative review.
And it sounds like during those technical reviews and administrative reviews, there's discussions between you and other analysts. Is that accurate?
Yes.
And is that an opportunity for training and learning as well?
Yes, absolutely.
And I assume that training and learning goes both directions, that you're learning and you're also helping others understand your thought process, which may train them as well. Is that accurate?
That's true, yes.
The tools you use, are the tools you use validated?
Yes, they are.
And what does that mean to have a tool that you use validated?
So a validation is a thorough testing of a process or procedure. So before we subject any evidence to testing, we ensure that those process and procedures will work within our laboratory. Based on the validation, we create something called standard operating procedures, or SOPs, and these are kind of like cookbooks. It gives us step-by-step instructions on how to do our process and procedures.
Oh, great.
And then both myself as an examiner as well as the biologists were all trained to those standard operating procedures and tested to those standard operating procedures during proficiency tests.
Now, you've talked about, I think, a couple of the tools you use. One you call StarMix, is that right?
Correct, yes.
And is that tool validated?
Yes, it's validated both developmentally and internally. Developmentally it's validated by the creators of the software. And then we, the FBI laboratory, also tested StarMix to ensure that we could use it within our laboratory and produce accurate and reliable results.
Now, when you say it was developmentally validated, is that in a peer-reviewed study?
Yes, it is.
And is StarMix used, how widely is StarMix used throughout the world?
StarMix is used in approximately 120 laboratories, both domestically and internationally.
I want to go back to some of the questions that you were asked on direct examination. You were asked about an Exhibit 8.4, Baker 8.4, which is the DOJ Ultra, which is the Uniform Language, what does that stand for?
Uniform Language for Reporting and Testimony, I believe.
Okay. It talks about language that you should use and language that you shouldn't use as an examiner and a scientist, correct?
That is correct, yes.
Now, I want to ask you a little bit about what you do when you have a conclusion, like you did in Exhibit 31. Do you know? Let's see. The directive from the Department of Justice limits the adjectives you can use to describe the evidence and the conclusions that you reach. Is that accurate?
Yes, it is.
And the thinking behind that is to submit the statistical number and let others decide, meaning the reader decide how they want to describe that number. Is that accurate?
Yes, it is.
So for example, if we can look at Exhibit 31, if you don't mind publishing that. Yes, and that's been admitted, so if we can put it on the screen. And Kimberly, if you could scroll to page 3 when that comes up. Thank you. So item 7, sub 1, is the swabbing from the towel from the rifle. We have the number in written form in the second paragraph beneath the heading, and then beneath that you have a table, correct?
That is correct, yes.
And the likelihood ratio gives the number, right? That's the likelihood ratio. And that's stated in sentence form in the paragraph preceding the table, correct?
Correct, yes.
The only language you can use to describe what that number means from the DOJ directive is very strong support for inclusion, correct?
Correct, yes.
And the sentence there that says the DNA results from item 7.1 are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The reader can assign whatever value they want to that, correct?
What do you mean?
Meaning adjective to describe what that means.
Sure, yes.
The adjective you can use is very strong support.
For inclusion, yes.
Okay, for inclusion. All right, if we go to 8.1, if you'll, Kimberly, if you can scroll down just to make that a little bit easier to view. Same question there. The results are from 8.1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The adjective you're allowed to use is very strong support for inclusion again, correct?
Yes.
Okay, we can take that exhibit down. Thank you. You were asked about formal activity level, and you described this as the lab cannot testify about, or you cannot testify about what action left the DNA on the object. Is that right?
That is correct, yes.
Does that mean that an individual did or did not touch? Oh, let me ask you this. How can DNA get onto an object?
DNA can get on an object via direct contact, so an individual touching an object. It can also end up on an item via body fluids, such as blood, or through transfer. So if I were to touch an object and then that object is given to someone else, my DNA could potentially be on that other individual through the transfer of DNA.
And your lab can't, or you cannot testify as to what precise action left the DNA on the object, correct?
That was the question
Correct,
you
I
asked just
cannot.
before this one. Asked and answered.
Same question about time. You can't testify about the exact time that DNA was left on an object, right?
Correct.
But there are some indicators that may give some information about how long and the conditions under which DNA was placed on an item, like degradation.
Yes, degradation or the condition of the item. So again, if a firearm, for example, is in a river, I would expect with the water rushing over that item, I may or may not be able to detect DNA. Also, if there's an item of evidence that it's is exposed to the elements, something that's been left behind 10 years ago, I don't necessarily expect to recover DNA, but something that may have been left yesterday, I might be able to detect DNA.
An item that has been left in the dirt or has been rubbed in the dirt, could that affect your ability to recover DNA?
It could, yes.
Could it also affect degradation?
Yes.
Can UV rays affect degradation?
Yes, it can.
Does degradation keep you from doing your work?
No, it does not.
Is degradation normal?
Yes, it is.
Does all DNA degrade?
It does, yes.
I imagine if it's kept in a pristine environment, it would degrade less than if it's kept in, or if it's found in a less or out in the open. Is that accurate?
Yes.
Okay. You said with regard to the screwdriver, there is some degradation. Did that affect your ability to reach conclusions in this case?
No, it did not.
You said on item 7, the towel, or the swab from the towel, there was slight degradation, not as much as Exhibit 8. Is that accurate?
Yes.
Did that degradation affect your ability to reach a conclusion here?
No, it did not.
You're asked about the PCAST report. You testified that that gave guidance on different areas of forensic science. Do you know what year that report was published?
I don't recall the year.
Do you know if it's been within the last 5 years?
No, it is not.
Meaning it's older than that?
Yes.
Do you know if it's been the last 10 years?
I think it was 2016, but I'm not entirely sure. I would say within the last 10 years.
Let me ask you this. Has the science in your area, can I refer to it as probabilistic genotyping?
Probabilistic genotyping is the math in my area, yes.
The science in your area and in your field, has it developed over the last 10 years?
Yes, it has.
And have there been studies that have made suggestions which have been implemented in the field?
Yes.
You testified about Exhibits 7 and 8, that they both had mixtures. Excuse me. Yes, items 7 and 8. In your testing of these items, that they both had mixtures. And you stated, I want to make sure I understood this. You stated, I believe, that the minor contributor was less than 20%, and that it was actually 5%. The ratio is 5% to 95%.
For one of the samples, yes.
Do you remember that?
Yes.
Does that mean the 5% was from twigs, and the 95%, that 95% is assumed from the Robinson?
When I calculated the statistic, Twiggs' DNA profile aligned with the 5% contributor, and Mr. Robinson's DNA profile aligned better with the 95% contributor.
Okay. Same question with regard to 8. I think you said the ratio was 11% from the minor and 89% from the major. Is that Twiggs being the 11% and Robinson being the 89%?
Yes, Twiggs better aligned with that 11% contributor, and Mr. Robinson better aligned with that 79% contributor.
We are nearly done.
You're asked about Baker 4, an exhibit that was titled Baker 4 365. Do you remember this exhibit by chance? I don't have a copy of it, so, well, do you have Baker 4 365? Put that up. And item 7 is the towel, right?
Yes.
Item 8 is the screwdriver.
Correct, yes.
Thank you. You know, it's 5 o'clock. I'm going to wrap up.
Thank you.
We can go ahead and take that down. I'm sorry. Thank you for helping out with that. In reaching your conclusions, did you follow the protocols of your accredited lab?
Yes, I did.
And based on your training and experience in following those protocols, did you in fact come to the conclusions described in Exhibit 31?
Yes, I did.
Thank you.
Right, Mr. Burt?
Thank you, Your Honor.
And how much time are you anticipating?
About 30 minutes.
Right.
This brings a
You referred
10-pound
on
notebook.
cross-examination to your training and experience, right?
Yes.
Do you agree with this statement in the PCAS report? Experience or judgment cannot be used to establish the scientific validity and reliability of a metrological method, such as a forensic feature comparison method. Moreover, a forensic examiner's experience from extensive casework is not informative because the right answers are not typically known in casework, and thus examiners cannot accurately know how often they erroneously declare matches and cannot readily hone their accuracy by learning from their mistakes in the course of casework. Do you agree with that statement?
I don't. I think experience, they're right in the fact that we never know the true answer. However, my experience means that I've seen a lot of different DNA. I've seen a lot of validation data, so that does help me come to a conclusion.
Do you agree with this statement by that same report? Good professional practices, such as the existence of professional societies, certification programs, accreditation programs, peer-reviewed articles, standardized protocols, proficiency testing, and the code of ethics cannot substitute for actual evidence of scientific validity and reliability.
I don't think I agree with that either. The science has been heavily validated and tested to show that's reliable. Following protocols that are based on validation, again, shows that my results are accurate and reliable, as well as being proficiency tested.
By the way, you said that that report was not authored by experts, but the head of that group was Eric Lander, who is one of the foremost experts in the area of forensic biology, is he not?
That name does not ring a bell. I don't know who that individual is.
You don't know who Eric Lander is?
No, I do not.
Okay. When did you go to school? What years?
2003 to 2007.
You said that STR mix was widely used and that it's been validated. The PCAS report said the problem is it's been validated by the people selling the product, right?
Developmental validation, yes. Internal validation, no. A laboratory that's going to utilize STAR mix has to validate within their own laboratory.
And the PCAS report said that we need validation data not by the people selling the product, but by independent scientists in order to make this reliable, right?
They do, and that's exactly what happened. There was 31 laboratories that came together in response to the PCAS report and gave their validation data on how they internally validated STAR mix.
And then after that information came forward, the PCAS committee reviewed it, and they said PCAS was unpersuaded by those studies. While likelihood ratios are a mathematically sound concept, their application requires making a set of assumptions about DNA profiles that require empirical testing. Errors in the assumptions can lead to errors in the results. To establish validity with a range of parameters, it is thus important to undertake empirical testing with a variety of samples in the relevant range. And they specifically address the studies you're referring to, did they not?
I believe they did, yes.
Yeah. And then lastly, you said that STR mix is widely used, but as I understand your testimony, you didn't use it and rely upon it for your conclusion about twigs, right? The software told you there was no support there for including them, and you ignored it and decided otherwise, correct?
I did not ignore it. Again, given the type of sample, it was an elimination sample. I compared that individual to the DNA profile that I developed and determined that I could conclude that I could utilize him as an elimination sample.
You said your laboratory was accredited, correct?
Yes.
But you're aware that in 2004, the Inspector General did a comprehensive audit of your laboratory and published a report called the FBI DNA Laboratory Report, a review of protocol and practice vulnerabilities, which found a number of errors in the way that your lab does testing, correct?
Objection. The 2004 study is hardly relevant to this proceeding 22 years later.
It's relevant because he's relying on accreditation to somehow say that these results are valid. This lab was accredited when this study was done.
I'll allow this single question as you may respond. So I'm overruling the objection, and then we'll continue to move forward.
You're aware of that study, right?
No, I'm not.
Okay, thank you. That's all I have.
All right. Anything further for this witness?
Thank you. Yes, I think there's one follow-up needs to be asked. You were asked that, or you testified that you never know the true answer with field work, correct?
Correct, yes.
And that's compared to ground truth studies where you do know the true answer and you can compare the conclusions that analysts draw with the true answer, the ground truth answer that is the basis of the study. Is that right?
Yes, and that is what our validation is.
Your validation actually studies is a ground truth test in essence.
Yes.
Okay, thank you.
Anything further for this witness?
No.
Thank you.
May this witness be excused.
Not enough screaming goats.
Thank you, Ms. Baker. You may step down.
Thank you.
All right. Well, does either party need the benefit of the record before we go into recess?
No, Judge.
All right. Having both parties say no, we'll go ahead and be adjourned until tomorrow at 1 p.m.
1
We do not
p.m.
have morning court
Mountain Time.
for this proceeding, and we'll start up at 1 p.m. in the afternoon. Court is in recess.
So tonight, when the judge goes home and rethinks his life decisions, he's going to have moments from today replay in his mind, and it's going to be painful, and he's going to cry a lot. I just thought I'd share that with you. There's no other pointer than that. It's just I think we have a sad judge now. This is his first year as a judge. It might be the first time he's had evidence like this presented in his court. It probably is definitely the first time a preliminary hearing has gone anything like this in his court. And Excedrin, Advil, Judge, I recommend that. Maybe acetaminophen, ibuprofen. Some of them you can mix and match as needed. Read the label. Ask your doctor if you need instructions. But a good pillow, a nice bed, and if you're married, just ask to cry on your spouse's shoulder for a little while, and you will feel better in the morning. You will. It's a tough one, but there we go. All right. Meanwhile, I'm fighting with YouTube over here. This is what I'm typing over here on the other side of the screen, as I'm trying to get them to fix the issue where they, on their own, sua sponte, decided to issue a warning copyright strike against Top Mark Media because the content that it was broadcasting matched another stream. Excuse me? Excuse me? That's not how pool media works, YouTube. So I've filed an objection. Unfortunately, it's going to take 72 hours over there. It was just a warning. I aced the 7-question quiz because I actually understand what it is. And then I've reached out to Team YouTube on Twitter using the Top Mark Media account, hoping to get a little bit of traction on that with a little head start on the investigation because this is just wrong. Just wrong. It matched KSL's feed, as did The Associated Press, which is doing the exact same thing, they also are equal to us. They're pool media on this. We both have rights, permission, authorization from the court, and we're provided the link from KSL to live stream this. And yeah, it's all good. It's all good. So the only reason we live streamed it on Top Mark Media is because KSL is putting this out with a single channel of audio, just one ear. We were switching it to mono, boosting the levels, and putting a limiter on there so that everyone could hear, and that people who maybe tonight wanted to go over and replay parts of court and show a certain clip that they found interesting. Heaven forbid, it's probably some DNA expert somewhere. But we wanted to have a feed out there that had good audio, and they could follow along, and a nice clean feed that didn't have logos and everything over the page, as we are entitled to do under the law. But YouTube thought better of it. Yeah, they said it matched other people's live stream, and it matches a lot of people's live stream because lots of people, by my count, 135 members in this media pool. 135. That's a lot of live streams out there. Anyway, wonder how many of them, I guess because I hadn't put a logo marker on it, it matched the clean feed, sort of like APs. But anyway, I don't want to replay any of this, honestly. Only one thing excited happened today. Josh, happy birthday on your new nephew born today. That's wonderful. That's wonderful. We're super excited. Now we're just waiting for news of one more on the same day. If that could happen, then Red Pen is going to throw a party in chat. She's promised. So, people are taking a stream broadcast on other platforms. That's what they do. That's what they do. I've never issued a copyright strike on anyone. We've asked occasionally people not to do it if they're doing it for the sole purpose of mocking me, because I can copyright my additional content that we put on this. But if they're just going to make fun of us and make fun of people, chatters and things like that, messages we put on the screen, some of it's all in good fun. That's great. And you know, that should be protected. I can't stand here and say, hey, we want transparency in the court, but we don't want other people's freedom of speech. So I'm a champion of freedom of speech. I think it's cool. It's nice if they ask permission. Maybe, you know, I might even give them a shout out. But it is what it is. Let's see. Brandy's catching up in the morning. She may regret it. Oh, Brandy. Skip the day. At least she's got half a day to do it, and she can watch it fast forward. As far as what happened important in this afternoon's occurrence, we saw a little bit of sportsmanship, good sportsmanship, on behalf of the state as they were about to call their next witness. They wanted to have witness number 3 for them come in. It's been going slow. The defense said, we have a problem. Our witness, Amanda Baker, the forensic examiner, she has to go. She can only be here today. I thought we might be done with the state's case in chief by now, with it being Tuesday and everything. So we scheduled her for today, and she's not here. Can we just have her go in the middle of your case? Just drop everything, like mid-witness, and then we'll do our bit? And the state said, we understand. We understand. You can't control these things. They happen. Tell you what, just say when. Say when. We'll put her up there. We'll put our people on hold. We'll make that happen. Never again. Never again, state. Don't do this. You saw what they did? You saw this. They dove into master's level DNA test prep is how we got to that. This is a preliminary hearing. You almost just want to say, sir, this is a Wendy's. This is stuff that may be applicable. I'm not going to say is. May be applicable at court. This is something the jury might want to consider if this goes forward and there's an actual trial. The weight of the evidence, the validity of the DNA tests and the probabilities, that's something the jury, it's boring sometimes. It's really in the weeds technically, There's a lot to learn. Okay, this will take you right back to college real quick as you're studying about alleles and matches and 11-11s and 17-18s and what position and how many peaks. But it's important stuff. Just not today. And unfortunately, defense was not able to read the room, and the state's continued objections, as they made several. They got us all the way up to 72 objections today. We started at 52, so we got 30 objections total, and about 4 or 5 of those were from the state during this witness. And they just, I'll say it, droned on and on in a tone-deaf style manner after the judge even repeatedly basically said, hey, too much, not here, wrong place, wrong time, be brief, be briefer. and instead they brought it. I would expect this level of questioning in the trial, and I think it's appropriate in the trial. Great, you're ready, wonderful, let's go to that. But yeah, anyway, DNA 402 level class, yes, most of us should have a doctorate after this. That's how it works. Why do we need to know to prove that he had DNA on his own rifle? The thing is, DNA, I would love it if you, when you turn on the microscope and you zoom in and you look at DNA, it just has the person's name and social security number, and you're like, it's him. And it's like, I saw it. It's in the DNA. It told me. It has peaks and valleys and changes, and some's a little bit corrupted, and there might be other materials that somehow got in there because heaven forbid somebody else might have also touched something in this world before it got swabbed, and so it's not just the black and white, which is why in addition to that the odds that there might actually be a match somewhere statistically, you can't just come out and say this was a match, this was that person, and I don't know, it's good stuff. I know that the DNA days in court are difficult for a lot of people. Some of you out there are psycho sickos and just eat this stuff up. And I think that's wonderful. We need you guys. Thank you for taking one for the team. But I'll take my PhD now in 20s. Non-consecutive bills. No die packs, right? Yeah. Anyway, it was a good day. It was a good day. We've got the matches. We have DNA from both Tyler and Lance. They were roommates, after all, on the screwdriver and on the towel that wrapped up the gun. And I think some on the gun as well. I'm not sure if I remember. I sort of got a little faded at that point of the testimony. I'll have to go back and listen. But a mix of DNA, not unexpected when you have two people who live together and items might have been in contact with both individuals and then possibly in contact with another object. You can have the transfer of DNA like it was to the gun. Anyway, Blue Star, glad you enjoyed it here, got to listen with us. We hope you come back and listen another day when it's more exciting as well, as you do. We know you're an OG here. OG! We deserve something for sitting through that questioning. I opened up my Milky Way, the share one, and I did not share. I apologize. It's told me to share. I did not. I needed all that sugar to get through that last bit of testimony. It was a little bit tough. You can prove that it has a high likelihood of being in person, though. Yeah. We got a person, for sure. I think that's enough work for the day. Laura is calling for the music. We will do that. Tomorrow's going to go like this. We're continuing to follow this trial all the way through, this case. Obviously, Top Mark Media is currently, I guess I could live stream again because I'm not banned. It was a warning. It doesn't impact my channel at all. And it falls off after 90 days because I guessed right on the 7-question quiz on all 7 questions because I know the answers. I could live stream it again tomorrow, but unless I hear from somebody who says they really need the audio so they can use it, I might just put it up as a video at the end of the day. I've got it all. I can put it up as a complete video, not live streamed, and maybe that'll be good enough. Did you ever check the burner phone for Selena? I did. I got the message. Believe it or not, I do check my messages occasionally, so that's a good thing. I'll need popcorn for when the guy tries to out-science the scientist. You know what's coming up? Wednesday, Thursday, Friday. One of these 3 days, we're probably going to get text messages from Lance and his roommate. We might get some testimony about police officers and what was said when he came into the police station. These are things that we don't have a lot of information on. I mean, we got the text messages. Those were released. Hopefully we can get the video, the video the judge saw, then the court saw, but we didn't get to see. That needs to be fixed. Anyway, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please be safe. So we go live again tomorrow morning, probably about 9:45. We're going to do some court hopping, which is where we jump around to some of our favorite courts around Michigan, Texas. Yeah, Tennessee, we started 110 years ago. We're going to jump around and see some of our favorite judges. Maybe Judge Middleton, if we can get good audio out of his court. We're going to miss him when he retires at the end of the year. And then we're going to join the Tyler Robinson case at 1 o'clock Eastern. Or excuse me, 1 o'clock Mountain, which is 3 o'clock Eastern. So it'll be an afternoon, short, half day until about 7 o'clock or so, and then we'll be done for the day.
Banished from the state of Georgia.
I will warn you, tomorrow is the hump day, the middle day of the week, and we do a hump day yell first thing in the morning. Take your earplugs out, headphones off, step away from the speakers, turn it down a few notches. I'm not liable for your hearing loss. I have to do the yell. It's contractual. You guys have a good night. We'll see you. Bye-bye.
You don't put a diplomatic plate on a hoopty.
Oh, and we're going to portal over to Courtroom Confidential for Josh tonight.